Well, morning everybody for the recommencement of these hearings in relation today and this week to the eco chapter. I've got a few health and safety announcements that I just have to make, and it's inflicting on some of you who've already heard this ad nauseum, but toilets, etc., are out the rear that way. If we have any emergency, can everybody depart through those rear doors as well and assemble outside the Spade Sale House outside. Otherwise, can I ask that you all ensure that cell phones are turned off? And in saying that, can I make the observation that I see in the Otago Daily Times this morning an expression of outrage by councillors and chief executives from Southland and Otago, I think it was, councils or who had appeared before a select committee where nobody in the select committee was there. They were all there on the screen, but they were all sitting there with their telephones and were looking at their phones whilst the submitters were making their submissions. Some of you will have seen through the course of these hearings that I personally am often looking at my telephone, as are, I think, possibly some other members, but it's, I can assure you, because we're looking at topo maps and, in my particular case, the RMA. That's my record of the provisions of the RMA as I'm dancing around in that. So please don't be affronted by the fact that you might see some members of the panel looking at their phones. It's genuine. We're not texting. We're not chatting to our mates. And, but we would ask that you not text and you not use your cell phones through the course of the hearing. So those opening comments, we'll be commencing this morning with a presentation from the Otago Regional Council. And unfortunately, as many of you will have seen, due to unavailability of Dr. Lloyd, there's been a series of questions from the panel members to Dr. Lloyd and a series of written answers which are available on the webpage. But otherwise, we're in the hands of ORC. Thank you.
Thank you. Good morning, Commissioners. Before I kick off with ORC's opening submissions, I'll just introduce who we have here with us today. So we have our 42A author, Melanie, and we also have here is Scott Jarvie, ecologist at ORC, and Kieran Campbell, who is a freshwater ecologist at ORC. Now these gentlemen provided some evidence on Eco Objective 1 and the New Zealand threat classification status. So they're here and available to assist the panel with any questions you may have arising out of that evidence.
I'm sorry, that was Mr. Jarvie and
Mr. Campbell.
Right.
Lovely. So ecosystems, and I believe everyone, sorry, has a copy of their written submissions for ORC. So ecosystems and Indigenous biodiversity is chapter 10 of the proposed Otago Regional Policy Statement. Already introduced our 42A author, Melanie Hardiman, who produced a report on Form A. And she also produced a statement of supplementary evidence on this chapter on 11 October and a second supplementary statement of evidence on 24 February. The pORPS seeks to maintain Indigenous biodiversity by identifying and mapping SNAs, significant natural areas, and Te Auka in EcoP2, avoiding adverse effects on SNAs and Te Auka in EcoP3, applying the effects management hierarchy in EcoP6, managing coastal Indigenous biodiversity in EcoP7, restoring and enhancing biodiversity in EcoP8, and managing wild conifers in EcoP9, while implementing a coordinated approach in EcoP10. By now we're quite familiar with the legal framework. Section 6 is that the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna is a matter of national importance. And unlike other matters of national importance in section 6A, B and F, recognition of and provision for the protection of significant Indigenous vegetation and significant habitats are not subject to any qualifiers. Under section 6C, the ORC is required to recognise and make provision for the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna. Section 6C is a matter which the authors of a regional policy statement must recognise and provide for to achieve the purpose of sustainable management. And while section C does not give primacy to preservation or protection within the concept of sustainable management, that does not mean a particular planning document may not give primacy or preservation to protection in particular circumstances. Accordingly, protecting what is significant can translate into a bottom line or limit. Section 7 is also relevant. In this case, the matters in section 7 to which particular regard should be had include the intrinsic values of ecosystems, maintenance and enhancement of the quality of the environment, and any finite characteristics of natural and physical resources. And relevantly, the RMA defines environment, intrinsic values, and biological diversity. And they're set out there, and I don't propose to read through those. I think it's just a really helpful reminder, because often when we think of biodiversity or the protection or maintenance of it, we think of a specific animal or specific invertebrate or even just habitat. And those definitions just set out there that it's all those constituent parts, and it's a lot more complex than that. So section 30, a regional council has a mandatory statutory obligation to maintain Indigenous biodiversity, and section 31 GA is set out there. To maintain means to protect, which in turn means to keep safe from harm or injury. The High Court in the Property Rights in New Zealand case held that 31 GA makes it a mandatory function of every regional council to establish objectives, policies, and methods for maintaining Indigenous biodiversity. And similarly, in the Attorney General and Trustees of Motiti Rohi Moana Trust, the High Court held that the RMA has made express provision for the maintenance of Indigenous biodiversity as a core function of regional councils. And in the Environment Court, in Oceana Gold and Limited in Otago Regional Council, Oceana Gold argued to the contrary. The Environment Court held, footnotes omitted. In the property rights case, the High Court held that 31 GA creates a mandatory obligation on regional councils to make provisions, policies, and methods for the maintenance of Indigenous biodiversity. An Attorney General, the High Court held that the RMA has made express provision for the maintenance of Indigenous biodiversity as a core function of regional councils. Mr. Christensen submitted that section 31GA is a direction as to subject matter to be addressed, not as to a particular substantive outcome that is to be achieved. That submission seems to imply that a regional council could choose not to maintain biodiversity so long as its plan covers the subject. Ms. Gett submitted for the societies that if the provision was to be merely directing the subject matter of an RPS, then it would have omitted the words for the maintenance and simply specified that the function is the establishment of provisions for biodiversity. In other words, the subsection requires particular emphasis on the management of Indigenous biodiversity and applying the High Court authorities cited in the previous paragraph. We hold the latter view is correct. There is a directive component to section 31GA, especially when it is read in the context of section 52B and section 7C RMA. Moving on to section 5, the sustainable management purpose of the RMA in section 5 also must be borne in mind. The protection and maintenance of Indigenous biodiversity is to occur in the context of achieving the purpose of the RMA. Section 5.2 defines sustainable management. It must be read as an integrated whole. The use of the word while before subparagraphs A, B, and C means that the paragraphs must be observed in the course of management referred to in the opening part of the definition. So while means at the same time as. Just to note there that it's not an option for regional councils or those giving effect to the RMA to choose preservation over use and development, or vice versa. Both must be achieved under section 5. So the New Zealand Coastal Policy Statement and the National Policy Statement for Freshwater Management also contain direction on the management of biodiversity. In the coastal environment, the direction is to protect significant biodiversity. Policy 11A requires decision makers avoid adverse effects of activities on areas with certain biodiversity characteristics. However, the policy contains a hierarchy based on classification of both the environment and environmental effects. Policy 11B requires decision makers avoid significant adverse effects on certain environments with specified characteristics, for example, areas of predominantly Indigenous vegetation in the coastal environment, and avoid, remedy, or mitigate other lesser effects. The proposed RPS gives effect to the NZPS in the coastal environment, and similarly, in the NPSFM, Policy 9 directs that the habitats of Indigenous freshwater species are protected. Of note, the NPSFM uses an effects management hierarchy, including aquatic offsets and compensations, with principles defining when offsetting compensation will not be appropriate. And the proposed RPS gives effect to the NPSFM in the freshwater chapter. So the pORPS approach to protecting Indigenous biodiversity, we see Eco P3, and that is for protecting significant natural areas in Te Auka. Just for ease of reference, I have used the most recent 42A version and removed the track changes from it for the purposes of these submissions, and that is footnoted in there so that we don't have the colour and the strike through. So adverse effects on significant natural areas that result in reduction of the SNA area or values identified and mapped under Eco P2 are to be avoided. Other effects are then to be dealt with using the effects management hierarchy in P6, but there are exceptions. Eco P5 provides for the continuation of existing activities and SNAs that are lawfully established. And under Eco P4, all effects of the listed activities are dealt with using the effects management hierarchy in P6, without first needing to satisfy the ordinance requirement in P3. And those activities are nationally and regionally significant infrastructure, mineral extraction activities, aggregate extraction activities, development. Sorry, I've just lost my place there, use of Mahika Kai and Kaimoana, and also development of whakakainga, marae and ancillary activities associated with customary activities, the use of Māori land and native reserves, and protecting, restoring or enhancing a significant natural area or Indigenous species or ecosystem that Aotearoa, and addressing a severe and or immediate risk to public health or safety. So for those matters, access to the effects management hierarchy without satisfying Eco P3 is generally in recognition of the activity's significance, together with the activity being functionally or locationally constrained. Eco P6 sets out the effects management hierarchy, and again I'll set that out for you there. The hierarchy applies to all but Indigenous biodiversity, but its availability is limited as above for significant natural areas in Te Ariki. It requires an applicant to demonstrate that they have applied each step of the hierarchy before progressing through it. The first three limbs of the hierarchy are unremarkable. They closely follow section 5.2c. The fourth and fifth limbs of Eco P6 are enabling of offsetting and compensation in defined circumstances for any remaining adverse effects. They are to further enable activities within the bounds of acceptable offsetting and compensation. APP3 and APP4 set out what is and is not acceptable offsetting and compensation. Offsetting and compensation are not available in all circumstances. When available, offsetting and compensation proposals must achieve relevant outcomes. Offsetting is not available for an activity that will result in the loss of an ecological district of any individuals that are threatened to tax it, other than kānuka. Measurable loss within an ecological district to an at-risk declining taxon other than manuka. The worsening of the conservation status of any individual biodiversity listed under the New Zealand Threat Classification System. The removal or loss of viability of a naturally uncommon ecosystem type that is associated with Indigenous vegetation or habitat of Indigenous fauna, or the loss, including cumulative loss, of irreplaceable or vulnerable Indigenous biodiversity. The limits on availability of compensation is similar. It's not available where it will result in, again, the loss from an ecological district of an Indigenous taxon or any ecosystem type. There's an exclusion there for freshwater fauna and flora. Removal or loss of viability of the habitat of a threatened Indigenous species under the Threat Classification System. Removal or loss of the health and resilience of a naturally uncommon ecosystem type that is associated with Indigenous vegetation or habitat of Indigenous fauna. The worsening of the conservation status of any threatened or at-risk biodiversity listed under that classification system, or the loss, including cumulative loss, of the irreplaceable or vulnerable Indigenous biodiversity. And it must be kept in mind that significant Indigenous biodiversity and significant habitat of Indigenous fauna can also be locationally constrained. Naturally rare and uncommon ecosystems are an example of this due to environmental conditions. Often they exist where they exist and cannot be recreated elsewhere. Oceana Gold advocates for criteria set out in APP3 and APP4 to be amended so that they are no longer limits of criteria that need to be achieved, but principles for consideration. This point has been thoroughly litigated in the context of the partly operative Otago Regional Policy Statement 2019. In an appeal to the Environment Court by Oceana Gold, the issues for the court to determine were whether there should be limits on the availability of compensation, and if so, what they should be, or whether they should only be a list of considerations. ORC, Forest and Bird, and the Environmental Defence Society argued for limits, although they disagreed on their number and content. Oceana Gold, the Ministry for Energy and Resources, and Queenstown Lakes District Council opposed limits. Although they accepted the matters proposed by the other parties could be considered is considerations for assessing the acceptability of a compensation proposal for a resource consent. The court undertook an extensive consideration of the limits to compensation. It reviewed the ecological and planning evidence adduced by the parties and their legal submissions. It adopted some amendments. With some amendments, the limits proposed by the societies being Forest and Bird and EDS. The limits that were the subject of the Environment Court's determination are largely replicated in the proposed RPS. And at 49 and 50, I've just set out the limits that were the subject of that court hearing. An appeal to the High Court by Oceana Gold alleging errors of law in the Environment Court's determination failed. A key part of the effects management hierarchy is that if residual adverse effects remain after all steps have been completed, the activity itself must be avoided. It goes without saying, but could be added into the proposed RPS for clarity, that the remaining adverse effects must be more than minor. The policy is not intended to require avoidance if only minor adverse effects remain. The final avoidance limit is necessary because otherwise the effects management hierarchy would not be protective of nor maintain Indigenous biodiversity. Without the final consequence of avoiding the activity, the result of the effects management hierarchy failing to address adverse effects in a satisfactory way could be to do it anyway. Where this leaves us is that it is only in limited circumstances that the proposed RPS gives primacy to the protection of Indigenous biodiversity by requiring the avoidance of an activity. Those limited circumstances are where Indigenous biodiversity is still subject to more than minor adverse effects after avoidance, remedy, mitigation, offsetting and compensation, and where there would be a reduction in area or values of significant natural area or teoka, and the Eco P4 and Eco P5 exceptions do not apply. This is in accord with King Salmon. It's necessary to achieve protection in terms of Section 6C, and it is necessary to achieve the maintenance of Indigenous biodiversity in terms of Section 30, 1GA. There can be no doubt that this is an appropriate framework for the proposed RPS to achieve the purpose of the RMA and Otago and to meet the requirements of Section 6C and 30GA. I'm just touching briefly on some matters raised by submitters. So inconsistency with Section 104(1)AB. Ms. Hunter for OGL considers limits are problematic and are at odds with higher order planning documents, the exposure draft of the National Policy Statement for Indigenous Biodiversity, and Section 104(1)AB of the RMA. Similarly, for contact, Ms. Hunter considers APP3 and APP4 create an inconsistency with Section 104(1)AB, and she considers the limits are unreasonable and seeks their removal. Mr. Tuck for Silver Fern Farms seeks the removal of limits on the availability of biodiversity offsetting to assure alignment with Section 104(1)AB. If these are a submission that limits on the availability of offsetting and compensation are unlawful, then the submission must be rejected. As noted above, limits to offsetting and compensation is a point which has already been litigated in the context of the proposed Otago Regional Policy Statement 2019. Section 104(1)AB does not preclude a planning instrument from including provisions as to offsetting and compensation in specific contexts. Applying that logic, all manner of policy statement and plan provisions which regulate activity status, for example, prohibited activity status, could be struck down on the basis they are inconsistent with Section 104(AB) or Section 104(1)A or C. The correct view is that a consent authority must consider all the matters listed in 104(1), including any standard, regulation, policy statement, regulating, offsetting and compensation, such as the NPSFM, which includes limits on offsetting and compensation. There is nothing inconsistent or unusual about that. And relevant to the discussion on the proposed RPS's use of limits, various submitters have sought alignment of the pORPS with the draft NPSIB. The exposure draft was released for public comment in June 22. It was anticipated to be gazetted in December. That did not happen, and the web page now predicts gazettal sometime this year. ORC's position with respect to the draft NPSIB remains unchanged. The proposed National Policy Statement for Indigenous Biodiversity has no legal standing, and there is no statutory direction to give effect to it. Further caution must be exercised. A National Policy Statement for Indigenous Biodiversity may or may not be issued in the terms of the exposure draft or any earlier iteration. It would be wrong to make amendments to the proposed RPS on the assumption that a national policy statement will be issued at all or with or without amendments. It is worth noting, however, that the draft NPSIB also contains limits as to when biodiversity offsetting and compensation will not be appropriate. Examples of when offsets would be inappropriate are when residual adverse effects cannot be offset because of the irreplaceability or vulnerability of the Indigenous biodiversity affected, or when effects on biodiversity are uncertain or unknown or little understood, but potential effects could be significant. And I've set out the examples there from the draft NPSIB for compensation as well. And as noted by Dr. Lloyd in his response to questions from the panel, the exposure draft of the NPSIB goes further and places limits in relation to effects being uncertain but potentially significantly adverse, or where there are no feasible options to secure gains by offsetting. It has also been consistently raised by submitters that following the hierarchy in sequence and or requiring applicants to demonstrate the hierarchy has been followed may not achieve the best outcomes for biodiversity. Those submitters, however, also seek that the RPS be aligned with the draft NPSIB, or they submit that the proposed RPS is inconsistent with it. Principle 1 of the draft NPSIB for biodiversity offsetting and compensation is adherence to the effects management hierarchy. So with respect to offsetting, an offset is a commitment to redress any more than minor residual adverse effects and should be completed only after steps to avoid, minimise and remedy adverse effects are demonstrated to have been sequentially exhausted. And the same applies for compensation. Giving effect to the NPS-REG and NPS-ET, it has been submitted that the proposed RPS fails to give effect to those two national policy statements. Generally, that was dealt with in the EIT hearing. In the specific context of this chapter, nationally significant infrastructure and regionally significant infrastructure with a functional or operational need to locate in a significant natural area or to affect Teoka are exempt from avoiding adverse effects under EcoP3, with their effects to be addressed under the effects management hierarchy. So in conclusion, the ORC has a mandatory statutory obligation to maintain biodiversity. It must protect significant biodiversity as a matter of natural importance. The proposed RPS provisions provides an appropriate framework to do so in a way that achieves the sustainable management purpose of the Act. The policy framework recognises and provides for significant activities that are functionally or locationally constrained, but not at any environmental cost. Accordingly, the proposed RPS gives primacy to the protection of Indigenous biodiversity by requiring the avoidance of activity only in limited circumstances, where biodiversity would remain the subject to more than minor adverse effects after the hierarchy is applied in EcoP6, or where there would be a reduction in area or values of significant natural area or Teoka, and the EcoP4 and P5 provisions do not apply. There are questions from the panel there.
Thank you, Ms. Sutton.
Thank you. I suppose not surprisingly, section 6C seems to come up quite a lot in the evidence. And I just was interested in your views on whether this case law, I mean, section 6 is about matters of national importance, and 6C is talking about protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna.
Yes.
Is there any guidance around whether that's referring to nationally significant Indigenous vegetation and habitats, or can that be brought down a peg to sort of regionally significant as well, given they could potentially be quite different or have some differences?
No, that's a really good question, and I'm more than happy to have a look so that I'm not answering off the top of my head about whether there is case law available. I would assume that it would be on all regional policy statements and, sorry, I'm just having a rethink through here, have their own significance criteria, and there will be at a regional level, I would say, a regional flavour to that. But I also understand that if biodiversity is to be maintained, then it's to be maintained at the regional ecological district scale. But as for case law, I'm more than happy to look into that. And also, I guess section 6C deals with significant biodiversity. The direction in section 31GA is to maintain all biodiversity.
Yeah. I think one of the reasons it's prompting that question is that we've got a lot of evidence before us telling us whether provisions are or aren't consistent with section 6C or giving effect to section 6C. And I suppose it's just sort of, is there any guidance as to the level of significance in there? Yeah. Notwithstanding what we've got in section 30. Yeah. That's all from me. Thank you.
Yeah, thank you. Just following on from Bianca's questions around the interplay between section 6C and the relationship with the functions side of the council's duties, and that was the bit that's been exercising my mind, because and I think you said in your evidence, maintain means to protect, and I think there is case law around what protect means in a wider sense. Doesn't mean absolute protection. That's something I'll be interested in as well, but the concern coming through from the evidence seems to be, yes, we have to protect significant habitat and vegetation. That's understood. The maintenance of Indigenous biodiversity, so a little bit of a frog in the front. I don't know why you don't have code. The way I read it, it's saying maintain biological diversity. I think the concern coming through is that when you work through the hierarchy in the RPS, you have to avoid on those significant values, but then I think it's policy 6 kicks in for all other stuff, and that when it's not significant, that hierarchy applies as well. And by maintaining biological diversity doesn't mean to say you have to maintain all Indigenous vegetation. That's not significant, does it?
Absolutely, and I think that's what the hierarchy provides, because obviously, especially by the time you get down to offsetting and compensation, you're not necessarily maintaining, particularly the individual, the compensation is generally a like for unlike. So while you're having a negative effect over here, you could be offering something wild and wonderful over here, and that's a trade-off. So in that strict sense, you're not maintaining that specific item of biodiversity that you're having an effect on. But again, the overall goal is to achieve no net loss and preferably a net gain.
Of all biodiversity, not significant.
Of Indigenous biodiversity.
Okay. Okay. Now, the only other sort of legal question is around policy 5, which seems to step into the existing use area. You'll be familiar with that case that's coming out recently down Southern District. Just wondering on your take on that, particularly when it refers to the scale, etc., before the RPS became operative. I think that case in Southern was talking about pastoral land that had been cleared over decades, but it kept getting recolonised by manukas, eucalyptus, your shrubland stuff. How does this work in that context? Because that existing use rights there starts way back before an RPS now.
Mhm.
This seems to reset the clock almost, and whether that's legally possible, that's probably the question.
So I can quite honestly say I'm not familiar with that case. I'm more than happy to review that case, and certainly, if not before the end of this hearing, reply submissions or closing and correct existing use rights. From what I know, they're sort of a protected common law, which is quite a different body to legislation or policy framework.
I understand the intent of this policy, and it's actually trying to allow minor upgrades and stuff of things that are already there, but it's where that kicks in, I guess, and how that applies in that circumstance. That would be useful if you could have a look at that. I think any other thing? Mr. Christensen's evidence, I think he's quite strong on promoting the fact that the effects management hierarchy in the freshwater management MPS, he doesn't see any bar to using that for ecological biodiversity from a legal perspective. Did you have a view on that?
From a legal perspective, I'd be very hesitant to comment, because I think biodiversity in the freshwater sphere is quite different. Particularly, I recall with this effects management hierarchy, the exclusion there specifically in compensation and offsetting for freshwater fauna and flora is because of those differences. They are highly movable from memory. They're not restricted necessarily to ecological district. They move in and out. So I would be concerned without advice from the ecologists as to whether that would be an appropriate framework. Obviously, it is specifically designed for freshwater flora and fauna. At the same token, I would say that there's probably a lot of similarities and overlaps in the
I think he was probably talking about the actual cascade rather than the actual criteria that may determine whether you an offset or a compensation is appropriate.
Yes, absolutely. And I believe that the MPSFM does have its own limits as well.
Yeah.
And they're probably quite similar from memory to that of the draft MPSIB.
Yeah.
I'm concerned with loss of vulnerable or irreplaceable biodiversity, or where effects are unknown or uncertain.
Okay. Yeah, the only other thing is around in your paragraph 49 about for offsetting that came out of the Environment Court determination in the last piece. There is a slight difference in that, though, isn't there?
Yes, there are differences.
Yeah.
They're largely carried through. The offsetting particularly, I think that come through from the Environment Court really is broken up into two limbs, where in response to community consultation and submissions, we've ended up with more limbs or limits than simply has come from the additional two.
what you set out in paragraph 49, there's been a lot of issue with the offset ensures that there is no loss of individuals, whereas I think that this proposal has loss of any individual. So there's a slight difference in how it's phrased, but it has quite significant effects, doesn't it?
From memory, and my 42A author might be able to correct me, there was criticism that it wasn't clear in that policy framework that the offsetting policy applied to any individual. So that was made clear in this proposed RPS. And I think there is a lot, again, in the course of that litigation, there was a lot of discussion and consideration of that. And I believe that was one of the areas of law that was appealed to the High Court.
So you're saying that it's actually meant to apply to any individual?
Yes, yes, that is what was held in the lower courts. Yes, of a threatened.
Okay.
Yes.
Okay, thank you.
I have an observation I'm supposed to make and a question which really applies not just to you, but I think to everybody here this morning. And I'm going to throw it out to everybody. And that is around taoka, how you define that, and whether the definition requires some sort of different way of dealing with it than, say, as an SENA or any other way in which you want to define it. Because it worries me a little bit that the word seems to just get tagged on as you go through something and taoka, and I'm not quite sure whether what you're saying is you fully understand what they are and that they might actually be different and might require a different way of being handled. And I'm not quite sure what the answer is, but it's just a nagging thing I have in my mind. Do you have any thoughts on that?
I think that the reason it is not tagged on, but it is with significant natural areas, because they are both matters of national importance. So it is elevated to that. And I think the fact that it is SNAs and taoka, there is a recognition that they are different. How that's given effect to, I believe objective 1 is kaitiakitanga and stewardship. Sorry, that's 3. Objective 3, and then policy 1, is kaitiakitanga. So I think through those provisions in mana whenua, we're hopefully not professing to fully understand taoka or how Māori or mana whenua wish to manage. I think it's given effect to, whereas certainly that's the intention through those provisions and through iwi involvement.
I mean, the term taoka is applied in various different ways throughout the whole RPS, but I think it's particularly relevant under the Indigenous biodiversity tag, because that's where a lot of the taoka, I think we need to say K, that kind of reside for most Māori. It's around food resources, it's around all those sorts of things, which are quite material things that people look at, various plants, medicines, and all that sort of stuff, And I think what I heard Ngaitahu saying earlier in the piece is that they are more than just special. They actually require special attention, some sort of special handling, if that's the right word. And I'd be interested in how others who are going to be presenting today see that as well. Is there something around how Oceania Gold, for example, sees the issue of taoka and whether it's fully recognised, I suppose, in the proper sense, in the right sense, so that it's given effect to as you're putting it. Yeah, that's the only point I wanted to make. Thanks for your response, and as I said, I'll leave that as an open question for others as well.
I just really wanted to start by exploring a bit further what's been raised with you in terms of Section 6, because one of the tricky things about Section 6 is that the different wording that is used in the different subclauses or subsections rather, and if one takes even the one that has just been mentioned by Commissioner Kirikiri, the what's required is a recognition and provision for, as a matter of national importance, the relationship of Māori, and leaving out the irrelevant words, and their other taonga. The words protection or preservation aren't specifically mentioned. But it would seem to me that in the proposed regional policy statement, taonga are given exactly the same status as Indigenous biodiversity, and we could, I think, arguably reach a conclusion if that was justified by the evidence that Commissioner Kirikiri is talking about. But as a matter of law, is there a difference that we should be applying between wording that is talking of protection of Indigenous biodiversity as contrasted to recognising and providing for a relationship for Māori with taonga?
I guess in a regional policy statement that is given flavour and effect within the Otago context and specificity, and that's where it's landed there. I do note that for taonga, the Section 6 matter is also an unqualified matter. I do agree that it doesn't specifically reference protection. So how do you recognise and provide for mana whenua relationship with all those matters without protecting it? So I would say from a legal perspective, it's quite appropriate that they are on the same footing.
And if you look at, I've got a new phone, it seems to cut me out of it.
As long as you're not texting.
If you look at Section 6A, in answer to Commissioner Cubitt and yourself were having an exchange there in relation to the freshwater instrument. Wording there in Section 6A is the preservation of the various aspects in relation to freshwater, whereas we're, in terms of Section 6E, looking at a different wording, the protection. The preservation aspect in Section 6A, as was pointed out, the King Salmon case, then gets ameliorated in reality by the final words of the section, which talk about preservation and protection. So it uses both words, but from inappropriate subdivision, use and development. And that phraseology doesn't, for some reason, appear in Section 6C. Should we be placing any weight on that differentiation? And has that issue been addressed in any cases that you're aware of?
That preservation is not expressly mentioned in Section 6C.
That the phraseology of protection from inappropriate subdivision, use and development, the omission of that in Section 6C,
yes.
Is that significant, and has it been identified as such in cases?
In my submission, it is somewhat significant. And like I said, Section 6C is not, and Section 6E are not subject to any qualifiers. Inappropriate subdivision, use and development is traversed in King Salmon. what's inappropriate or what is deemed inappropriate is determined by what is sought to be protected.
And then in paragraph 13, I think it is, yeah, paragraph 13 of your submissions, you referred to a decision, Cannon Vineyard, in the High Court, holding, you say that to maintain means to protect.
Mhm.
What was the context of that case?
Oh, I would have to come back to you on that one, I'm afraid.
Well, look, rather than coming back to me, can you give me a copy of the decision?
Absolutely,
All right,
yes.
And I'll have a look at that. Thank you.
Has been somewhat recent and helpful in my submission discussion around protect and maintain, where I think really it's a 2022 decision. The case law has really got to is that they've become used interchangeably.
No, it's not in your submission, but when you were going through at page 9, I just you then jumped to appendix 3 and 4 and didn't specifically refer to appendix 2, and I was wondering what ORC's position is, or has it adopted a position yet in relation to that joint witness statement?
Yes.
Which we provided.
Yes, so I will let Melanie speak to that. I understand a number of matters were narrowed and there was agreement on some wording and amendments.
Right.
And I understand that, and please correct me if I'm wrong, Mel, that Melanie endorses where the experts have come to agreement and defers to their expert technical expertise.
Okay. In paragraph 53, you make the statement that it goes without saying,
Mhm.
but it can be added to the proposed
Yes.
RPS to avoid any doubt that the remaining interspects must be more than minor.
Yes,
Um,
I really, I guess, to an extent, I noted your question to Dr. Lloyd on that point.
Right.
He just said that technically it could apply to all adverse effects, but I've just footnoted king salmon there, and it's accepted that minor or transitory effects wouldn't necessarily need to be avoided or offend the avoidance policies.
right, thank you. I'm getting picky here, but paragraph 66, you said, I would have thought a strange way in saying section 104(1)(a)(b) does not preclude the planning instrument. It's not, it's more that it enables the consideration of offsetting compensation by
Absolutely.
way of conditions.
Yes, and our submission is that having a plan provisions that limit availability is not inconsistent with. So obviously you can have a really directive planning provision, and I've given the example NPSFM. You come to in a consenting sphere, section 104, and of course it is one of those matters, despite the directive policy, that must be considered. But we know from Davidson and also King Salmon that it's subject to part 2. And those planning instruments, unless there's ambiguity, uncertainness, incompleteness, to be treated or as giving effect to part 2. So when you've got the higher order directive policy, it is unlikely that, although there has to be the offsetting and compensation proposal has to be had regard to, it's unlikely that in the face of a directive policy that consent would be granted.
Just help me out, and the reason I wasn't just being picky, it's an issue that strikes me as unusual that in the RMA, correct me if I'm wrong, but that's the only reference to offsetting the compensation. Is that right or not?
Oh, off the top of my head, I am unsure, but that was an amendment that came in 2017, and I understand that while offsetting has been relatively common or well understood, compensation is a bit of something that's developed somewhat subsequently, or is not as well understood or as common. Previously, I think they were sort of thought to be cut from the same cloth, and certainly it's not the case. One's a like for like, and one's like for unlike, the trade-offs. So that may be the only place where it is referred to.
Doubtless Mr. Christensen can
Yeah,
correct me if I'm wrong on that, but
I can do a quick
it
word
seems
search.
it seemed an odd situation to have arisen where
Mhm.
had a really offsetting the compensation seems to me have developed over time.
Mhm.
And, Mr. Mark Christensen's evidence sort of describes how that's occurred, but it's developed as a practice almost, really, as part of the condition, is a suite of conditions type approach taken on consenting. And then the reaction to that, the statutory sense, seems to have been to acknowledge by that statutory amendment of 1AB, section 104(1)AB, that there's, appears to me, a real lacuna in terms of statutory direction for RPSs or for plans as to the setting of policies or objectives relating to the offsetting compensation. So challenge I'm really making to Christensen and to you, Ms. Stephen, is am I overlooking something? And I'd be very interested in hearing from on that. All right. And the final question really arises out of the point that Commissioner Sullivan was raising with you about this regional or ecological district scale issue. Again, what I've been struggling with in reading all of this evidence is, in a statutory sense, where is the guidance as to the scale at which these decisions have to be made in terms of what's significant, or in terms of whether or not protection is necessary for particular Indigenous biodiversity? Is it at a regional scale, is it a national scale, or is it at an ecological district scale, or a local scale? Are you able to assist us with any case law or any statutory provisions that we're overlooking in thinking that there seems to be a lacuna in that regard as well?
My only response is that my understanding is that it's agreed between ecologists that the appropriate scale is the ecological district. Obviously, in the appendices, we're concerned with worsening of classification status at a national level. That's triggered there, but biodiversity is set in the RPS is, attempted to be maintained at the regional scale. So ecological district is the appropriate scale here, as far as I understand. In the regional policy statement, we're seeking to maintain biodiversity at the regional level. And then in the limits, it is referred to also the worsening of the threat classification status, which is a national scale. But I am more than happy to, as I said, to remember that I would be happy to look at that from a case law perspective and see if there is some firm guidance on that.
Thank you. Thank you.
So ORC now calls the 42A author of this, and that is Melanie Hardiman.
So
Hi, good morning, everyone. So this statement provides an update on my understanding of the key issues still in contention with the eco chapter since I prepared my section 42A report, supplementary evidence and second supplementary evidence on this topic. In my view, the outstanding issues can be grouped into the following themes: providing for activities within significant natural areas, the effects management hierarchy in relation to Indigenous biodiversity, amendments sought to APP2, APP3, and APP4, amendments sought by Kaitahu. In this statement, I will also respond to matters that have arisen since the filing of my evidence, including Claire Hunter's supplementary evidence dated 31st of March 2023, and the joint witness statement of the ecologists produced from expert conferencing on APP2 on 31st of March 2023. The above is not intended to be an exhaustive list, as a range of other amendments are sought by submitters, which have been addressed in my section 42A report and supplementary evidence. If I have not discussed an issue considered in my section 42A report or supplementary evidence in this statement, and I consider that either the issues have been resolved or the remaining issues are not significant. I've identified some errors in the latest version of the ecosystems and Indigenous biodiversity chapter, which will not show some of the recommended changes from my supplementary evidence in section 42A recommendations. These errors are set out together with the corrections in Appendix 1. I acknowledge that these corrections have been identified as necessary to properly understand the eco chapter. To assist the hearing panel and signal to submitters when my views may have be changed in response to the evidence, I've attached as Appendix 2 a track change version of the eco chapter. I'm conscious that I have not heard questions from the hearing panel to submitters, and therefore these views are preliminary and no section 32AA assessment has been included to support these changes. A full analysis in section 32AA will be provided in the reply report. Providing for activities within SNAs. A number of submitters have raised concerns that EcoP4 fails to recognise and provide for a range of activities that are locationally constrained. Some submitters consider EcoP4 should provide a pathway for quarrying and mineral extraction activities. I note that my recommended changes to EcoP4 and my supplementary evidence may satisfy these submissions. Ms. Stiles for Manawa seeks no greater is amended to same or similar in clauses 1 and 2 of EcoP5. I do not consider the suggested amendment as appropriate because it could result in activities within SNAs having potentially greater adverse effects. If an activity does not meet the parameters set out in clauses 1 and 2 of EcoP5, then it falls under EcoP3, which has an extra test provided it does not trigger EcoP3-1. This extra test requires applicants to show that they have stepped through the effects management hierarchy, which EcoP5 does not. The effects management hierarchy in relation to Indigenous biodiversity. EcoP6 sets out how Indigenous biodiversity is to be maintained through decisions on applications for resource consents and notices of requirements. The issues originally raised in submissions on EcoP6 still largely remain the same. Some submitters seek EcoP6 is to be aligned with the effects management hierarchy contained in the exposure draft National Policy Statement for Indigenous Biodiversity, particularly regarding the inclusion of the text where practicable or where possible. In section 10.41 of my section 42A report, I discussed the submissions received seeking the alignment of the eco chapter with the draft NPSIB. My recommendation has not changed because the draft NPSIB is not in force and therefore there is no certainty about the content the council may be required to give effect to. Furthermore, I consider the inclusion of where practicable or where possible will weaken the purpose of the policy, which will allow for the loss of Indigenous biodiversity and result in poor environmental outcomes. Ms. Mealy, for Director General of Conservation, considers the order of effects management hierarchy in EcoP6 should be reordered from avoid, remedy, mitigated to avoid, minimised, remedied. She suggests reducing the impact on biodiversity through minimising or mitigating provides better protection for the environment than attempting to remediate what has been lost. Mr. Brass for DOC supports Ms. Mealy's evidence. Ecological advice is that it is appropriate remediation comes before mitigation in the effects management hierarchy. Therefore, I do not recommend reordering the hierarchy. Kaitahu seeks a new clause in EcoP6, which states decision makers must have particular regard to Hikiukai practices and mana whenua when assessing adverse effects in the implementation of EcoP6. I addressed this in paragraph 266 of my section 42A report. I still consider Kaitahu's new suggested clause does not fit within the scope of the provision because Eco P6 deals with Indigenous biodiversity and Mahikia Kai is a concept relating to the customary gathering of foods and other resources. Furthermore, Eco P6 is a process policy and is very specific. I note that MWP3 may address Kaitahu's concerns and that the proposed Otago Regional Policy Statement is an integrated document and must be read as a whole. Ms. Mee for Fulton Hogan considers to effectively prohibit activities which have residual adverse effects that cannot be compensated goes beyond what is necessary to achieve Section 6 of the RMA. Eco P6 responds to the obligation of the Regional Council to maintain Indigenous biodiversity under Section 31 GA of the RMA. Therefore, I consider it appropriate if residual adverse effects cannot be compensated and activity is avoided. The ecological justification for this approach to avoid activities where residual adverse effects cannot be compensated is to ensure potential adverse effects on irreplaceable and vulnerable Indigenous biodiversity are avoided. Ms. Hunter considers Eco P6 reliance on APP3 and APP4 as inconsistent with Section 104 1AB of the RMA. As discussed in my Section 42A report, I do not consider Eco P6 as inconsistent with Section 104 1AB. Eco P6 provides specific means of offsetting and compensation in a particular context. The consent applicant may propose something else and it will be considered by the consent authority in terms of its broader discretion under Section 104 1AB and the remainder of Section 104 1. Amendments to APP2, APP3 and APP4. APP2. The issues originally raised in submissions on APP2 largely still stand. I note that some of the submitters' concerns may now be resolved since the expert corpusing. Some submitters remain concerned that APP2 sets a low threshold for identifying areas to be included as SNAs, which could result in the classification of inappropriate areas as SNAs. Several submitters consider some of the criterion as broad and ambiguous, which I addressed in my Section 42A report. A number of submitters see APP2 as aligned with the draft MPSIB or best practice, which I addressed in my Section 42A report. On March 31st, March 23, expert caucusing on APP2 was held between the ecological experts involved in RPS on APP2. I was not a party to these discussions. The purpose of this caucusing was for the ecologists to review and identify points of agreement, including any agreed changes, and to report any areas of disagreement. The following table outlines the points of agreements the ecologists came to during the caucusing and the reasoning for the agreed changes. I note there are still points of disagreement which are set out in the joint witness statement. I recommend accepting the points of agreement that are outlined in the above table between Dr. Lloyd, the ecologist for Otago Regional Council, and all the other expert ecologists, because it appears they will provide better ecological outcomes as the recommendations will improve the clarity and measurability of the criteria. These recommendations are set out in Appendix 2. I consider these amendments as a result of the caucusing satisfy some of the submitters' concerns. In particular, the concern regarding the low threshold of certain criterion has now been addressed, and the issue around measurability of some criterion has been resolved as well. APP3 and APP4. Some submitters consider clause 1 in both APP3 and APP4 set unreasonable limits on when biodiversity offsetting and compensation are available. For this reason, Ms. O'Sullivan for Queensland Airport and Ms. Jarrett for Waka Kotahi seek APP3.1 and APP4 be deleted. I disagree with these submissions as I consider there needs to be strong bottom lines to guide good decision-making on biodiversity offsetting and compensation. Ecological advice is that offsetting and compensation models developed in New Zealand for resource consents have not been robust and have not assisted decision-making. Therefore, I consider it as important there are strong criteria used to determine when biodiversity offsetting and compensation are available to assist decision makers to ensure the best ecological outcomes are achieved. Ms. Hunter for Contact Energy and Ms. Stiles for Moana Energy seek APP3 and APP4 are aligned with the draft EPSIB. I address this in sections 10.29.2 and 10.3.1 of my Section 42A report. Ecological advice is that the criteria set out in both APP3 and APP4 are similar to those in the draft NPSIB 2019. Furthermore, the draft NPSIB is not enforced, and therefore there is no certainty about the content council may be required to give effect to. Therefore, I do not recommend accepting these submissions. Ms. Jarrett for Waka Kotahi seeks specific amendments to APP 32E and APP 42D. She considers these criterion should be amended to be an option instead of being a requirement for an applicant. I do not recommend accepting the submission because making the criterion optional will weaken the intended ecological outcome of them. She also seeks APP 32H is deleted because offsetting outcomes often go beyond the regional council terms and need to be enabled to achieve significant benefits rather than time-bound benefits. I disagree with Ms. Jarrett. The purpose of APP 32H is to ensure applicants achieve the biodiversity offsetting outcomes they committed to. Furthermore, regional consent terms or durations can span up to 35 years, which I consider is enough time to achieve biodiversity offsetting gains. Given these matters, I consider APP 32H as appropriate and will ensure better ecological outcomes compared to deleting the criterion. Kaitahu seeks specific amendments to the provision of Mataroki Māori in APP 31A and APP 41B so that Mataroki Māori is applied and not just a consideration. Kaitahu also seek the inclusion of the following new criterion in APP 3. I recommend accepting the submission because it is consistent with section 6E of the RMA and policy MWP3 and the proposed Otago Regional Policy Statement. Dr. Kissing to Contact Energy and Moana Energy has provided extensive specific amendments to APP 3 and APP 4. He seeks to delete some bottom lines from APP 1 and APP 4 and seeks to delete criterion from APP 2 and APP 42. It appears to me that Dr. Kissing suggested amendments to APP 3 and APP 4 seek to soften the criteria through the removal of limits on when offsetting or compensation is available. Therefore, I do not recommend accepting the submission. Ms. Mealy for DOC has provided specific amendments to APP 3 and APP 4. These include deleting some of the bottom lines in clause 1 of APP 3 and APP 4 and proposing new criterion under clauses 1 and 2 of APP 3 and APP 4. I note that these suggested amendments are of a technical nature. However, I do question the measurability of some of the terms used in the proposed criterion. For instance, socially acceptable in APP 3.1 and APP 4.1D. Ecological advice is that it is important there is strong criteria used to determine when offsetting and compensation is available. I am unsure if Ms. Mealy's suggested amendments add to the robustness of the criteria in APP 3 and APP 4, in particular the bottom lines. Therefore, I do not recommend accepting the submission. Amendments sought by Kaitahu. Mr. Bathgate has proposed a new method to illustrate how Katiaki will be involved in biodiversity management. In Kaitahu's original submission on Eco M6, they considered the provision needed to clarify the Kaitahu partnership role in the management of Indigenous biodiversity. I did not oppose their submission and suggested they provide specific amendments in the evidence for consideration. I support the inclusion of this new suggested method in the Eco chapter because it is consistent with MWP1, MWP2, MWP3, and INP3, and section 6E of the RMA. In Mr. Bathgate's evidence regarding P6, he's recommended that methods is included in the provision. For completeness, I recommend accepting this proposed change. Mr. Bathgate has also recommended amending Eco P10 2P from the coastal environment to coastal biodiversity ecosystems. I prefer this wording because Eco P10 refers to implementing a coordinated approach to managing Otago's ecosystems and Indigenous biodiversity, not the coastal environment. I therefore recommend accepting this suggested amendment, but propose coastal Indigenous biodiversity because Indigenous biodiversity encapsulates ecosystems as well. Response to Claire Hunter's supplementary evidence. At paragraphs 6.10 to 6.11 of Ms. Hunter's supplementary evidence, she disagrees in part with my reasoning for aligning Eco P41A and 1B with the National Policy Statement for Highly Productive Land. She considers Eco P4 should adopt the direction of the National Policy Statement for Freshwater in relation to mineral extraction because wetlands, in particular natural wetlands, often contain Indigenous biodiversity, which qualify as an SNA and are managed through the effects management hierarchy set out in the NPSFM. Ms Hunter therefore considers the NPSFM provides sufficient protection to Section 6 habitats and species. I note that EcoP4 also seeks to protect Taioka, which is consistent with Section 6E of the RMA. This is a matter the NPSFM is silent on and does not afford the same level of protection as Indigenous biodiversity. Therefore, I consider appropriate to adopt the more stringent approach out of the two national policy statements. Because EcoP4 is dealing with more than just Indigenous biodiversity, it is seeking to protect two different matters of national importance. I also note that because these matters are described as being of national importance, it indicates that they are to have relatively greater weight accorded to them. Ms Hunter considers my suggested amendments and my second supplementary evidence to EcoP4 open the door for mineral extraction. However, her concerns regarding EcoP6, APP3 and APP4 are not resolved because these provisions still place limitations on when biodiversity offsetting and compensation can be accessed. Ms Hunter considers if there is a pathway for regionally or nationally significant mineral extraction activities within the Eco chapter, then further changes to EcoP5 may not be required. In EcoP4, Ms Hunter considers it is unclear what is meant by new use and seeks the term is removed. Ms Hunter suggests the following amendments to EcoP4. For reasons stated above in paragraph 29, I do not recommend accepting Ms Hunter's suggested amendments to EcoP4 to align clauses 1A and 1B with the NPSFM. I do not recommend including ancillary activities as this widens the scope of the clauses. I do, however, recommend removing new use and including operation and maintenance in EcoP4 1A and 1B as this aligns with the language used in EcoP4 1.
Thank you, Ms. Hardeman. Yeah.
Yeah, thank you. Yeah, I think what you provided there does cover off some of the questions that I had from your 42A report. So let's turn that on. So thank you for that. That's helpful. Some of the questions that I've got here may be more suitable for for the ecologists. And I know we have had some questions in writing responded to by Dr. Lloyd. I mean, do you, there's been quite a lot of discussions around criteria or principles in Appendix 3 and 4. Is that something that you've sort of formed a view on, or are you just referring to the ecologists on that?
I'm referring to the ecologists.
Yeah, okay. I mean, one of the other things that's come up quite a lot too is whether there should be definitions for offsetting and compensation. And I note Mr. Mark Christensen's covered that in his evidence. And there are, in the NPSIB exposure draft, there are definitions in there as well. And I suppose one of the, when I was sort of, initially looking at this chapter, it was sort of seeming to be a gap there for me. I mean, do you think that that offsetting and compensation are sufficiently well enough understood that there don't need to be definitions, or do you think that I suppose the definitions are sort of inherent in the provisions that are in the plan? I mean, do you have any comment on that?
I consider that APP3 and APP4 qualify what biodiversity offsetting and compensation is. However, I'm happy to seek ecological advice and consider that in reply.
Yeah, okay. Eco P9, I didn't see that addressed in there. There was, in terms of wilding pines, and I think it was most QLDC were one of the submitters that were covering that, but there were some suggestions around whether it should be applying to to species other than just conifers, and there were some species listed, and I think they're also ones that are recognised more widely as well. Do you think I mean, do you have any sort of other comment on that at this stage? And I was also interested too, I mean, I suppose this, and is this something, I suppose it's going to come down to a district, to what's in a district plan, but through the policy there, it is, I mean, it isn't restricting the planting of wilding conifers, is it? It's just avoiding them where they may impact on SNAs. I mean, is there, do you think that guidance goes far enough given the impacts that we're seeing of wilding species? Is that likely to be consistent with section 6C? Sorry, that was a bit of a garbled question.
I think the purpose of this policy is to protect SNAs from wilding conifers, well, originally from plantation activities. And I think we did try to include wilding trees. However, from memory, we ran into issues with it being inconsistent with the NSPF. Yeah.
Yeah, I mean, I suppose I take that, you know, there's a lot of other activities that impact on Indigenous biodiversity as well, but I suppose, you know, given that we're looking at what the objectives are, is it going to be achieving the objectives if it's just focusing on SNAs? Understanding that I know the evidence of QLDC is saying that I think what they've got in their plan at the moment is taking that further than what you've got here at the moment in their district plan.
Well, there's nothing preventing from TNAs, TAs to include provision of that nature.
So you're happy. I mean, you're satisfied with the policy as it is, with district councils being able to go further than that if they seek to the district plan.
Yes. Just
Yeah, I think the other things will probably be directed at the ecologists. So, thank you.
Thank you. Thanks, Alan. Maybe just start with your supplementary evidence.
first or second?
Oh, sorry, I mean what you've presented today.
Oh,
Sorry.
right.
You're right, yeah, summary. Crikey, how many supplementary evidence? I probably haven't read them. Just sort of in a general sense, when you talk about some of the changes to APP 3 and 4, when I read the evidence, like a number of the ecologists, particularly Dr. Keesing and Doc, seem to almost agree about removing some of those bottom line or limits. And I'm just wondering if you have thought about that, what they're saying in the context of an issue that has been raised by a lot of the ecologists, is that an avoid approach in certain areas is not necessarily a good outcome, because the issues we have with biodiversity these days is what's left is not necessarily being protected, it's being degraded through pests, etc. So quite often the best outcome is actually allow people to do stuff and require them to upgrade that, improve what's there now. Did you have any thoughts around how that might work, or can that work in the current scenario proposed by the architect? the concern seems to be that it's made it very difficult to achieve something like that.
I'm not sure. Yeah.
Yeah, I just wondered if those themes that come through had influenced any of your thinking, but
I mean, from the equitable advice that we received, it was strongly suggested that we need strong bottom lines.
Yeah.
So, yeah, removing those bottom lines, I'm not sure how that would,
so something I guess the witnesses will address.
yeah.
Sort of related to that in your paragraph 14 today, you're I'm not sure if this is on point. And I did note it in your section 42A report that an applicant comes along and proposes something different in terms of how you achieve that offsetting and compensation. That could be considered, but there's pretty strong direction in the RPS that I can't recall what it is. I think there's one of the methods in there for the district plan that pretty much says if you don't follow this process, then consent authorities have to decline consent. So is that talking about, what's that talking about? Is that the effects cascade and
Yeah, that's the effects management hierarchy.
yeah, so not so much the APP 3 and 4.
Well, the effects management hierarchy does reference APP 3 and 4.
So is that's probably a question for, yeah, is that legally document actually, the planning document require that when there are other ways to skin the cat?
Yes. Yeah, I submit yes, and I did touch on that in my submissions there. And indeed, the higher order planning documents such as the NPSFM also require, like I said, I think it's the NPSM as well, certainly the exposure draft. The first principle is adherence to the effects hierarchy.
So
And it goes further. It says adherence to the effects management hierarchy. An offset is it says what it is, and then it says and should only be contemplated after, only after steps to avoid, minimize, and remedy adverse effects are demonstrated to have been sequentially exhausted.
So basically, if they haven't gone through that process, you have to decline consent.
That is what the national plan, national policy statement provides. Yes, I believe that the idea is that stepping through is very important for maintaining Indigenous biodiversity.
What was the clause you just read from? Which clause?
So sorry, that is principle 1 of the draft NPSIB, but as that has no legal effect yet, I would just like to get the NPSFM up. But I do understand that the NPSFM may have the same. Yes, so in Appendix 6 is and of the NPSFM is principles for aquatic offsetting, and Appendix 7 is principles for aquatic compensation. And number 1 on both of those is adherence to the effects management hierarchy. And it says it should not be, it should be contemplated only after steps to avoid, minimize, remedy are demonstrated to have been sequentially exhausted.
Yeah, I guess my question was around the reference in paragraph 14 that if a consent applicant proposes something else, but I think that's not in relation to the effects hierarchy as it is in relation to the criteria in APP 3 and 4. Just trying to get that in my mind.
Yeah.
Yeah. Okay. What's the check? Yes, one of the concerns that's been raised, and it's around mapping that and it not being mapped, people not actually understanding where it is. There is a bit of an unknown there. Taking the lead from the chair around the different levels of protection offered in section 6 around that, because Kanuka and Manuka and Otago isn't scarce, it's everywhere. And that's a Taiaka species, so I just wonder how practical some of those avoiding adverse effects on Taiaka like that is that these policies actually require. So any loss or reduction in area of those things contravenes these policies. Even though Kanuka has been removed, I think, from the indigenous vegetation references, it probably hasn't from Taiaka. So how do we deal with that when you've got vast tracts of private land that is involved with a provision like that?
Sorry, can you please rephrase?
Okay, I'll try to. I'll find where the actual provision is. So policy 3. Let's first avoid any reduction in indigenous vegetation and any loss, and that includes Taiaka. They're identified and mapped. So the question is that it's more in the context of things like Kanuka and Manuka that aren't rare in Otago. That could fall under that. And it's going to be farmland, that's going to be an issue. How do we deal with that when I think the policies don't require Otago to be mapped if we don't want it to be mapped? Maybe not a question for you, it might be for Otago. I'm just trying to think ahead how this would work in a district plan. We see it in M3. They may not identify that.
Yeah,
How does that work?
in terms of how can someone avoid.
Yeah,
Yeah.
you've got an avoid policy or a loss of extent policy, and you've got something that's actually not met.
Yeah,
I don't see how that works.
Yeah, I can see how that would cause potentially some issues.
Yeah, I'm just sort of thinking ahead, someone who's going to write a district plan, put this in place, and not sure how that would actually pan out. Maybe it's just something to think about.
So just in the monophenol chapter, I believe that it's identifying values, including biomapping, because there are situations, particularly we know in Queenstown, where iwi don't want the item that is special mapped. So I guess mapping is one way of identifying and TAs and regional councils would have to work with mana whenua to
Yeah, I
give some
guess,
specificity and some protection around that. It'll have to be a real collaboration really.
yeah, it'd be probably a question more for
Mm,
Kaitahu because
Mm.
it'll depend on what the actual value of resources
absolutely.
and how they want to deal with it. Imagine if it is vegetation, they'll have to probably map or identify it some way.
Mm.
The only other question was around policy 5, which we discussed a little bit earlier. I'm just trying to work out how that works also. It allows the continuation of these things. Will not provide, will not lead to loss of extent or degradation. And then the adverse effects are no greater in character, spatial intensity. The whole idea of existing use right is that it is going to actually remove or lose those values. If this is applying to indigenous vegetation, which regrowth, I guess, I'm thinking of a farming scenario here, how would that policy apply? For example, a farm scenario in the Catlins where it's an area where indigenous vegetation pops up all over the place quite quickly, you'd be caught by something like that, wouldn't you? It goes back to that existing use right issue. Because the existing use right is the ability to clear the spatial extent of that vegetation. It's coming back.
Yeah, I guess in theory it would.
Area would stop it. I understand the intent of it. It's
Yeah.
the work in practice and
Yeah.
what is the likely scenarios that would apply in Otago. And that's that Southland issue is on that point, that very point. So maybe worth looking at that case in relation to that. I just had one other question. I can't remember what it was. Yeah, actually, that was on that. So thank you for that. Cheers.
Kia ora. Your paragraphs 25, 26, 27, and 28 pretty much hit the nail on the head as far as my earlier question is concerned about how taonga and the relationship with mana whenua are handled. But that was Mr. Bathgate's suggestion as a new method.
Yes.
Right. But if I go back to your paragraph 12, we're looking at Eco P6, and you say you're talking about mahinga kai as a concept relating to customary gathering of food and other resources, so it doesn't quite fit. I'm wondering though, if you looked at mahinga kai as a place rather than a process, because they're both. Mahinga kai can be a place and mahinga kai is a process of gathering from that place. It's a bit confusing, I think, to the non-initiated, but there is a difference. And a mahinga kai could be, for example, a fishing ground or a particular hunting ground. It's the place that you go then to do your mahinga kai verb, I suppose it is, the doing of it. Would, in that, well, if you were to accept that, would that then address your concerns about Eco P6 and Ngaitahu's request to have that included as part of Eco P6?
Yes, it would, but I'd have to think about the drafting.
Yeah.
Yeah.
I just
I
want,
see
because
what you're
I
saying.
think we need to recognise that as well.
Yeah.
It's not that it's the gathering of food, but it's the place where food is gathered. So maybe if you could just have another think about that. Yeah. Great, thanks very much. Thank you.
Not sure whether I've missed something in the welter of documents from yourself, but in relation to the way that the provision is worded at Eco P4 in the second line, maintain Otago's Indigenous biodiversity by following the sequential steps in the effects management hierarchy in relation to Indigenous biodiversity set out in Eco P6 when making decisions on plans. Then it says application for resource consent or notices of requirement. When you get to P6, the word plans is missing. So in P6, it's third line and decision making on applications for resource consent and notices of requirement. And some of the submitters at some stages in submissions have raised that omission. I wasn't sure whether you came to any final conclusion on it.
Well, the Eco in 4 and 5 direct regional MTAs to include the effects management hierarchy.
At a policy level, there's a gap.
Yeah, I think it is meant to be.
Well, I'm not asking you to give us the spur of the moment decision on it,
Right.
But I want you to address it and reply.
Okay.
Because I may have missed it. You may have addressed it somewhere in your report or in your supplementary evidence, but I can't remember seeing that you had. And then we ended up in, when I look at your final today, the same omission seems to be there. And I wondered whether it was a purposeful omission, and if so, what are the reasons for it? And that's something that you need to think about and come back to us and reply, if you would. All right, thank you. I was just turning to your evidence today. I was taken a bit by surprise by the statement that paragraph 29, if you compare to that, where you're addressing Eco P4 also seeks to address Tāwaka, which is consistent with section 6E of the RMA. And you then said, this is a matter the NPSFM is silent on and does not afford the same level of protection as Indigenous biodiversity. But if you look at the NPSFM, it's just replete with, right up front, virtually, with recognition of all aspects of Mātauranga Māori and Te Mana o Te Wai concepts, the requirement that even if you look at the compulsory appendices, if you look at Appendix 1, there are 4 headings: ecosystem health, human contact. These are compulsory values that have to be taken into account. 3, threatened species. 4, mahinga kai, and 3 or 4 paragraphs in relation to it. So I'm a bit bemused by you statement that the NPSFM is silent on and does not afford a level of protection for, or the same level of protection as for Indigenous biodiversity. Was there some reason for you saying?
I think I was referring to the effects management hierarchy in the NPSFM and the appendices.
All right. I'll have a look at those in due course. Okay. So when further down, you say in that same paragraph, the Eco P4 is dealing with more than just Indigenous biodiversity, seeking to protect two different matters of national importance. So just for absolute certainty, you're meaning Indigenous biodiversity in significant areas and the protection of taro.
Yes.
At paragraph 21, one of the, where you're addressing the requirements in appendix 3 to ensure applicants who achieve the biodiversity offsetting outcomes they commit to, and you're supporting the proposition that that must be within the duration of the consent. And one of the reasons you advance right near the end of that paragraph is furthermore, regional council consent durations can span up to 35 years, which I consider as enough time to achieve biodiversity offsetting gains. But equally, they can be far shorter than that, can't they? And very frequently, particularly where allocation issues are involved, they'll be far shorter. They might even need 5-10 years. Proposition that a lot of the ecological experts are putting to us is, look, as an offset, we might be proposing things that may even involve, for example, the growth of podocarps or something of that nature. You just can't reasonably demonstrate that within a period of 5 or 10 years. Do you accept that that's a reasonable proposition or advice?
Yeah, I do. Yes.
Just the wilding trees issue that Commissioner Sullivan raised with you. You said, and I'd definitely like you to give some thought to this before we come to the replies, reply by the council, because having in the intervening period between the last set of hearings and this hearing, having driven down to just have a look at the areas that we've been hearing evidence about and driving through the Mackenzie, you just can't help but be horrified by what's happening there. And you can't help but think, if something doesn't happen literally in the next 2 or 3 years in the Mackenzie country, and the same could potentially occur in Otago, we're here hearing evidence about everybody being concerned about the ecology and the indigenous biodiversity within tussock grasslands. But if you drive through the Mackenzie at the moment, there's just swathes of wildlings that are literally 18 inches, I'm sorry, I'm on fashion, but whatever that means in centimetres, but there are just swathes of wildlings everywhere. Wakakotahi seem to be doing their best to spraying the road edges, but immediately over the fence there'll be a shoulder belt with a wind pattern of wildling spread beyond it, and that's just commonplace. One of the, it would seem to me, one of the very strong policies that is needed in this piece might well be a stronger emphasis, not in terms of protecting SNAs necessarily, but just in terms of protecting the general biodiversity that exists in Otago. And when you look at this RPS, you correct me if I'm wrong, but it seems that all that is provided for other than SNAs is supporting initiatives to control existing wildling conifers and limit the spread. Am I missing anything? That seems to be the limit of the protection that the RPS is advocating.
No, you're correct.
Right. Yeah. And on the issue of trees and conifers, I think it was DCC, I think, in their evidence, and referred to the fact that I just turning to it because it's filed. I think I've got a note here. Yeah, it was Mr. Freeland's evidence of paragraphs 52 to 54. He addresses the spread or the risk of spread of rowans, sycamores, boxthorn, hawthorn, and certainly coming from Marlborough, I know that all of those are serious issues. As I would have thought, and I'm not sure that I couldn't pick it up on the list because it's a wild and conifer list, but the roseberry, again, in areas like Central Otago or Marlborough, again, major weeds of concern that can shut out other Indigenous biodiversity. Is this an area that needs a real rethink by the council? And that's probably for Mr. Jarvie as much as for yourself. But have you turned your mind to those sorts of issues?
Yeah, I think there probably is more thinking needed in that space
Right.
because it is an issue.
Well, I'd
at the
certainly
moment.
put it out there for the council to.
Sorry.
I'd put it out there to the council to respond to in closing, because we're hearing a lot of concerns being expressed about the removal of areas, whether it be for mining or for telecommunications networks or for roading or whatever it might be, about the removal of what might be arguably relatively limited areas of land. But the bigger risk, it seems to me, is the uncontrolled spread of pest species that are quite massive by contrast. And that probably leads to the last issue the broader issue that I just want to canvass with you, which is really that sitting back from this huge amount of evidence, I don't envy you the task, and we've got it as well, but to try to look at the various large number of ecological experts who are coming along. But I thought, I think it was Dr. Keesing put it really well at the end of his evidence, where he basically said, look, we have to be aware of the fact that we need to protect SNAs, we need to maintain Indigenous biodiversity, but the reality is we've got an elephant in the room that's bigger than those and is going to overcome it, and that's climate change and the climate change effects. And so his emphasis then was that when you're weighing those considerations, that you've got to give greater effect to the bigger risk, in essence. So, I mean, I probably would agree with the way I paraphrased it, but that was the thrust of what I got from his evidence. If we were to conclude that that was a reasonable proposition, then in weighing the avoiding of effects at the lesser level, when a proposition has been put forward, whether it's been second national grid for resilience from a Lake Onslow type proposal or whatever it might be, whether it's the Lake Onslow proposal itself or whatever it might be, that is arising out of the electric regeneration, sustainable regeneration, generation, sorry, not regeneration. Is that something that we should be weighing more heavily than avoid policies which are trying to protect the level of Indigenous biodiversity, which is subject to all sorts of predator species and pests?
I'm not sure.
Well, can you give it some thought? Because I'm going to ask you the same question when we come to closing. So I'd rather that you put forward a reasoned thought process on that issue, because I think it's a very valid point that he's raised, and we need to decide it at some stage. But we would obviously be very much assisted by ORC, and I appreciate that that's something you want to talk to the RD about, or Dr. Lloyd, or whoever. But certainly is a very large issue that I'd like to hear about, and equally I'd like to hear about that large issue of predator species and the potential impacts of those, and whether or not the RP is strong. So thank you. Otherwise, if we got into the detail, we'd be here all day with you, but get on and hear the other witnesses. So we'll take a break at this stage and have a cup of tea for a quarter of an hour, and then we're on with contact energy. Thank you.
for Mr. Jarvie or Mr. Gamble.
I think we're in a position where we pose the questions to Dr. Lloyd. Obviously, a number of those issues raised with Ms. Hardiman really would have been issues that require a response, and I don't think it's worth us. We've got a pretty heavy load for these few days, and I was rather hoping that Mr. Jarvie might stay and hear the other ecologists and hear the issues, but equally you may be doing that online. So in reality, what we're looking for is a measured response in the reply. Whether that, and I'm not sure whether Dr. Lloyd's going to be available for that. But the last thing, certainly we're looking for Mr. Jarvie, and we'll be having questions at that time.
Thank you.
Thank you. So we're contact energy.
Yes, thank you. Good morning. So I think we are meant to have Brad Coombs on the line or on our list as well, but he's not going to be joining us as far as I'm aware. So it's just myself and Dr. Keesing this morning.
Thank you.
So I'll kick off. I've got a summary statement.
Just before you do kick off, as you've got it, how are we to deal with Dr. Keesing's evidence? Because we had read that you felt that your evidence was the same for contact and for Manawa. So some of us have read the contact energy version, some of us read the Manawa version. So how do you want to deal with that?
Well, fundamentally, it's the same because the opinions and the evidence is the same and the issues are the same for each. If we deal with contact energy and Manawa kind of today in whole, and tomorrow I can turn up again for Manawa, if you have questions overnight, thoughts about that, and we can address those there, but I thought we would give the substantive responses today and the questions today.
Good. Right. Thank you. Thanks for that.
I think you should have my summary statement in front of you now.
Thank you.
Just reading on 1.1. Contact Energy made submissions on the eco provisions of the proposed Otago Regional Policy Statement. In particular, Contact had concerns with Eco P2 and Appendices 2, as well as Eco P6 and its reference to Appendices 3 and 4. These matters are summarised below. 2.1, Contact submission raises concerns with the generality of the approach to identifying significant natural areas using the framework set out in Appendix 2. In Contact's view, using this approach will likely require large areas of Otago to be classified as SNAs because the threshold for qualifying for an SNA is too low. Dr. Keesing has similar concerns, noting that applying the criteria in Appendix 2 will likely lead to significant uncertainty as well as a lowering of the bar, such that many areas or features often of low ecological value would be found to be an SNA. Contact sought deletion or otherwise amendment of Eco P2 to provide for the mapping of SNAs at an appropriate scale in the relevant regional and district plans. The Section 42A report notes the requirements of methods Eco M2 and Eco M3 to work with mana whenua to identify and map SNAs, and therefore did not consider it necessary to specify the responsibility of local authorities in the policy. However, the report has recommended inclusion of mapping to the identification process. I support this amendment. Notwithstanding this, I still consider there to be potential problems with the criteria set out in Appendix 2, on the basis that the bar may be set too low and it will take some time for the mapping to be completed. I have reviewed the joint witness statement following the expert ecologist witness conferencing session to discuss Appendix 2, which occurred on 31st of March 23. It is apparent from the statement that there is not yet an agreed set of criteria between the various ecologists. And in my view, this is not an unsurprising outcome. However, it further indicates that the criteria may not be fit for purpose and therefore should be taken with care in terms of the application, of Appendix 2, as it could, as demonstrated in Contact's and others' evidence, potentially have widespread and unforeseen implications. I also note that a number of ecological experts agree that the impact of implementing the criteria has not been analysed as part of the Section 32, of the RMA or within the Section 42A reports. On this basis, I am unsure of the likely impact the proposed SNA framework, in whatever form it will ultimately take, will have on development activity in Otago. A number of experts also expressly acknowledge in the joint witness statement that meeting only one of the criteria set out in Appendix 2 is a low threshold for attributing a significant status. In addition, Dr. Thorson and Dr. Keesing recommend amending this as follows, so that an area is considered to be a significant natural area if it meets the threshold for the rarity criterion or 2 or more of the criteria set out below. Given that an agreed set of criteria has not yet been developed amongst the ecologists, it may be more appropriate to refer to the criteria in a less absolute way when drafting the provisions and methods of this policy statement, which refer to Appendix 2. By this, I mean that additional wording could either be added to Appendix 2 itself or within the methods Eco M2, setting out that, I'll just read that for clarity, an area is considered to be a significant natural area if it meets the threshold for the rarity criterion or 2 or more of the criteria below and is mapped in the regional district plans. If an area meets the threshold for the rarity criterion or 2 or more of the criteria below and is not mapped in the plans, determination of significant status will need to be verified by an ecological assessment on a case-by-case basis. Getting now to Eco P6 and pieces 3 and 4. Contact submission noted its general support for enabling a pathway for infrastructure projects by allowing access to the effects management hierarchy for such activities in Eco P6. However, Contact raised concerns about the workability of the policy when read alongside Appendix 3 and 4, noting that these appendices contain criteria significantly limiting the situations in which our environmental offsetting and compensation would be available. When environmental offsetting and compensation are not available, the policy response requires avoiding adverse effects for the activity itself, which could significantly curtail otherwise meritorious yeah, sorry, I can't get that one out. Proposals, material, you know what I mean. In Contact submission, reliance on Appendix 3 and 4 creates an inconsistency with national directions, such as the NPS freshwater or evolving best practice as set out in the exposure draft proposed national policy statement for Indigenous biodiversity, as well as with section 1041 AB of the RMA. I believe the current drafting of the criteria within Appendices 3 and 4 is too limiting. It also fails to recognise that the reality that large-scale renewable electricity generation projects will inevitably affect natural and at times highly valued resources. Moreover, the constraints and scale of renewable electricity generation activities will often mean that it will not always be practicable to locate, design and manage these activities, such as adverse effects on SNAs are all avoided and limits met, particularly in natural environments. Under the current drafting of these appendices, if certain impacts are to arise, e.g. the loss of any individuals of threatened taxa and or the removal of its habitat, the activity is automatically ruled out for offsetting or compensation. In other words, offsetting and compensation cannot be part of the environmental effects management matrix when specified species of conservation value or the habitat will be lost, even though the loss may be capable of being offset or compensated to produce a net gain for the species of interest. As recognised in the National Policy Statement for Renewable Electricity Generation, effects from such proposals will often need to be offset or compensated, and it requires decision makers to have regard to them. That is a specific obligation solely for offsetting and compensation for renewable electricity generation activities, and which must be given effect to by the proposed regional policy statement without limitation. The approach which is set out in Appendices 3 and 4 is therefore not currently consistent with this. Such limitations could therefore inadvertently preclude renewable electricity development, as well as the ability to achieve good biodiversity outcomes in Otago through valid offsetting compensation means. Dr. Keesing agrees with this from an ecological perspective, noting that the current drafting of Appendices 3 and 4 set a high bar as to when offsetting and compensation are available in Otago, and that this will ultimately lead to poorer ecological outcomes for the region. He notes that the NPS 5B exposure draft does not take such a restrictive approach. Instead, it gives examples where offsetting would be inappropriate, including because of the irreplaceability or vulnerability of the Indigenous biodiversity affected. I consider that Appendices 3 and 4 should be amended to remove the relevant clauses that set unreasonable limits on when biodiversity offsetting compensation are available as a management response and seek to ensure consistency with recommended best practices and or national guidance for biodiversity offsetting and compensation, such as the NPS IB or the NPS freshwater management. Similar to this approach, it would be appropriate to amend these appendices so they act as guiding principles against which offsetting and or compensation proposals are considered against. That's the conclusion of my summary.
Thank you.
Yeah, thank you. Just in relation to your paragraph 2.11 in the summary you've just read out. And I was just wondering if you could direct me to where in the NPS reg it talks about that. I suppose with that that NPS would override the RPS anyway. Am I correct in that?
Yeah.
So
I think the provision, I just will need to bring it up online.
So I'm just I suppose wondering to what extent that is an issue.
I think I'll need to just double check what it says, but I think that particular policy and the NPS directs the regional plans and district plans to
Right.
include provisions.
Okay.
Is it policy C2 for the other bit?
I need to roll it up online.
C2.
Yeah, I'm assuming that it probably is C2, which says decision makers with regard to offsetting measures or environmental compensation including measures. Yeah.
Yeah, well, it probably is.
So I suppose I'm just struggling a little bit in seeing the difference between that and what we've got here. I'm just wondering if you could elaborate on that a little bit more.
I think because the provisions direct for the activity to be avoided if you can't give effect to the effects management hierarchy, which if you can't give effect,
So
if
it's
you can't have offsetting and compensation,
Yeah,
then you circle back to an avoidance.
the bottom rung is the problem. Whereas I suppose this policy is saying if you can't avoid, remedy and mitigate, you have regard to offsetting and compensation, but it doesn't actually say what happens if offsetting or compensation isn't appropriate or
Yeah, it doesn't in that, and I as I acknowledged, there may be circumstances where that it isn't appropriate, but you should still, be allowed to make your case in terms of an application process.
Okay, but through policy C2, yeah, it's not saying it must be granted.
No, it is, you shall have regard to.
Yeah.
But I think here, the way this is structured, that you simply cannot have regard to it if you don't achieve those. You don't get through the gateways effectively in terms of the limits that are set out in TNC 3 and 4.
Yeah.
It's closed off too.
Yeah, okay, no, thank you for that.
Thank you. Thanks, Cleo. I didn't really have a lot. The funny thing is we've been hearing this for the length of the hearing, actually, this very issue. But the concern around the Section 32 analysis as it relates to the spatial extent of what might be affected by the policies. Is that a relevant issue? Surely the Section 32 will determine what's the best way to deal with significant biodiversity, and it'll come in the form of a policy in these documents, because they're not going to map things in this document. I'm not sure what the concern here is.
I guess it's an understanding of the costs of the implication of that particular, criteria if it's far reaching. that will apply to a lot of the Otago, environment, and what the potential costs of that need to be quantified in some way in terms of the Section 32 analysis.
Pretty hard task anyway,
Well,
isn't it?
I agree, but I think there needs to be some judgment applied there in terms of the Section 32 obligation.
So really, it's the extent to how that policy is going to impact spatially rather than.
Yeah, and I think that's where I'm suggesting that maybe it shouldn't be an absolute requirement, and that perhaps, where they are mapped and clearly sort of defined boundaries in the district plans, that makes sense, and that's probably the best of the best that you're protecting there. And I don't think people would really object to that. But then if it's, you might hit some of the criteria when you're looking at a project, and there needs to be some more ecological evidence around the significance of that.
Yeah. And is that your amendment and?
And
Appendix
2.6, yeah. So
Yeah.
that probably addresses some of the cost to a certain extent if you apply it in more of a, not such an absolute way.
Yeah. I'm kind of trying to work out how that might work, that the last line. An area meets the threshold for rarity or two of them other criteria, and it's not met. Significance has to be determined or verified by an ecological assessment. It's kind of the other way around, isn't it? You kind of need
Well, I
to-
think, you might hit the criteria, but I think then some sort of application of the environmental context, the receiving environment might need to apply, and make perhaps the significance isn't so, black and white there. That's what I mean by that.
Yeah. Casey looked at me sideways there, so you want to address that. Yeah. Yeah, I guess, and that, what you've sort of highlighted there is probably a question I have for Dr. Kissing around this use of ecological districts, there's use of land environments, there's all these things and how they relate. And I think that's probably the issue. Yeah, okay. I don't think I have any other questions on that, but your concern with page 6, and you're giving evidence for someone else soon with a different set of policy structures that I think Mr. Christian has promoted. And I can't recall what your evidence was around that, but I'll leave it to them because it is structured differently, and what ACN is proposing, how the policy and definitions and all that work. You haven't touched on it here, I don't.
No, I haven't. No, we will return to that this afternoon. So
Yeah. Okay, well, I'll just leave it there.
I'll just come back to the question I asked right at the very beginning of today's proceedings around Tauka and the relationship that Mana Whenua would have in the broader picture around ecosystems and indigenous biodiversity. Now, in your paragraph 2.3, you refer to Section 42A report that requires Mana Whenua to work with or to identify and help map SNAs under Eco M2 and Eco M3, which you support. But I do wonder whether it goes far enough. It referred to the bar still being set pretty low.
I don't really have a specific comment on that. I mean, if that's, that does talk about local authorities working with Mana Whenua to agree a process for identifying.
Well, it's another question I have, and again, it's a very general one, but every now and then I see, not just in your evidence, but in a lot of the evidence of a number of other people that refer to unreasonable limits. So what's reasonable?
I think that it shuts the door immediately. So that's an unreasonable proposition, more than an unreasonable limit. It's more that if you hit that criteria, even though you might be able to offset it and compensate it through valid mechanisms,
Yeah.
you're not able to demonstrate that you can do that. That's what I mean by
Okay.
reasonable situation.
And that's around whether offsetting or compensation is
Yeah,
available.
it's available, so
For example.
it's unreasonable if you're shut at that point. Yeah.
All right. Mm. Okay, that's me, thanks.
I've got a lot of questions for you, Ms. Hunter, but just looking at the NPS on renewable electricity generation. The same, I know it was 2011. And the same gap seems to apply there that I was raising with Ms. Hardeman or Ms. Hepton, I can't recall which, but in relation to the fact that it only seems to draw attention to the conditions imposed on consents, i.e. in policy C2, and I've just checked your evidence, and the footnote you gave was to that policy C2. So all the regional policy statement provisions, regional plan, district plan provisions under subsection E of the national policy statement don't seem to address offsetting or ecological or environmental compensation at all.
I think they probably do in a more indirect way by saying that you're talking about including objectives, policies and methods to provide for the development, operation and maintenance and upgrading of new and existing. So in doing that, you might have provisions that relate to offsetting compensation for biodiversity, noting the types of environments they're within.
Right. It just seems a really strange policy gap, doesn't it? You know, in terms of the way in which the statute's been amended, the way in which these NPSs have been issued, that from a central government viewpoint, the statutory guidance seems to be solely limited to conditions on resource consents in relation to those two issues of offsetting or compensation.
Yeah, well, yes, in terms of the words there, but I actually, it's not limited in any way because of this NPS. And then there are other things that have, happened since then, like the section 104.1a(b), which does allow offsetting compensation to be considered.
Again,
Section 104, yeah. But I think that this doesn't foreclose any ability to do that.
No.
It's wording.
No, look, I understood your evidence well, thank you, and no further questions for you.
Excuse me. I've handed you out a further brief statement of evidence addition, 20 pages, in addition to that which we met earlier on in this process. And it basically just runs through the joint witness statement variations I have.
Actually, there was one other question from Ms. Hunter that I'd like to raise with you, not arising out of your evidence, but just in terms of the joint witness statement, the contrast seems to be between Ms. Hardeman's position that you accept all of the propositions that were agreed between the experts, but as I understand the thrust of what you're saying is we should put a strong emphasis on those points of disagreement and the reasons for the disagreement. And you say that is still sufficiently worrying in terms of Appendix 2 to lead to the potential for large areas being, which may not be of necessarily significant importance, being identified as SNAs.
Yes, I don't think there is an agreed set of criteria. That's essentially what I'm saying.
Thank you. Sorry.
That's right.
We've now got your brief statement.
Right. I just want to make a point clear too. Under the heading "My Evidence," the fourth bullet point in it says, "In essence, my opinion." is that the current level of threat, and by threat I mean willful and accidental clearance by humans, not the threat of wilding pines or the threat of climate change. So that threat that I'm talking about in that paragraph is about active clearance by people. That has diminished substantially over the last 30 years, that activity. It still occurs occasionally, but compared to how it used to occur and how much it used to occur, it's. So I just want to make sure when you understand when I say threat there, that's what that was about. Now, to the joint witness statement, in essence, the most important thing from my point of view in that is that the criteria allow you to tick one and one only, and therefore register yourself significant. And I still think that some of those criteria, such as diversity, are not empirically based and allow you, with a kind of a wave of your hand, to tick that and move on. And I don't agree that that's the way. So one way around that without taking diversity out of the criteria is to make sure that two criteria have to be ticked, or rarity in and of itself, because rarity is A, more empirically based, and B, perhaps more important. You'll find that in the representativeness, we generally agreed to that criterion, and it's an important one. It's, to my mind, it's one of the most important criteria, because it says that your community reflects something of the structure and species assemblage that was there. And if you're about conservation, then that's what we're trying to do, is protect those full functional systems. One of the reasons why I believe that we need to remove diversity is I don't believe it has an empirical basis, and I don't think it offers us anything that couldn't be covered in distinctiveness. So if you are an assemblage, say a forest, and you're sitting there and you've got a range of species on the ground, a range of species at the top, a range of species in the middle, and an ecologist comes along and counts them all up and said, that's representative of a natural forest, well then of course it's going to have its natural diversity. It's not going to have a high diversity, and it's very unusual to have a particularly high diversity unless it was unless all your other examples around the place were highly modified. But then that makes it distinctive, not a particular value to high diversity. If you have the diversity you should have, then you are representative. Does that follow?
Yeah.
So I think it's a redundant criterion. I think it is a criteria that is too often ticked without really any evidence. Similarly, if you have a sequence or a series of habitats that are associated with different gradients, maybe a pH gradient or a water gradient or a soil type gradient, to my mind, that can be better covered by a distinctiveness criterion rather than a diversity of habitats, because wherever you get a change in a type of habitat, you might argue that you've got a diversity. If you've got 3 or more bits, you might say, well, there's a high diversity. So there's no reference, no empirical way of saying objectively, yeah, that's a high one. And again, I think it just leads to people ticking it. And it would be, to my mind, a shame if a feature ticked diversity high, and that was the only criteria it ticked, and you said, therefore, it's significant. I think this should be more robust than that. I would like to remind you all that, in my opinion, and I think I've written evidence, these set of criteria are going to be applied to little features in the private landscape. DOC has its area, and it has most of the best of things. Then there are a range of reserves and other types of QE2 and other types of common areas which pick up the next good things. A P&AP process has gone through New Zealand since '81 that has identified the important big features. Not all regions, not all EDs have been done. Then each council have done S&A surveys, and not all of them are published, not all of them are done, but surveys have been done. So these criteria are going to be generally applied to those things that are below that lot, and to smaller features and highly modified features in the general. So we're not talking about cream of the crop here, we're talking about a lot of smaller, probably highly modified features. But all of them will be quite readily able to be ticked significant under these criteria. And ordinarily, I wouldn't mind if it wasn't an avoid or stop or do nothing policy. And recently, I had a discussion with a council officer oversight, just as an example, which was very highly modified. only met the criteria on a technicality. And I said, very well, so we have to avoid it. Yes, he said. I said, well, we'll put a fence around it and walk away, see you later. And he froze. He said, well, you have to plant it up. I said, no, we're avoiding it. You have to fence it. No, we're avoiding it. You have to take care of the pests that are destroying it. No, we're avoiding it. And this is a problem. It's not something I wanted to do, but if the client has avoided the feature, there is no requirements of them to change the trajectory of that feature. And I think a lot of the features we're going to talk about in this criteria being used are those that are declining. And in the absence of some form of rescue or management will decline to zero. And that'll only be exacerbated as wilding kinds and climate change and pests and predators come through. And the question I ask myself, well, who pays to manage those things? And I see that the offset procedure, or even the mitigation procedure for that matter, is one of the main things that have occurred in my last 20 years of work that has caused these things to stop declining, to get better. And sometimes you have to lose a little bit to get that. And from my mind, that's highly valuable. It's okay to lose a little bit if you get security for the greater good. There's a few other little bits and pieces of disagreements, not many and not major. As I say, the most important aspect of these that I see is that ensuring that only one criteria isn't enough to make it significant. And very briefly, I will touch on the criteria for biodiversity offsetting and compensation. As Ms. Hunt has already pointed out, I do think that they are overly restricted, and I think they will stop a lot of good happening. As I've just noted, a lot of potential benefit comes from allowing an activity with an offset attached to it that has conditions around that offset and that governs and checks compliance of that offset so that those things happen. But where, for example, you get a loss of an individual of a threatened taxa. Now, threatened taxa is a high bar. There's only 3 types that are highly endangered, if you like, but some of those taxa, such as Rahutu, are still quite common, Neometus pedunculatus, and you'll encounter areas of it, and you could certainly lose a couple of individuals and not have an effect on the wide population. If you said, no, you're going to chop down that one small Rahutu shrub, therefore you can't do the activity, and therefore you can't get all the offset gains that you might have had that would have secured the widest feature, that would be a very poor outcome. So I think there are examples in here that really restrict, irrespective of the fact that maybe it's an infrastructure that's coming through that needs to happen and would be stopped. Just getting a good outcome from the ecology point of view could be stymied by both of these criteria at the moment. Right, at the risk of talking too much, that's generally where what I was talking about falls.
Thank you, Dr. Pease.
Thanks, Dr. Casey. I have a few questions here for you. Just to start off, I'm just curious. You were talking about, I suppose, the cream of the crop protected in the dock estate, and I'm just curious. I mean, I suppose a lot of my work's been in Canterbury, where the dock estate generally is the higher elevated areas. And the lowland ecosystems, which are much more productive for economic social uses, aren't at all well represented. Is that the case here in Otago as well? I mean,
not to the same degree, but everywhere in New Zealand, which had the lower, easier, good soils with fertility, are put to work. So wherever you go, whether it be the Manawatu Plains, where it's the Thames Plains, wherever you go, that is the pattern in New Zealand. Anything associated with a river and a sea for access was early developed, and those were the better soils to grow things on. And that's the case, but it's nowhere near as bad as Canterbury.
Yeah, but being that I'm assuming that there are some examples of some ecosystem types that aren't well represented or or aren't represented at all in the DOC estate. Would that be the case
That
here?
would be the case here too, yes. And if you look at the lens environment mapping, you will see that it is read through just about everything that is lowland, meaning just about everywhere in New Zealand that is coastal and or floodplain has an underrepresented Indigenous community presence, which is another matter about the whole rarity thing. So if you are on a lowland coastal plain or floodplain, the river, the chances of you ticking the rarity box if there is an Indigenous remnant present is, well, it's guaranteed. So everything will be SNA, irrespective of its condition, whether it's viable, etc.
And I think it was your figure 3, the lens map that you've got there. I did have a comment against that, where you've got the the areas that are, I think, the sort of pink and orange areas, I think, wasn't it?
Yeah.
Red and orange. And I suppose I had a comment that, but given that any last remnants in there, well, there's not many of them, but surely they would have an elevated value.
If you adhere to the fact that rarity makes you valuable, yes. One of the things is some of those pieces won't be viable without help. So you have to ask yourself, if it's a small fragment of a podocarp Hikatea forest on a river flame, and for some reason it hasn't been cleared and there's a farming going on, and maybe it's fenced, maybe it's not, but it will be full of weeds, maybe it's completely full of Tradescantia through it. We'll still tick it that it's significant. It meets a number of criteria, but its future is zero because it's not regenerating. There's no new Hikatea seedlings. The wandering dew is throughout it. Its diversity is low because it's been grazed in the past. We will see that as an unusual or rare piece of forestry that's left, but it has no viable future without management. So if we said that's significant and you must avoid it, we would retain it for a short time.
But is it better? I mean, I suppose you're sort of, one of the things that's coming across in your evidence is that you're really thinking that, in a lot of instances, such as the one you provide there, that offsetting is actually a good outcome there.
Yeah.
But surely there are other ways for those outcomes to be achieved as well.
Not many.
There are sort of methods in there, and I suppose funding for pest control and fencing and all those other sorts of things through, either through council or through other mechanisms as well. I mean, do you think that is better than an offsetting approach in terms of overall sort of, whether we're looking at net loss versus, no net loss versus net gain, where?
I think you have to have the suite of things. And in my 30 years of practicing, I've seen more gains come from an offsets than I have from voluntary programs, which can work, but often their funding falls short. Often the committee that's arranging them goes left instead of right in terms of what they're trying to achieve. Some are well guided, some are poorly guided. Sometimes local landowners do the best job of everybody in the absence of any guidance, and sometimes they don't do it well at all. But in my experience, the best outcomes come from regulated offset compliance monitoring.
I just have a few questions on your evidence. I think 6.2, and I'll just double check this because there may be something you've just covered off. Yeah, in paragraph 6.2, you talk about various mechanisms that have been in place since 2010. I'm just wondering if you could explain what you're referring to there. Yeah, 6.2.
I'm just catching up on where I was going.
Sorry, the right, this a while back. And I think it's in relation to so Indigenous land cover dropping quite significantly, and then sort of looks more maybe around sort of 2012 that decline slowed.
Yes. So looking at the New Zealand statistical data. The various mechanisms I was thinking of as firstly mechanisms in the RMA that came along that firstly started to value and identify these things. And then there were mechanisms that caused you to mitigate your effects where you didn't used to. And there were requirements to, it wasn't called offset then, but an extended mitigation, which was effectively the new offset, as well as a greater awareness in the landowners through more media and more recognition of the value of Indigenous biodiversity. And I think those things really started happening in the 80s and into the 90s. And the mechanisms were awareness and then the RMA bringing in effectively mitigation regimes.
Okay, I was just curious because I suppose the RMA came into effect in 1991, and when you look at that continuing steep decline since then, it sort of goes to show that perhaps it wasn't overly effective.
But it was, but it just took a lag time to get in, I think.
Yeah.
And I did, I was working all through that period.
Yeah,
And you see attitudes start to change.
I think attitudes, yeah.
Yeah, but that was partly because of the for all around all this new things, come in and recognizing value. I still remember when they brought the Forestry Act in, and I was out doing a P&A survey, and all night the chainsaws went to beat the act. But afterwards, things got better.
Yeah. I suppose one of the things that I'm finding through some of your evidence is there's a bit of conflict as to the extent of the issue and whether we have an issue or not. And I suppose, I look at figure 2, which doesn't paint Otago in a very good light.
Yeah. But keep in mind what the x-axis is. It's small.
Yeah.
It's a percent or two.
Yeah. Yeah. But I suppose it shows that we're still, yeah. There has been a lot of decline, I suppose. Yeah. In the following paragraph, you talk about the bar as what constitutes an SNA has been dropping over the last 10 years. And I suppose I wondered, is this partly due to pest, plants and animals getting more established and surrounding land use encroachment and those sorts of things, and possibly, the impacts of climate change that we're starting to see already? Is that meaning that the bar is going to potentially continue dropping as the examples that we've got get, I suppose, continue to decline?
I don't think so. I think what we're looking at here is a range of highly modified, ever smaller bits and pieces on private land. It's become the focus of this. And I think general awareness of Indigenous biodiversity has been growing over the last 10 years to the point where it might be that people don't necessarily understand it or what it is, but it's topical. And I think there has been a focus on the fear of loss, perhaps even guilt too, of Indigenous biodiversity. But one of the things I challenge you to remember is as something gets rare, its function and importance in the ecosystem diminishes. And as opposed to us valuing it as rare and thinking that's special, sometimes in terms of the environment, it's actually not special anymore because it's ceased to be important. So there's this thing playing off there in the real world, where as something gets rare, it's no longer needed in the environment. And if it became extinct tomorrow, the ecosystem would shrug and say, whatever. Whereas we go, oh my goodness. So there's some of that in some of what goes on through.
Yeah, and I get that in terms of ecosystem functioning. Yeah. And I suppose part of it, possibly too, I think, when we're talking about extent versus values as well, and that there is a sort of a distinction there.
But I will say, protecting a couple of spots of forest on a floodplain isn't going to return forest.
No.
So
no, it takes a lot more than that.
Yeah.
Yeah. One of the, I think in your section 7, a lot of the the focus seems to be on representativeness in there. And I was just interested in what, in your experience, what are the key criteria that often drive a site's classification as an SNA? Is it mostly rarity?
Yeah,
Given
so,
the number of, the increasing number of species we've got in the classifications.
that's right. Yeah, so rarity and context are often the things that are most often ticked.
Yeah.
But in ticking context, often it's, again, non-empirical. Oh, it's a buffer. And then if you were to say, well, a buffer to what? For why? And that's often not an easy answer to say. I don't personally tick ecological context very often because there are very poor records on use of corridors and need of corridors or buffering. But I do find that a lot of people, ecologists practice here, tick the ecological context box, and the rarity box is often ticked. And when we talk about the rarity, don't forget that also means the lens, land class, threat rarity.
Okay, thanks for that. Yeah, I think I have. Yeah, I was just in your paragraph 7.23. I was just wondering if you could elaborate on the, you refer in the last, or second to last sentence there about being overshadowed by a national cause. I was just interested in what you're actually kind of referring to there.
Well, yeah, so I guess what I'm saying is, and if you put species aside for the moment, because there is a national threat classification for species, and less so for habitat except for wetland, sometimes I see in some regional plans a focus on something that might be regionally quite common, but nationally uncommon. And so there's a drive to seek to protect what is common in that region to benefit the nation. That's all great, but should it be that way? I question.
Yeah, I've done some work on the West Coast, and I know they certainly have had that issue over there.
Yeah.
Yeah.
And so, you know, I raise that as a question. If it's a regional plan, should it not focus on regionally important aspects? And if that feature, whatever it is secure and protected and okay in the region, do you have a national driver there to make it still important?
Okay. I was just curious in relation to paragraph 7.37, where you talk about corridor functions, and you say they've really been proven as necessary or helpful for New Zealand Indigenous species. And I'm just thinking back to my sort of ecology papers at university and the like, where that was sort of one of the things that, I mean, this is going back a ways, but you know, that was sort of one of the key things that we were sort of taught about. And I suppose I was interested in whether that's because nobody's actually really looked at it.
And that's the problem. There's no published research that says, you know what, the Southland grass skink requires an indigenous vegetated shrubland to get from A to B.
Yeah.
In Australia, they've done those things. In North America, they've done those things. In Europe, they've done those things. And they talk mostly about mammals and sometimes about birds. But nobody in New Zealand has said, you know what, it absolutely is necessary that there be a joined piece of bush for this species of snail to get from there to there, even if they do, or this bird to fly from there to there.
And I suppose I'm thinking about, you know, if it's in Christchurch Banks Peninsula to get tui established, for example, where we don't have tui really. Well, there's some on the peninsula now that have been introduced, but and one of the issues being that there's not forest corridors for them to move around, so they haven't got food and they don't.
Well, there are bellbirds.
There are bellbirds.
And that's why they don't have food, because there are bellbirds.
Well, yeah, but I suppose I was just wondering, you're saying that it has really been proven as necessary or helpful, but is that just because there hasn't actually been any work? So it's so the contrary would also be true.
That's true. We just don't know.
Yeah. Yeah. I'm just checking here. Just looking at the joint witness statement and ecological context where you're suggesting it's deleted. And you have touched on this a little bit, but you're saying it's captured by multiple criteria, which you did cover this in your introduction as well. I think that might have been in relation to diversity. I mean, are there sort of examples where you think that the likes of, say, you know, diversity or context could be relevant, where some of those other criteria wouldn't kick in?
I don't think diversity ever is,
Right.
but under context, it is possible, yes. What I object to is that sometimes it's lazily ticked without really any evidence that it's required. So a buffer, for example. So where you have a feature and it's an SNA that has a surrounding of gorse and Manuka regeneration, and someone says, well, we need to include that as the buffer to the SNA because it stops wind blowing in or changes the hydrology or something. On occasions, that will be valid. On other occasions, it's unproven and it's probably not valid. If you chopped all the gorse away, the feature would carry on as per normal. And this is the problem I have with the context is that the evidence around the importance of the contextual feature is often not presented or not, it does not exist. But it's not enough to say, oh, that shrubbery surrounds that forest and therefore it's a buffer and therefore it must be significant in and of itself. I don't think that's how.
Yeah. You discuss around paragraph 2.25 around you raise a no net loss concept. Sorry, I'm just wondering how do you go about measuring whether there's net gain or no net loss, and how much kind of uncertainty is there within that?
On a site or at a region? Because
And I suppose I'm sort of thinking, say, if you've got a consent application, somebody's proposing offsetting, there may be, you know, such as we're looking at here, an objective that may say no net loss or there needs to be net gain. How do you go about evaluating that, I suppose?
that's quite a common thing to do these days. So you either run, and I don't like them, you either run a biodiversity offset model, but ostensibly what that is you measure the area and maybe the number of species and the area of different species and the proportions of species of the area you're affected. So you build a baseline. So you know that there was 2.1 hectares of that and 0.3 of a hectare of that, and it had, you know, a full complement of species, and that was 60. Say, so you've quantified it, and then you look at your offset and you say, does it equate to that or more in the area when it's growing? Will it have those number of species or greater when it's finished? And you can track that through the years of monitoring, and you can plan that so it's twice the area or 3 times the area or whatever the multiplier is for lag and time, and you can physically measure the area that you've reproduced and the success of that in terms of health indices or the number of taxa that are present, or the processes that occur, or look, seeding is occurring and germination of young seeds are occurring. That process is working. So there are all sorts of ways you can measure the success of your habitat recreation, if that's what it is, or successful transplantation and sustaining of species where you see it's breeding.
So that's sort of what you talk about there is almost more, you'd be monitoring it as you go. To what extent can you have confidence at the time of a proposal being put forward?
Depends on what it is.
Right.
So there are lots of examples of successful creation of habitats of different sorts. What you don't know is generally the long-aged tall forest ones, for example. But after about 20 or 30 years, you can see if they're going to succeed. You have to remind yourselves, though, that they're always going to be vulnerable to weed and pests. So that's a long-term thing. But if you're going to build a wetland, you know within 3 years that you've succeeded or not.
Yeah, okay. In terms of forest, because that was another question I had here. Sorry, I'm nearly done. You talk in 10.30 about that you think the offset being achieved within the duration of the resource consent isn't appropriate. And you give an example there where the offset's targeting a mature forest habitat.
Yeah.
In those situations, I mean, what would you be referring to there? Like you're planting something from scratch,
Yeah.
or you're okay.
So you might have cleared, let's go back to the Kahikatea example. You might have knocked that half hectare of Kahikatea over, and to compensate for that, you're planting 5 hectares of podocarp lowland forest, and you probably have taken it from a paddock because there won't be any others there, and you want to get a gain, not an improvement, because that's the other important thing about offsets is no loss of extent means you have to actually actively create more that didn't exist to balance the loss. You'd plant it, and you would have to then manage it through probably 10 or 15 years.
I suppose one of the things that I'm struggling with some of the stuff is, particularly, when you've got a forest like that, you're taking a ecosystem with all its soil associations, all its fungi, all its invertebrates and microbes and everything else that's in there, and you're planting something which doesn't have
All that stuff.
any of those associations or any of that stuff. How can you say that one is offsetting the other? I mean, maybe in 200 years it might, or 100 years or 50 years, depending what it is. But how can you have confidence that what you're planting, I mean, I can plant Kahikatea in my garden, but I can't compare it to a Kahikatea forest with all those associations. How do you deal with that?
2 things there.
Yeah.
Firstly, if you're knocking down a Kahikatea forest piece on a lowland flat river terrace, chances are it's not very representative. Chances are it's highly modified. Chances are it doesn't have all of those things. But put that one aside. If it is, you can, and there are now methods to inoculate with mycorrhizae, take some of the soil and duff across. That's quite often done now. So you want to inoculate soil with the mycorrhizae and the invertebrate soil species across. You can take woody debris, and so when you fell the thing, you have to salvage the lizards anyway, and you can salvage the material and relay that into your habitat. So there are ways of helping bring some of those smaller things across that enhance your ability to reproduce what it was.
I suppose, would they be able to survive without mature trees there?
Some can and some can't.
Right.
So there are growing examples of success. A lot of that success does depend on whether there are donor colonies in the wider landscape that can come to your area. But you can assist some of the processes, especially around the soil.
I suppose the only other sort of question I had, there were a few points in your evidence where your view changed through the joint witness statement. I was just interested in, were there discussions that occurred during the caucusing that led to some changes of position, or, I mean, I know you can't really.
Yeah, well, yes, I mean, we had a good discussion.
Yeah.
I was surprised at how good that discussion was.
Well, that's good. I mean, it's obvious from this. So, thank you to who put effort into that.
There were good heads in the room.
Useful.
But some of those things in my evidence, I was willing to compromise on. And some of them I was willing to give away.
Yeah.
And so those were the changes.
Yeah. No, thank you. Thank you very much.
Yeah, thank you. Bianca's probably traversed quite a bit of the ground where I was heading, but I just want to head back to that full record that Otago supposedly has. When we look at the various statistics and graph, and to be fair, I probably sit in your camp, but I have noticed that decline over the last 10 to 15 years. When you look at figure 1,
yeah,
my thoughts of that was, well, 95, not long after the RMA came in, not a lot of district plans were developed then. My experience of that was a lot of people go, right, we're going to cut down all that tussock shrubland more so than larger forests, and the rules kicked in there. But in terms of Otago's poor statistics, where's the starting point for that? Because when I look at figure 2, you've got the ones that have grown over that period, you know, Wellington, Nelson, Auckland, well, pretty urban environments. Otago, and I look at the figure 3, the lens map. If you actually look at that, the objective Y, there's a lot of Otago's
Still there.
it's a lot of Indigenous biodiversity.
Yep.
When I look at the red and orange areas, and this is focused some of the questions to Dr. Lloyd. Those red and orange areas are the farming area, and originally that was forest pre-human. If we're taking that starting point, that's now probably what's in there. Indigenous species from tussocks that we have more.
Yeah, more of than we had at the start. Yep.
So how do we deal with that in a rarity context when they're not actually rare and they weren't actually here pre-human?
Well, I think we don't call them rare.
But they're listed as a priority.
Exactly, and therein lies the problem. And so the discussion I had with Dr. Lloyd and I is that, well, present evidence. and so his form, I believe, without speaking for him, and I agree with it, is that at some point the ecologist must present the evidence that says it's in opposition to these plans and these things. And that just creates stress, I realise that, but there's no rule that covers everything all the time. So there will be times when one of us will present evidence that doesn't fly in line with these things, or the threat classification or whatever. And it's just up to us to present that evidence, I guess.
Yeah,
And put stress upon the planner.
that threat classification and the rarity criterion. You know, I'm actually looking at
Well, naturally uncommon is also problematic because sometimes things are naturally uncommon and perfectly well protected.
Yeah.
So why does that make them special?
With the rarity, you've touched on it. The criteria 2 there, it's former extent nationally, regionally within a relevant land environment, which is the lens category, ecological district. How do they relate?
Well, so I've said it's important, and most ecologists work at an ED and ecological district level, and there are a number of those features in any region. And I think from a regional plan point of view, they have to have an ED and a regional focus. But often where you must be using national threat classification procedures. So for a species, it doesn't really work, but for habitat types, that's where it's important to use an ED, the ecological district, and a regional basis, not a national one. And what it is it says you can calculate the approximate habitat type representation in an ED. And then you can say, well, is there still 20% of that left in that ED? Yes, no, yes, well, that's fine, carry on, no, and that gets that tick. Or at a regional basis, we would expect, 500,000 hectares of that stuff. Is there, 100,000 of it left, 20%? Yes, no, but you wouldn't go any further than that. Does that make sense?
Yeah, so in your view, that 2 should probably just be regionally or within the ecological district.
Which is what I put on the side there, I think.
Yeah.
Yeah.
Yeah. In Otago, so how do you determine an ecological district? Because I've seen some of those reports that I know they're mapped, but I've been in quite a few of them and they are quite similar, some of them.
Yeah, so it was done by, and I'm going to be cheeky here, but it was done by 3 or 4 people, around a kitchen table at night, thinking about what the environmental drivers and terrain and topography was that made areas special. And the line was drawn. There's not hard empirical drivers and evidence of that. And those lines have stuck since that time.
So if you've got one ecological district, it's got, for example, say it's got 50% Indigenous vegetation covered, but there's a very similar ecological district that only has 10%. What would be the importance of the one with the 10%?
Well, not much, you would say.
Yeah.
But
so you apply the regional context.
You can apply the regional context. But if you were working in that 10% ED, you would catch rarity.
Yeah. Well, that's where I'm trying to get to.
Yeah.
It's like, where's a sensible demarcation?
Well, I guess what you'd be saying is that ecological district in and of itself has now got underrepresented the types it should have, even though it's well represented in the next door one.
If that's a human construct, how you identify those ecological
Yes, it
districts.
is. Yes, it is.
Yeah.
Mhm.
In your, it's 9.1 in your Manawa, but probably maybe 10.1 in your, but it's around the effects hierarchy and you're talking there about the linear hierarchy and what you've been discussing basically that it could limit options. And that quite often are a mix of avoid, remedy, mitigate.
Yeah.
How does this effects hierarchy not allow you to do that? With the way I read, I thought you avoid that bit, but over there you might mitigate by doing this, and this bit over here that you're going to lose, you may offset.
Yes, I guess the difference is that you don't have to avoid, if you have an SNA and you're directed to avoid that SNA, you can't just avoid a bit of it and maybe manage another bit of it in a different way. So I guess that's what I was trying to drive at is historically, you might avoid the most valuable bit of the SNA and still hit the SNA. And then you would manage that through remedy for this bit over here because you didn't need that bit for what you were doing. And then you might go for an offset for a portion of it.
Yeah.
So I'm really thinking about inside of the SNA. If you were to,
Okay. Yeah. I was interested in your example actually around the avoidance where in your recent example, there is a submission, I think, from the New Zealand Infrastructure Commission suggesting that the RPS should recognise the ability to actually provide for additional development rights. If in that case you were talking about, well, yeah, we'll let the subdivider one over here, but rather than avoid that SNA, you're going to get in there and do all those things that the council officer wanted you to do. I don't think that was accepted. But following your logic, that should be in there. Those
it should be.
options should be
Yeah.
made available.
A bit like Ms. Hunt said, don't close the door too early. Because one of the best ways to get outcomes is to cause people who need to do these things and spend the money doing it.
Yeah.
Slashing up would be in there.
I think Link has sort of covered this. I had lots of questions over your marked areas, but probably the only one on the criteria APP2. Anyone was in the distinctiveness that you recommended of restricted occurrence being taken out, but you've agreed to let that in. Your logic was reasonably sound around that. I wondered why you've changed your position on that.
In the distinctiveness,
Yes, and the criteria, well, which is,
Indigenous species and their distribution limits
yeah,
are still one out. So if you drift over to the right there, it says an area that supports, remove that please, Mike Thorsman and myself.
I'm looking at the wrong one.
No, I think you look, I think you are looking, because I was going to raise the same issue with you. It's down number 3.
Oh, number 3, indigenous
Yeah,
vegetation,
distinctiveness, yeah.
In distinctiveness.
which we've removed.
You've removed the word distinctive, which was, as you see, that's already, that's the criteria is about being distinctive. But you recommended removing of restricted occurrence.
That's right.
I all agree with that, so you've agreed to now that's.
I have, exactly. So, but that's on the assumption that we remove the diversity component. And I feel that that then fulfills the loss of diverse habitats, gradients and things. Indigenous vegetation of an association of indigenous species that is restricted occurrence has developed as a result of unusual environmental factors and combinations, I believe, can therefore account for when you take diversity out and it's about in the context of similar areas and similar ecosystem types, or has changes in species composition reflecting the existence of diverse natural features. I believe it replaces that.
I was wondering about your concern around diversity and whether you could keep it in, but have a, with a qualifier that can only be there if there's one or two other associated
Yeah. Well,
criteria.
So I prefer it the way I put it, obviously, but I'd like to lose diversity and have the distinctiveness carry that.
Yeah.
And that you would still need to handle reality.
Yeah, I think the ink has covered most of it, so I can't read my writing. So we'll just leave it here. Thank you. There may be something more occurs tomorrow.
And I'm
Yeah.
here tomorrow.
Thank you.
Kia ora. I'm going to read back to you paragraph 10.37 in your evidence. It reads, in terms of subclause 3E, it is also unclear what consideration of Mātauranga Māori means. This is not usually an aspect of most ecologists' training and will require a specific set of skills and understanding, usually from local mana whenua. I recommend this subclause is clarified to make clear what is required. I think I know what you're saying there. Would you like to elaborate a bit more?
Sure. I'm not qualified to do these things, to make these assessments, to make judgment calls on Mātauranga Māori. Although I'm asked to in some of these things. We have a criterion, the significance criterion in Wellington that says, last one, that tangata whenua, the cultural values are adhered to, and I can't do that. And I find that the same things are here, is that there needs to be an additional skill set or whatever that comes to this, if that is to be there.
Okay.
But most ecologists are not.
That's how I understand it, because I don't hear any of it so far. But I do want to know whether, well, are you aware of anyone who might have put on a real Mātauranga Māori hat or tikanga Māori hat and looked at these same issues that you're discussing here and perhaps even come up with something quite different?
No, but I do know Craig Pauling, who has established some cultural monitoring regimes for fresh water and stuff, so that the flavour of that is building. But from the terrestrial side of things, I don't encounter and haven't met anybody who built or does these things. And I interact with a few, and I go through a few hui, and we discuss these things.
Yeah.
But there's no formed procedural way yet.
Yeah, in my experience, for the most part, most Māori scientists, like ecologists, if there are any, are kind of reacting
Yes. So we have a
to
couple
what
of
the system is saying to them is what's right, I guess, in a way.
Yeah. We have a couple.
I was curious to see whether anyone had sort of gone out on a limb and said, hang on, let's put that all to one side. Let's get a clean sheet of paper and so let's have another look at it from this point of view. And I'm thinking in particular of ecology.
It's in the wind. As I said, I've been having discussions with a number of people, and they all nod and say yes, but nothing happens.
Yeah.
Mm.
Yeah, that's what the issue was saying here, which is why I read a bit. Because it gets really to the crux of the issue I raised right at the very beginning. You know, where does this other world view fit in? Not more than where, but how? Is
And
there a real way of?
it is different too from the science-based thing.
Yeah.
And because I think it comes with, it's not a conservation-focused thing.
Yes, it is quite different in lots of ways. Which is the point I raised earlier on about, mahinga kai is a place as well as a way of doing things.
Yes.
So there is a mindset difference that I think the overall system still struggles with.
And I see it as a resource management
Yeah.
thing, not a resource preservation.
So do I, yeah. I'm glad you see that, because kind of what I was looking for. How do you manage your way through that? You know, in a sense, because I think most people will accept there is a difference, but they don't know what the difference is. Or if they think they know, they're too scared to actually get in there and talk about it. Because, you know, the minute you say something silly, people jump on you and tell you you're silly. But it's not silly.
No, and you need to go on, somebody needs to go on a limb.
Yeah. You have to sort of go out on a limb in some way. Yeah. Okay, good. Thanks very much, Dr. Kesey.
Yeah, just following on from that question, the thrust of what what I took to be your concern in that paragraph was that a client is going to be looking to you as the ecological expert to say that you have developed the offset in accordance with Appendix 3.
Yeah.
And Appendix 3 then has the clause biodiversity offsetting proposed in the application for resource consent. I emphasise strangely the plan change appears there, or notice of requirement must address all matters in that Appendix 3.2 and then include application of Mātauraka Māori.
Yeah. So I'm either going to have to go out and find somebody who can do that, which is not easy, but I can't do it. And most ecologists, I would suggest you almost no ecologist is qualified to do that currently.
I've had your evidence very easy to follow, thank you. So I don't have a whole lot of questions, but just at paragraph, so I'm really just going to be asked for clarification of some things. At paragraph 6.7, right in the last line, sorry, this is unaware evidence, so I'm not sure of the number of the contact evidence. The meaning of the last line, or should not consider the quality / intactness of a feature. What are you meaning by intactness? Are you meaning rarity or
Intactness? No, I mean it's cohesiveness. It's solid structure and appropriate structure of the 3 dimensions. It's,
several assemblages?
early successional ones that you go from grasslands to shrublands to forest.
Right.
That's the serial steps.
Oh, I see. Okay. You dealt with with Commissioner Cubitt in relation to the difference in relation to the joint witness statement on the restricted occurrence. And if I understood and noted your response carefully, you were basically saying that your acceptance of that was on the basis that you'd made the point at the previous page, diversity
Exactly.
be deleted. Right.
Yeah.
Just going down a couple of paragraphs again, the unaware evidence 6.37. And again, you verbally today described the lack of hard evidence, empirical evidence in terms of corridor function, and recommended that in that paragraph or the next, I got the feeling that you were basically saying that you didn't accept that as being necessary, but I noticed in the joint witness statement it seems to have survived.
On context, and delete as redundant as captured by multiple criteria. So I'd like the whole thing deleted still.
So just take me to that again.
I'm sorry. You're right. That's 4.
Looking at
Sorry,
on
you're
page
quite right.
9,
4. Yes,
on page 9,
got you.
that an area that has important connectivity value allowing dispersal of indigenous flora, etc. All agree.
Yeah.
But then there is no.
There is a note. Yes.
Yeah.
So I mean, the concept in and of itself is right, but the evidence and proof of those things occurring is poor. So I in the end, after much discussion, I was in agreement that you shouldn't just remove them, but as my evidence says, where is the empirical evidence for that? And what worries me is it becomes very easy to tick that box because you saw a lizard and you went to yourself, oh, that only connected to there, so you can't take a swathe out of that that removes it. You would have to have evidence that the lizard is using that space, before you said it was ecologically important contextual corridor. But I think the premise of that is good, it's valuable.
Just figure 3, the lens map, does that happen to be of the ecological district?
That's of the region.
That's of the region.
On my evidence, yes.
Right. The examples that you gave, again, none of our evidence, but paragraph 8.4, that the class Pika Expressway, is it the transmission gully?
No, it's the next one north.
Oh, I see.
It's the first one that got finished.
Sorry.
It's the first one that got built.
Oh, right. Just in terms of those massive developments up in the North Island, which incidentally it meant in Marlborough, you can't get native plants in the nursery because they've all gone north.
Yes.
So, in terms of those, I mean, they look wonderful and they're huge as you drive around in the North Island. But I'm not sure, it's probably too early to say, but if they planted podocarps at all in those, or if they stuck to lower level species?
The Macassar peka has stuck to wetland and lower level in the main. The transmission gully has an enrichment planting which should occur now, and that's where all the podocarps are going in.
Right.
So all of the early cereal communities are in and are establishing, and some of them established quite successfully. And now is the season, so 3 years after, on the 4th and 5th year, there is enrichment.
Oh, I see.
To be so the cereal are supporting those.
Right.
In the Macassar peka, which was more advanced, those podocarps have gone in where they're required, mostly in the wetland areas and mostly swamp miry and kekatea, and they're growing.
And so if you have knowledge of the area in the Bay of Plenty from Tauranga through to Whakatane and those plantings there, again, will they have a podocarp base as well? Or?
I don't think they do, but I don't know for certain.
Right. In terms of the mycorrhizal aspect to the soils, what do they do on those big?
The fungi basically enable the plants and the roots to gain more nutrients and compete with other things.
Yeah, look, sorry, I probably didn't express that well. What I was meaning was, what the Kotahi do in terms of trying to get that result? How do they get that actual result?
So there are 2 ways that you might end up with mycorrhizae in your soils on your replanting. One is that the nursery people, when they collect the seed, they also inoculate the seed that germinates with material. Or the other thing is you actively transport soil and mulch from one side to another, in which there will be hyphae of the fungi, and basically lay that on the soils to inoculate your planted material.
So the thrust of what I read from your evidence is that you say, look, in comparison with what would have previously been, if you take that Bay of Plenty example, probably cubifruit areas or whatever, or down in this area, small type proposal, tussock grasslands. If you look at the Hurufenua situation, it might have been some sort of cropping, I don't know. But in essence, as I read your evidence, you're saying, look, the result of these major offsets or compensation, whichever way you look at them, has been the development of really very extensive areas of Indigenous biodiversity, which would not have been achieved had you said avoid.
That's right.
Okay.
Absolutely, that's exactly it.
You're a bit, again, Manawa Evans, paragraph 9.26, you're a bit askance about the requirement for offset models.
Yes.
What on earth is an offset model?
Forest Judge, and you'll put it in a black box. An offset model basically is a way of enumerating the values that exist on site. And so that might be the hectareage of each community type. It might be the number of species. It might be the number of species and the ages of the podocarp trees. Any metric that suggests or enumerates the value. And that is your first part of the offset. This is what you're losing. And then the next part of the model, which is basically a spreadsheet calculation system, says, what are you going to do to offset that? And so you will say, I am planting, 27 species, these types, this number of them, they will make up an area of X. It will take 7 years. There is a discount factor, a percentage for the amount of time that it takes to get to where you think it's going to be. So that might be a multiplier that doubles the area you need. You put all of these things into the other side of the box and until you come out with a net zero or gain.
Right.
And so it basically allows you to drive how much you need to do and what type. It is prone to what you put in, you get out. And you can manipulate it, to be honest. And you can choose which variables you want to address, although there are some reasonably standard ones, and the hectareage is one of those standard ones. I'm going to remove 5,000 square meters of old podocarp, and I'm going to plant, and you start off, say, I'm going to plant 5 hectares of young podocarp, and it will say, not yet. And you might change the area until you get a balance, and you might end up planting 20 hectares to balance off the 5 hectares that I said, because of difference in age and size. So it's a calculating system that allows you to do that.
So in terms of consent conditions, it's not so much trying to set a standard of achieving something by the end of the duration of the consent. It's a matter really, isn't it, of trying to have far more complex monitoring required through and having to meet particular targets as you're going through.
It is, but you need to set it up so it will achieve, the quantum you need. But then it is absolutely about managing the process to get there, because that's normally where things fall down. I've seen a number of projects start off and it looks very good, and by year 4, maintenance had fallen away, and the weeds were invading. Some of the plants had died. Somebody had pushed some rubbish in, and it started to not look as though it was going to achieve because there was no compliance.
Final question really for you. In terms of the threatened species process, how regularly is that reviewed? Who does it? And how do species get on the list? And how do they get off it? And if you use the Porivitus, for example, I mean, as I understand it, 10 years ago, probably, I don't know how many years ago, regarded as extremely rare, and now everybody realises they're everywhere. So
the lists are made up of expert panels in their field nationally. They come together and they access whatever data is available from whatever surveys and their expert opinion, and they make decisions about where the classification should be, and they follow a set of rules or guidances. But ostensibly, it depends on how much information is known about the distribution and the populations of each of those taxa that they're thinking about. And I'm going to move to a long fin eel because that's an easy one. So long fin eel are caught in a number of surveys by a number of people all around New Zealand, and that data all, in theory, gets added to the NIWA database, right? So there is a running record every year based on surveys all around the country by all sorts of people about how many long fin eel are being surveyed, and then estimates by the panel are made about whether those populations are going up, going down, or what. And from there and their sets of guides, they determine which slot classification falls into: at risk declining, at risk relic, not threatened, nationally critical, wherever. And it's in that way that each year's data comes in, and they might review it in 3 years or 4 years or 5 years. I'm not sure what the formal period is, and it changes for the different species. So fish happen more often than plants. But they will then test them again with the new data. The big problem about that is there's a whole lot of data gaps. I mean, if you're talking about invertebrates like the pORPS, the number of people who survey for pORPS in New Zealand every year is tiny. So the data that you've got to make choices on is really circumspect, and they have to make opinions. So some species are better represented correctly in the classification than others. And on occasions, and I shouldn't say this, but I know that some species haven't fallen off the list for political reasons, not data reasons. So that happens. But basically, that's the system.
Thank you very much, Dr. Keating. Very interesting evidence. Thank you. That's it for content.
That's it. That's us.
Thank you.
I'll be back shortly, yeah.
Thank you to everybody, including Oceania, that our experience has been that the first questioning processes tend to be long, and we do speed up, and we will get you done.
Yeah, I am anxious because I have to be in court in Christchurch tomorrow. I can't return tomorrow.
Yeah, no, we'll get you done today. All right.
What time are we resuming?
Oh, sorry. Yeah, look, I should have said we'll be back at 2. Right, tomorrow at
2 o'clock.
Starker. By the way.
Kia ora koutou. I think Maria Bartlett is joining us online. Joining us live from Te Aomarama. So what I'll do, I'll just let Kate to check that she's there. I'll read through my summary and then Maria, I don't think is presenting summary, but she'll just talk to her points. Cultural evidence has highlighted the enduring relationship of kaitahu with tile. Responsibility associated with being kaitiaki to ensure that Maui is protected and restored, and the importance of mihi kai is a cornerstone of kaitahu culture. This deep and complex relationship of kaitahu to tile brings RMA section 6C, 7A and 8 into play, in addition to section 6C with its focus on significant biodiversity. The treaty partnership is also at the centre of Te Mana o Te Tao, the Aotearoa New Zealand Biodiversity Strategy 2020, which seeks that mana whenua will be better able to practice Rakatira and kaitiaki responsibilities. And particularly in drafting my evidence, I've had regard to Te Mana o Te Tao as a guiding document. The planning evidence of Sandra McIntyre emphasised that Section 6C promotes the decision-making role for mana whenua and the enabling of cultural practices such as mihi kai. In terms of kaitiaki taka, Section 42A changes to Eco 03 and Eco P1 clarify the inherited duty of mana whenua to exercise kaitiaki taka. Absent any notified method on kaitahu involvement in biodiversity management and in response to an invitation from the Section 42A author, I've recommended a new method for kaitiaki taka based on similar methods in the and coastal chapters, but also responding to the recognition of the mana whenua role, both in Te Mana o Te Tao and the draft NPSIB. And in the live stream, I heard the Section 42A author accepting that method, which we appreciate a lot. In terms of mihi kai, amendments to Eco P4, Method 4, 1A and Method 5, clauses 2 and 3 appropriately recognise and provide for kaitahu mihi kai practices. While at a policy level, mihi kai is managed under Eco P6, lack of specific recognition within this policy risks too narrow an interpretation of adverse effects in relation to mihi kai, and promoting a new clause to address this. In terms of Tauka, which has had some discussion, I believe, this morning, I support the Section 42A amendments for Tauka species and ecosystems. Despite the non-gazettal of the NPSIB with its provisions specific to Tauka, I consider the amended eco provisions provide an appropriate pathway for management of Tauka, also providing for implementation of Te Mana o Te Tao. In terms of the Maori land, the need for an enabling approach to Maori land has been discussed at the mana whenua hearing, also at the coastal hearing. The draft NPSIB signals the need for an alternative management approach to biodiversity management on Maori land. My evidence-in-chief recommended development of alternative provisions, but consistent with approaches sought in other chapters by planning witnesses like Kaitahu, I consider that a new clause should be added to Eco P6 or in the entire new policy added that provides a framework for these alternative management approaches. And I'm suggesting some wording there which is very much aligned with wording that's been promoted by Kaitahu and other parts of this hearing. And then in terms of integration and clarity, I'm just supporting Section 42A amendments to Eco P7. Two further amendments sought for clarity, and then recommending further amendments to clarify the titles of Eco P4 and P5 to highlight that these encompass Tauka as well as significant biodiversity, and to clarify in Eco P10 that is land-based effects on coastal biodiversity and ecosystems under consideration. So yeah, in short and in summary, I guess we're very much behind where the provisions have got to following Section 42A consideration and supplementary evidence, just promoting a couple of further amendments. Happy to take questions.
Thank you, Mr. Parker.
Yeah, thanks. And this may be better directed to Maria, but I'm not sure if she's absent.
She's not. She was about to join. She's confirmed that she was about to join.
Yeah. I mean, I suppose my question was more, I mean, she provided information around Kānuka and Mānuka in an appendix. And I was just interested in how, in terms of Eco P2, identifying and mapping Indigenous species and ecosystems that are tauka. How, I mean, I'm just interested in how you go about that and to what extent, you know, how many species are likely to involved areas. We don't really have any information on that today.
Yeah, so I can speak to that, I think, and then Maria can beg to differ if she wishes. Because I listened to the live stream for the LRC presentation and I was present for the later questioning on energy. So I know there was some discussion around Taka. And Commissioner Kirikiri sort of asked the question, what is Taka? And then Commissioner Kiva followed up with some observations around the prevalence of Mānuka Kānuka across Otago. So I think for me, and I'm not an expert on Taka, obviously, but the starting point and the mana whenua values that I've set out within this proposed RPS is that all living things, in essence, are Taka to Kaitahu.
Yeah, that was one where I was sort of seeing a little bit of tension, I suppose, between, you know, are we talking about all living things here as being tau, and potentially that's the case versus is it more mahinga kai and, you know, valuable materials, medicines, you know, those sorts of more functional species.
So to me, this seems analogous to maintenance of biodiversity from the get-go requirements under RMA. But that doesn't mean that necessarily you have protective provisions relating to all Indigenous biodiversity. It means you go through a process to identify what is significant and how that should be managed. So I think with Taka, it's to some degrees, even though there have been Taka species listed in the Ngāi Tahu Claims Act since 1998, it still seems like it's the start of a journey in terms of identification and management of Taka. And just as an aside, that isn't the be-all and end-all. I just want to emphasise that list isn't the be-all and end-all of Taka. I understand there were some limits placed on how many species could be identified within that piece of legislation. So I think it's just very much a starting point. But to get to your question, I think the MPS, you know, the mythical MPSIB is instructive because it talks about, I mean, it gives a lot of prominence to Taka mapping, identification, management, but it does talk about identified Taka. It doesn't, to me, suggest that management approach is going to be brought in that covers everything that may at some level be considered Taka species or Taka habitat. And I think the provisions that we have here within this document set up an approach whereby Kaitahu, working with the regional council, working with subsidiary, well, with other authorities, sorry, can go through that process of identification, mapping of those species and habitats that are of greatest concern or greatest value, and management of those accordingly. So that's set out under Eco M3. Is that answering your question?
Yeah, I mean, I suppose it just seems to be the question mark as to, you know, what that mapping could end up looking like, I suppose. Yeah.
Which is, I guess, a similar question that you might ask about the SNAs, which people have raised about the SNAs and the breadth of the criteria and whether you're going to capture all Indigenous biodiversity potentially. So, I mean, similar question.
Okay, thank you.
Yeah, thank you. Just following on from that, Mr. Barkett, and wasn't until Commissioner Kirikiri raised the issue is when I look at Eco Policy P3, So 1A is talking about Indigenous biodiversity. 2 is about the te aika. So there's a section 6C versus section 6E sort of issue there, and they both not qualified, but slightly differently worded. So section 6C is probably more as protection, whereas if you look at E, it's about maintaining that relationship. And I would have thought, and Bianca touched on, like Teaka, probably functional value. So then Mahakakai, etc. That's stuff that's used. So you're trying to preserve stuff so it can be used. Isn't there a bit of a conflict in how this is set up, that you're preserving it, keeping it, and identifying it so it can be used, but then the policies are actually saying you're not allowed to use it because you can't avoid adverse effects on it? Or is that adverse? It's not an adverse effect if we are using it for that purpose. We're just trying to get my head around how that works.
Yeah, just to answer that latter point, I think that's why I'm promoting that clause of policy P6 around Mahakakai. But going back to the start of your question, I think in this policy P3 1B, you've got lots of criteria and target values, and I think those values are not just protective in the sense of sustainability, not protective in the sense of locking it up and not interacting with the world or using it, but that those values do include use, as well as sustainable husbandry, if you like, for lack of a better word, of the resource. And I think it's also important to realise that not all taika species will be Mahakakai species. They might be local species, markers of seasonal change or indicators of just time to start certain practices or whatever they're not all Mahakakai species, taika species.
Guess the concern was raised in the evidence around Kanuka and Manuka not being identified. It's significant, and you're probably like me, we've probably walked a lot of the hills in Otago, and there's a lot of that stuff around. And it's just the impact of how that's managed, I guess, if that was.
Well, I can sort of respond, but it would be in a speculative way, and that it's not an area I'm expert in, but Manuka Kanuka had a lot of uses, a huge variety from rongoa through to direct use for Mahakakai type practices. And it may be that there's certain areas of significant in terms of gathering or use of those species, and they're in proximity to something that Commissioner Kurikuri talked to about being a place as well as a practice. There may be those particular places that are highly significant where Manuka Kanuka were gathered and used, rather than saying wholesale across the region, we're going to regard Manuka Kanuka as a taika species and map every instance of it and try and protect it.
I guess
again, that's me speculating.
It kind of brings in a different element, because we understand private land protection because of these values, but this is slightly different because of protected, so it can be used, but doesn't enable use because of private land. Dr. Lloyd suggested, I think he suggested that it's very easy to propagate. So is Kaiwan, you probably can't answer this either, but I guess Kaitaga, if it was important, are they propagating it and planting it on the properties now?
I don't know. I can't answer that. I can answer about other species that not. I just don't know.
The only real question I had around your evidence, Chief, was there's a bit of debate around where we start point. And in your paragraph, in terms of assessing impact, your paragraph 97 talk about Edward Allison's evidence, the degradation of Mahakakai habitat since European settlement. Well, now the ecological experts are saying, or in their joint witness statement, we have agreed it should be pre-human. that sort of opens us up a bit because a lot of what was pre-human isn't there anymore. How do you view that? It's not there because it's tussock land, etc. So is there an issue there from your perspective about where that start point is?
I think from the perspective of Kaitahu, the starting point is around Mahukai and trying to restore a resource that's been severely degraded. And I guess you can go back to whatever starting point you like in that respect, but I think that's the lens with which they will be looking at this sort of alienation of from, for various reasons, from what was once a highly productive Mahukai resource, and trying to restore that.
Yeah, effectively they're saying, well, we can't go probably back to pre-human because certain areas are just gone. Yeah, I guess it doesn't matter in that context. If you're focusing on Mahukai, it's what's happening now.
Yeah, and I would imagine the starting point would be looking at for that sort of 1840s to the 1880s type period where the sales went through and then things happened after that in terms of drainage and wetlands and the like that weren't anticipated.
So it's probably more related to the coastal fringe.
No, inland as well.
Yeah, pre-human's an interesting concept because Central Otago used to be a lake a few million years ago. So.
Yeah, that's right. That's right. We did.
Okay, thank you for that.
I'm going to start with the word Māori, which is, you referred to it in section 86 of your original submission. The protection and restoration of Māori is a key part of the broad ecosystem and indigenous biodiversity. But it's not necessarily something that the system embraces in quite the same way as tikanga does, I guess is what I'm trying to get at. But it does encapsulate all those things that I think everybody's trying to achieve, which is the health of the environment. And that's what Māori is, it's the health of the environment. But and there's been a dichotomy of thought, I guess, around using the words protection and restoration, as opposed to maybe sustainability of Māori or the health of the Māori, of the natural environment, because it comes back ultimately to another point you make in that same paragraph around the ngaitahu or the mana whenua relationship being encapsulated in whakapapa, which is associated with rangatiratanga and kaitiakitanga. Now, do you see those things being better woven into the RPS than they are at the moment? I mean, I think that's what you're trying to get at, but how do you see that actually operating?
Yeah, that's interesting because we had this discussion a little bit at the coastal chapter where we were promoting that objective specific to Māori of the coastal environment, and Māori doesn't feature in the objectives of this chapter, and perhaps it should. Just looking at tomorrow the tile, it's outcome one, priority one is the Māori of ecosystems is thriving. So it's right up on the top of that particular document. I think we can't undo what we've submitted, or expand what we've submitted on, but I think, if we looked at it again, perhaps we would be promoting more of a Māori centric approach to management of biodiversity, as well as those other areas like freshwater and coastal that we have supported on. I think for Ngāi Tahu, and it's probably no surprise to you, protection in relation to biodiversity is a fraught concept. The idea of a highly protective approach. Because it,
I just wonder whether we're underdoing it.
potentially.
I mean, my mind tells me we're sort of undercooking it, you know. There needs to be more sort of integration, or whatever the principle is, or the thing is around Māori and the general health of because I don't know if you were here earlier this morning, and I raised the issue around Mahinga Kai with Ms. Hardiman over here, you know, under Eco P6.
I was listening on the live stream.
You were? Oh, yeah, okay. So, yeah, so you understand what I'm sort of getting here. And I guess the other question was the one I raised with Dr. Keesing earlier on about tikanga Māori ecological front footing, like is how I'd like to put it. You know, that for the most part, mana whenua are having to respond. They're not exactly front footing a lot of this stuff. And I think, well, I don't know. I wonder what your views are, whether in the context of an RPS that we now have some, you know, ability to shape and renew, perhaps even, whether we aren't undercooking some of these aspects, and whether you think we maybe ought to be, I'm not saying bending over backwards, but need to be more enabling of things like Māori and Mahinga Kai as a real part of the URPS that we have here.
I think where it's landing is generally pretty good in terms of things like Mātou Raka and the incorporation of that. I think what's needed now is to build those partnerships. I offer the example of Brennan Flack's parents that was, you know, back in the opening days of this hearing, where he was able to talk firsthand of his experience of being in the Tāpiri area and his observations of the effects that were taking place in that area. Which absent, I mean, to give the IRC credit, they've expanded their science team in recent years, and they are out there doing more monitoring than they were doing in estuarine environments and the like. But there is generally quite a gap in the Western science around some of those ecosystem and habitats and environments. But people like Brennan have been doing it for decades and have that sort of that observational that much knowledge of what's going on. So it's really, we can put, I think the words are landing quite well in terms of incorporation of Mātou Raka as a method, but I think it's now about building and strengthening those partnerships, which are forming quite well already between councils and Kaitahu in terms of that.
And just to get back to the two words I was referring to early on, I always find it's hard to say. Rangatiratanga, rakatika, rakatirataka, and kaitiakitanga. Now, they are two words that are, let's accept they're reasonably well understood. But I still think there's a lot of misunderstanding about what that really means and how it could fit in, particularly Indigenous biodiversity. I mean, if I refer to the point I made earlier about a mahinga kai is about the resource itself as opposed to collecting the resource. Now, that's a key principle or element in tikanga mātauranga, you know, and whether again there was a better way that we could, I guess, harness or better recognize and better use, better utilize and better encompass that within this broader framework that we're working with.
I think my answer to that would be similar to the last answer. I think that the framework is being set up that recognises that kaitiaki role that does relate to Whakatiotaka and to whakapapa, but it's about how you give effect to that, how you implement that through, whether it's through decision-making processes, whether it's how potential kaitahu involvement in decision-making, or whether it's through monitoring methods or whatever. I think it's implementation to it is the key.
One of the issues that Edward talked about when he gave evidence was Indigenous species is valued as taoka. Right? And I've kind of been at pains to sometimes understand fully what that means or get a definition of what taoka means in the kaitahu context. Are you able to expand on that?
Well, that's got a good question, I guess. I guess it goes back to my early answer that in the kaitahu values part of this document, all living resources are regarded in some sense as taka, because there's a connection to taha more broadly and to particular species flying through that. But when it comes to what taoka means in terms of resource management and the process that we're in now, I think it necessarily will involve a narrowing of that conceptualization, and it'll involve targeting the things that I guess kaitahu seek to have the priority ascribed to, and that'll be mahukai species will be particularly, they'll at the forefront of that, but it may be other species as well that are not mahukai but are of value for other reasons.
Yeah, I mean, because Edward's point at the time was, I think what we require is a whole of management approach to deal with it. Which I think I understand.
And I guess that'll be, and I think as evidence he talks about the harbour a lot, and that may be where you aim your efforts at those particular ecosystems that are traditionally really, really important, but are also very degraded. So rather than saying here's this type of species and we're going to go across the region and try and protect, restore it, we're going to sort of, I think the answer will be to focus on some of those traditionally really important hukai and settlement areas and focus the efforts there.
Yeah. And the last point I just wanted to raise is the question of biodiversity on Māori land, which I think you referred to very, very briefly. Now, there's a whole lot of stuff sort of wrapped up in that, we often sort of struggle with. Because you then have to sort of define what biodiversity means on Māori land. And it may be quite different from what most other people might readily consider to be biodiversity. There'll be stuff on top of what the normal population would be regarding as biodiversity. But are there any other things that Ngāi Tahu would put forward as being sort of, I guess, intrinsically Ngāi Tahu around what's on their land in this context?
I think a different way of looking at landscape. This is probably getting into another hearing.
May well be, yeah.
Hearing topic. I'm not sure it features in our evidence in relation to the NFL topic, but a different way of looking at, say, what's an outstanding natural landscape or feature. I think that's one example. It's not directly related to biodiversity, but you did ask about things on top of biodiversity. Are there things on Māori land that Ngāi Tahu look at differently? Certainly think landscape is a really good example. Why is a landscape or an area that is viewed through, say, the eyes of a landscape architect as an outstanding natural landscape will be viewed through Ngāi Tahu eyes as, say, a cultural landscape of Waihi Tupuna, or an area that has traditionally been used for settlement and is no longer used, but there are aspirations to resettle and repopulate those areas. So that's, does that answer your?
Yeah, it does. It does. I said that was the last, but I do have one more question. In Australia, supplementary evidence in the list of amendments and things you were seeking out of the process, are there any hugely outstanding ones left in your mind?
In terms of the eco chapter. Check what I was asking. In terms of what's not been accepted by the section 42, because Ms. Hardman accepted the new method, which was one, and I think she's indicated that she's accepted Ms. Bartlett's recommendation. So it's probably just around that Eco P6 and trying to achieve some recognition of Mahi Kai when assessing adverse effects on biodiversity and making sure there's not unintended consequences through that effects management hierarchy.
Okay, thanks very much.
Thanks, just one issue really, and it arises out of that point that Dr. Keesing, I'm not sure if you heard him raising it, but in essence, in his evidence, he inquired how, or raised the issue of how anybody seeking to do offsetting could meet the effects management hierarchy, which requires that the assessment or the proposal rather is in accordance with Appendix 3 or Appendix 4, and those appendices have in them a requirement. I'll just read it to you. That in terms of offsets, the offset accords with Mātauraka Māori when taoko species are affected, and in terms of that's in terms of clause 2 to Appendix 3 and clause 3, the include application of Mātauraka Māori, and two issues really arise out of that. First is from a kaitahu viewpoint. Does make you wonder whether there's the old phrase, beware what you ask for, because what it will lead to is kaitahu being swamped with applications which can't progress unless there's been a response providing Mātauraka Māori response, which is only held by NICA. And will they be able to cope with that sort of pressure? There's not one question that arises. And the second is from the applicant, the resource consent applicant viewpoint, how do they, in a practical sense, identify who the person or persons might be who hold the relevant knowledge for them to be able to complete their offset application and get it before the council. So 2 questions to you really. One, resourcing for Kaito, and is it going to overburden them? Is it something they really want to be involved with at that level of detail? And secondly, is it reasonable to have in provisions that lead to an avoid in conclusion if you can't actually achieve the offset proposal because you can't get the input on what Mataraka Māori might require?
What was the first? So I didn't set that on APP.
Right. So what
APP3,
arises
so
from,
what was the
arises
first?
from Eco P6, all right? The requirement in Eco P6 clause 4 that where there are residual adverse effects, that they're offset in accordance with Act 3, Appendix 3, all right?
Yes, yes. Sir.
And then when you go to Appendix 3, clause 2, and there's been a suggested, oh, look, it may be a very late insertion. It's been suggested under the 42 process, the offset records for Tāpara Māori when Tāka species are affected. And then clause 3E, a requirement that includes application of Mataraka Māori. So,
Yes, sorry, that's my spots.
yeah.
Yeah, sorry.
So that's, so the outcome and what I'm really seeking is that in a resourcing sense, something that you think Kaito have thought through and are able to perform, and should it be a barrier if because of lack of resourcing or lack of willingness or whatever it might be, or lack of knowledge possibly in a particular area, Kaito who can't respond, and should applicants be prejudiced by their inability to either access that Mataraka Māori, or in a practical sense, how do they go about trying to access it? How do they go about identifying who they need to approach?
The cavalry is just written over the pass, as it were.
Sorry, what's that?
The cavalry is just written over the pass. As it were. So I'll let Ms. Bartlett answer that. Just as a general observation, though, that my understanding, and I'm sure Mr. Christensen here will tell me if I'm wrong, is that the criteria for offsetting are so complicated and so stringent that genuine offsetting examples are relatively rare. To date, it doesn't matter, they won't be going forward, that there may not be more genuine offsetting examples that meet these criteria. So I think that the small number, whether it's a gold mine or a significant highway project, the small number that actually do meet these criteria, I don't think it would be too onerous on resourcing to try and consider or employ Mataraka methods with those. So in terms of our resourcing, and the second part of your question, I think that we are the agency that an applicant would go through to access that Mataraka.
Right.
Well, I'll let Ms. Bartlett, she'll probably answer that a lot.
Thank you. Ms. Bartlett.
Oh, so you're happy for me to jump in? Yeah. So kia ora, I have been listening. You haven't been able to see me, but I've been able to see you. So I've been following, and I think Michael's answered it really well. Probably what I would want to add is that there are different ways that Kaito can provide that way to apply or incorporate Mataraka. So that could be by way of Kaitahu produced guidance documents, for instance. So there are ways in which this can be facilitated, I guess, and because we are talking in this context about Kaitahu, and we understand that we have the entities like Okaha and Te Ao Marama that are specifically set up for this purpose, plus we've had significant investment by the tribe over time in development of tools, most recently the Apati Whanau Tātai Whanau tool in that Ngāi Tahu ki Murihiku have been using for assessment of cultural landscapes, and there are tools used already in both Kaitahu ki Otago and Ngāi Tahu ki Murihiku around assessment of health of freshwater bodies in response. So I think we aren't, we're quite able, I'd say Kaitahu is quite able to respond to this and be mindful of the process and the need for the process to flow. And I think the goal would be to make that process flow well to assist in achieving the outcomes that whānau are seeking. So there's a strong incentive for Kaitahu to step up and do that. I think Michael's right that in terms of offsetting, we aren't necessarily going to be, well, I'm not anticipating that we're looking at a flood, and that therefore it should be a manageable exercise. But if we find that there's a bigger response required, then we're quite able to find ways to accomplish and provide the necessary guidance. To deliver this practically. I think the key here, though, as you've been hearing me talk, is that the onus will be on Kaitahu to bring this forward. But we do have some good existing examples of investment in doing just that.
Thank you both very much. I wasn't quite sure, Ms. Bartlett, are you intending to address this further or not?
Oh, I thought I was listening to some of the exchanges around the Manuka and Kānuka, and I thought that that was the primary point in APP3, and the points that you're asking about now that was sitting in my evidence rather than Michael's, and I did think that would be for me to talk to. Yeah.
Indeed. Thank you. Well, look, I'll pass that back to Bianca Sullivan.
Yeah, no, thanks. Oops, and I suppose one of the, did you hear the question that I had for Michael before?
You might have to repeat. I've made little notes across the morning, and but perhaps if you could just jog my memory, that'd be helpful.
Yeah. So the issue's more, I suppose. I mean, I think you raise in your evidence the significance of Manuka and Kānuka, and I suppose the issue comes to how Indigenous species and ecosystems that are Tauka would be identified and mapped, and what sort of extent is that likely to be if I suppose we are going to end up potentially with Manuka and Kānuka areas within that.
So I think so. Yeah, I did pick up the how will that occur? I think we've got the combination of policies and methods sitting in the MW chapter in combination with what's sitting in eco, and that the oh bugger, I just lost my thread, sorry. Yeah, so what was I trying to say in response? That mapping is most definitely a tool available, and in order for this approach to be effective, again, there'll be incentive for Kaitahu to invest energy in such an exercise to provide the clarity. In terms of extent, I guess if you start with the idea that your maximum extent is dictated by what is currently found in terms of Manuka and Kanuka stands in Otago, some of which have already been identified and mapped. So we've got a starting point, I suppose, is what I would say. And I think possibly your reason for asking around the mapping and the extent is really then on the implications, like how often this cascade of effects management hierarchy and offsetting might be triggered because of incorporating Manuka and Kanuka as tauka species.
Yeah, I mean, it's that. I suppose it also comes into Eco P3 as well, Eco P3-1.
Yep.
Where, potentially if we've got quite substantial areas, and, not just Manuka and Kanuka, but potentially a large number of species as well. I'm just, I suppose, just trying to get a feel for what the impact is of these provisions.
Yeah, what the potential implications are. I get that. I understand. And I think Michael's answer to this is the right one, in that the process of zooming in on what's important, that's part of the application of mātauraka around tauka species. So I think that can be expected to happen. What I wanted to probably pick up on is, I think, because we're coming up against what's been talked about already, the difference between the pure sort of ecological science criteria that's been explored and you've discussed with Dr. Keesing this morning, that is quite a different lens to a tauka species lens, and Commissioner Kirikiri was talking about this. That the idea that it's prevalent, that this tauka species is prevalent and vigorous in its growth, for instance, both those things are positives and equate to its value as tauka from the kaitahu's perspective. So it only becomes problematic to think about it that way, its abundance and its vigorous nature, when it comes up against this idea of protection or preservation or conservation, I guess. So the practical implication, though, I wonder about in relation to, say, if we do end up with large areas of Otago mapped for Kanuka and Manuka as places where these stands are significant and important from a mana whenua perspective, and that is a broad coverage. If the consequence of that is that when, and bearing in mind that when we talk about this, we also have to apply Eco P5, because I know Commissioner Kubert was asking that question around existing use rights and how that sort of plays with pastoral practices in relation to these species. I think Eco P5 handles that element. And so then if we do have extensive areas and we're not talking about that existing use issue, we've got a species that is probably very well designed for offsetting, because of the vigorous growth potential. So that if you are then talking about a new activity, so it doesn't have that existing status, then it's a new activity that's going to impact one of these stands, and therefore that would, if we follow through the effects management hierarchy, can't be avoided, remedied, mitigated, and we've dropped down to an offset. It's probably a good candidate for offset, and that's probably, I'm not an ecologist, that's for the ecologists to talk about, but my instinct would tell me that it's not a bad bet to say that. So and that's probably one of the reasons, just one of the reasons, that the original exclusion was put in there in APP3, both the abundance and the vigorous nature of the species. But of course, in doing that, the reason for the submission highlighting it, and then my evidence just honing in on this one narrow matter, is that it is a really, really good example of the difference between Te Māori lens and the standard ecological environmental science lens. It's a really good example of the blind spot, I would say, because there's a tendency to look at some of these tauka species like Manuka, Kanuka, bracken is another one, Aruhi. It's a really good example as well, where you know, it can be treated like a weed by some, and it is in fact important tauka species for kaitahu, and we've got to accommodate that somehow in our framework to better manage that relationship going forward.
Okay, well, thank you for that.
Yeah, thank you. I didn't have a lot, thanks, Ms. Bartlett, but I'm not sure I share your optimism that both you and Mr. Bathgate suggested around you won't get a lot of applications through EcoP6, because when I look at EcoP6, that excludes the significant natural areas thing. This EcoP3 applies there, and it does use the same thing, but EcoP6 is just talking about Indigenous biodiversity, regardless of significance. So I would have thought that provision is going to be used quite regularly. And are you saying that it won't necessarily get down to 4 and 5 offsetting or compensation?
Or the answer might be that the guidance on application of mātauranga and incorporation of mātauranga is provided by Kaitahu, so that it's clear and visible, and away you go. You know, there are different ways to handle this depending on what we end up with scale of response required.
Yes, so
there could be some very simple ways to do that, to apply the mātauranga and incorporate it, depending on the circumstance. Yeah.
And you're saying more often that would occur in the remedy or mitigate sort of level, rather than getting down to offsets and compensation.
I suspect so. Yeah.
And that's just to jump on, that was what my comment was about. And this was something that traversed several years ago at the 2GP hearings here in Dunedin, where the Department of Conservation turned up and said that there's very few examples of applications that meet their criteria for what is a technical biodiversity offset. So I was making a comment in relation to APP3. And it may change moving forward, but based on past experience.
Yeah, okay. Thank you.
Hello, Maria. I don't have much to add because you've already heard my questions, you've heard some of the responses, but I do want to refer to a point that Michael raised earlier on about the sort of marbles landing in the right places, or appropriate, marbles is not the right word, but the conversation is landing in appropriate places and are enabling Ngāi Tahu to keep pushing and keep responding and keep front-footing some of the issues. And you've just added to that by saying we are ready and able to do that, which is an addition to just the mere fact of knowing that you're going to do it or you need to do it. And being able to, I guess, be bold enough to push the envelope now and then. Well, more than just now and then, I guess, it's all the time, really, which is what I think Ngāi Tahu has had to do to a large extent and will need to continue to do, as every other sector of the community is doing. It's not just Ngāi Tahu. I mean, we've got Oceanic Gold here. They've got to push their barrow, and everybody else is pushing their barrow and all that sort of stuff. So that is comforting, I think, from a certain perspective. But I just wonder, what more is it that Kaito has to do in this space, the Indigenous biodiversity space? Because I just happen to think it's a really, really important one. You referred to some taonga species. I mean, arohe, you're right. Most other people would see that as a weed.
Yeah.
They want to throw it out. Yeah.
So I'd love to respond to that. I was listening to that and I was dying to just pick up on your questioning, your line of questioning around Māori. I think it was a really important one. I think we do have, sitting there in the integrated management chapter, the core notion of Māori and integrated management sitting at the heart of the RPS. So I'm quite comfortable that we can bring that into this conversation around Indigenous biodiversity and tauka species. What I wanted to note, though, was that those tools that I mentioned that Ngāi Tahu ki Murihiku are using to assess the health of a water body or a cultural landscape, a wāhi tūpuna, one of the indicators of health is the state of Indigenous biodiversity. That is a health indicator. It's the Māori indicator. And so that is precisely what we're talking about when we're talking about, we're not just talking about mahi kai, which Michael was starting to sort of say. Tauka species are not, like mahi kai is like a subset of tauka species, if you like. It's not the whole story. And I think a way to think about it, when Commissioner Cubitt was asking, how does this relate to Māori land? How do we think about the relationship of this topic with the utilisation of Māori land, for instance? I think if you think of Indigenous biodiversity as a health indicator, then when you're in the Māori land setting, the question is, how healthy is this place that I'm living in? How healthy is this place that I'm making use of? How am I caring for its health? And how does that in turn make me healthy and my whānau healthy? And that's really what we're talking about. So that idea of, again, why I think Manuka and Kanuka and the Brack and the Aotearoa are really good examples, is that idea that something doesn't need to be rare to be precious. It can be precious because it's abundant. And in fact, that it's precious because it's abundant is really critical from a Te Ao Māori perspective. And it was really interesting listening to Dr. Keesing actually talk about this from the other side. He was saying, by the time something has become rare and we're treating it as precious, it's lost a lot of what it was giving to the ecosystem health and function. That's exactly what we're talking about, these two sides of the same thing here. So I think it is right and appropriate, really, that we don't set up a system that presumes that it's still okay to knock off the abundant things and not worry about if if we're reducing them, and we can reduce them and reduce them and reduce them until they've got down to this rare and precious place where we care. I think that's not Te Ao Māori, and it's this place of abundance and health and vigor, that idea of robustness and sustainability. I think that is at the core of what we're talking about. And I think it is here in this RPS. I think the ingredients are there when you tie this back to both the integrated management chapter and the mana whenua chapter. Yeah.
Thank you very much. That's all I have.
Thank you, Ms. Bartlett, and those sort of sentiments were helpful. I've only got one question, and that is the guidelines that you've talked about of Kaitahuki Murihuku working on. What's a sort of completion date that one could look at for that type of work?
Oh, so that's probably you might have picked up in relation to the when I was talking about the cultural landscapes sort of tool that's already in use by Ngāi Tahuki Murihiku. That's one of the reasons that we were arguing for the provisions to be written the way that they are. Yeah, so these tools are already in use, but the important thing for Kaitahu is that they have integrity from a cultural perspective. They are held by the tribe, and effectively the fruits of applying them are what are visible and accessible to others. But the core of how those fruits are developed is held by the tribe, and I think that's really important.
Thank you very much. Thank you, Ms. Bartlett. Thank you. So the next on the list is Mata Kanui, and is
He's joining online.
oh,
Just be a second.
Kia ora, Ms. Colley.
Kia ora. Kia ora koutou.
And we're in your hands as to whether there's anything you wanted to add to your brief or not.
Just briefly, if I could direct the panel to paragraph 5.24 to 26 of my evidence. I just wanted to provide some updated comments on Eco P4 after reading Ms. Hardiman's updated second supplementary 42A report, which is the one dated 24th of February.
Right.
So Ms. Hardiman has recommended that there should be provision for mining activities to be added to Eco P4 in that new subclause 1A, and that the threshold from the NPS for highly productive land should be applied to Eco P4 for mining activities. That is significant national public benefit that could not otherwise be achieved using resources within New Zealand. And her reasoning is that the more stringent approach is necessary because P4 deals with Section 6 matters. So I agree with Ms. Hardiman that a threshold should be applied to mining activities included in Eco P4, but I do prefer the text in the NPS for freshwater management, being that the activity provides significant national or regional benefits. And a couple of reasons for that. So following Ms. Hardiman's line of reasoning, the NPS for freshwater management also protects values identified in Section 6 of the RMA. So I don't think that line of reasoning follows through. And in addition, I note that any mining activity would still be subject to Eco P6. which will ensure that the policy framework continues to achieve the objectives. Secondly, I'm concerned that demonstrating that NPS highly productive land qualifier being significant national public benefit that could not otherwise be achieved using resources within New Zealand is unreasonably difficult to demonstrate that it will be met and isn't necessary to achieve the eco objectives. So I recommend to the panel that my drafting of Eco P4 at paragraph 5.26, though I would add that qualifying text with significant national or regional benefits to be added in following mining and minerals exploration activities.
Can you just provide the clause reference that you were referring to in the NPS-FM in that regard?
Yes. So in clause 3.22, so clause 1, and then EII.
Thank you. Thanks very much, Ms. Colley. And I'll just ask the other commissioners if any questions. Thank you.
No, thank you, Ms. Colley. I think that's yeah, that's reasonably clear. No, thank you for that. Nothing from me.
Thank you.
I have nothing for me either.
Right. So let me check, Ms. Colley. Thank you, Ms. Colley, and what you've responded to has been helpful. Thank you. So,
Okay. Thank you.
that concludes it. Thank you. So, Mr. Christensen.
Kia ora koutou, and thank you for the opportunity to speak again. It's appreciated. The panel will receive a number of documents. So there's a legal submission, which I'll take you through shortly. There are also summary statements from the 4 witnesses for Oceana Gold, and there is also some marked up provisions of the eco chapter and the related appendices, which Ms. Hunter has prepared. And I might ask the administrator if she'd be kind enough to could you pass out the provisions as well? I just thought I'd get the provisions rather than Ms. Hunter's going to give her evidence at the end, and I thought it'd be helpful if you had those in front of you because you might want to make reference to them as we go along. If you're happy, I'll go to my written submissions. So I provide first a context for the suggested changes that my client would make to the relevant provisions of the regional policy statement. In January, I presented opening submissions on behalf of Oceana Gold, which addressed the regional and national importance of the Macraes mine and provided some background to the mine's operations, as well as highlighting Oceana Gold's general concerns with the proposed regional policy statement and a lack of response from the ORC to issues that have been raised through the submission and pre-hearing processes. At that time, you'll recall you heard from Ms. Paul, Oceana Gold's General Manager, Corporate and Legal Affairs, and also from the economist, Mr. Yacob. Without doubt, the Macraes mine is a significant physical resource, providing important economic, employment and social benefits and associated, as assessed at the local or the district level, but also at the regional level and the national level. Without doubt, the ongoing development and operation of the mine will have unavoidable effects on significant biodiversity values, so that we've got clear evidence about that. And that those effects need to be carefully managed to achieve good outcomes that ensure biodiversity is protected and maintained. And without doubt, the notified version of the proposed regional policy statement fails to provide for this. The outcome that OceanaGold seeks from this part of the hearing is the correction of that failure. A theme of OceanaGold's formal submission on the proposed regional policy statement and of my submissions to you in January was the general failure of the notified document to recognise and provide for the importance of the extractive sector in Otago and of the Macraes mine in particular. That failure was compounded by the ORC's refusal to address the deficiency through the pre-hearing process, leading out of a sense of frustration to OceanaGold, asking their planning consultant, Ms. Hunter, to suggest how this deficiency might be remedied. Since I last spoke to you, there has been some work by the ORC and various submitters looking at how the wording of the notified version of the document might be amended to address its failure to identify the importance of the extractive sector generally and to deal with the intersection of important minerals and important biodiversity values specifically. There's also been caucusing of ecologists to discuss the criteria that should be used in the proposed regional policy statement to identify areas that are to be categorised as significant for biodiversity values. That is the wording of Appendix 2. And that resulted in the production of the joint witness statement dated the 31st of March, which we've already been considering today. A related topic is the content of Appendices 3 and 4, which contain provisions guiding biodiversity offsetting and biodiversity compensation that have effectively been carried over from the partially operative RPS and are significantly at odds with contemporary best practice. These appendices were not addressed in expert caucusing. They do not reflect the contents of the national instruments that deal with offsetting and compensation, and there I refer to the NPS freshwater management and the exposure draft of the NPSIB. And they need substantial amendment so that they're consistent with the direction of those instruments and are able to be worked with in a practical way by applicants and their ecologists and by decision makers. The hearings panel directed the Regional Council to consider OceanaGold's suggested amendments as proposed by Ms. Hunter to better address mining. This includes changes or additions to various parts of the regional policy statement, including the eco chapter. The ORC provided supplementary evidence in response to that direction, and OceanaGold's consultant planner, Ms. Hunter, filed her own supplementary evidence in response again. An important and encouraging development from OceanaGold's perspective is that the ORC's planning team is now recommending an amendment to Eco Policy 4, which will provide a consenting pathway for mineral extraction activities. This has got a really loud hissy kind of sound. Is that just me? Or you hearing me okay?
No, we're hearing you.
I'll carry on. Other aspects, such as a new issue statement and the significant resource management issues for the region as proposed by the planning consultants engaged by various parties, also need to be addressed so that the regional policy statement as a whole makes sense and reads as an integrated document. To put that matter in context, why does Eco Policy 4 need to be amended to provide a consenting pathway for mining and quarrying? Because they are regionally important activities, and providing for these sorts of activities is a significant issue for the region. Absent that recognition, the recommendation now made by the ORC in Eco P4 doesn't appear, at least in my submission, to be properly supported within the document as a whole. Similarly, the clear identification of the regional significance of extractants is important to support other parts of the regional policy statement that need to recognise the locational and functional needs of important activities. The Regional Council has provided no indication of whether and how it proposes to deal with this, and it isn't a topic for this hearing. And in accordance with your minute 13, OceanaGold expects it will only find out whether the Regional Council grasps the issue when the ORC closes its case at the end of the hearing. So I make that comment because I know it's sort of not strictly on the eco topic, but I need to make that submission because you've made a ruling as to the process from here, and I accept that ruling. But it's important to understand that popping in the policy, Eco Policy 4, popping in the reference to minerals appears, I'm going to say later, out of the blue if you don't also have a recognition of the significant resource management issue, which is providing for industry and extractors. Paragraph 9 from the joint witness statement, it's clear that there are limited areas of agreement amongst all the ecologists on how the significance criteria in Appendix 2 should be worded. Many aspects of the notified criteria are in dispute to one degree or another. There is agreement amongst all the ecologists, including the ORC's ecologists, that a guidance document for interpreting whatever criteria are included is essential. This document, at least to my knowledge, is entirely absent at present. I do not know if and how ORC intends to address this, and it wasn't addressed in the ORC's case at all before you today. But that's a matter that all of the ecologists were unanimous about in the joint witness statement, that a guidance document on how these criteria, whatever they are to be consistently interpreted was essential. The changes recommended by the ORC planning team to address the need to provide for locationally constrained mineral development proposals to have access to the effects management hierarchy when development proposals intersect with significant biodiversity values are a useful start, but do not yet address the issue as well as they need to. It seems that the difficulty may stem from the fact that while policy 534 of the partially operative RPS says recognise the functional need of mineral exploration, extraction and processing activities to locate where the resource exists, an equivalent policy or recognition in the pORPS is missing for reasons that are not explained in the ORC's supporting documentation. Compounding that difficulty so far as the Macraes mine is concerned may be the fact that, to my knowledge, none of the ORC's planning team currently working on the document has had any professional involvement with the Macraes mine, and therefore there may be a lack of appreciation of the value of the mine and of the extent to which impacts on significant biodiversity and other values are unavoidable, but are able to be managed to produce positive outcomes. To address this omission, Ms Hunter has proposed a new objective to be included in the Land and Freshwater, Land and Soils chapter, headed Resource Use and Development, and that would read to recognise the role of resource use and development within Otago region and its contribution to enabling people and communities to provide for their social, economic and cultural well-being. After quoting from her previous supplementary evidence, Regional Council's Ms Boyd says, I continue to have the same concern about the appropriateness of this objective in the Land and Freshwater, Land and Soil section. I confirm that OceanaGold is not opposed to an objective facilitating mining and other important resource use being placed in a different chapter that Ms Boyd identifies as more appropriate. What is important is that such an objective is necessary somewhere. Otherwise, the exception ORC now recognises needs to be included in Eco P4, as I say, appears out of the blue. Ms Hunter has also suggested the inclusion of another policy that deals specifically with mining. Ms Boyd does not support a blanket pathway for all types of mineral and aggregate extraction, and considers that if the hearings panel was minded to adopt such a policy, its scope should be limited to activities with regionally or nationally significant benefits only. As Ms Hunter explained in her evidence, the suggestion she has made would align mineral development with the approach proposed for infrastructure, which encounters similar locational and functional constraints to mining. At a practical level, OceanaGold would accept policy settings that provide for regionally or nationally significant mineral and aggregate extraction operations to have a consenting pathway, and this is what OceanaGold promotes in the Eco chapter, where mineral development and significant biodiversity values overlap, and I discuss this in more detail below. So there's a consistency between, I wasn't aware what the previous submittal was going to say, but the same approach that she advocated for is also acceptable to OceanaGold, as you see. I turn next to a new policy in the Eco chapter, it's an objective in the Eco chapter that's proposed by Ms Hunter. And that would be social, economic and cultural wellbeing, manage Indigenous biodiversity in such a way that also provides the social, economic and cultural wellbeing of people and communities now and in the future. I submit this is a useful addition and do not agree with Ms Hardiman's view that it lacks consistency with what the Eco chapter is trying to do. I submit that resources, including Indigenous biodiversity, need to be managed in an integrated way and for the purpose of the Act. The relationship of people and biodiversity is already provided for in Objective Eco 03, which recognises that in the context of biodiversity, mana whenua need to be able to exercise their role as kaitiaki, which includes providing for te hora o te takata, the health of the people. Proposed Objective 04 is not inconsistent with that approach. Objective 02 is about restoring and enhancing biodiversity and is entirely concerned with the relationship between people, biodiversity, and the activities we undertake. Proposed Objective 4 is a reasonable extension to that and requires that biodiversity be managed in an integrated way that provides for social, economic and cultural wellbeing. I submit the proposed objective is not at odds with the direction of the other objectives of the Eco chapter. So that's looking at the horizontal level of the objectives that sit in the Eco chapter. I now want to talk about the vertical level. So if we consider the objective that's proposed by Ms Hunter in the context of the policies that sit beneath it, when the policies that implement the objectives are considered, it becomes clear why new objective 04 is needed. Policy Eco P13 is about facilitating access to and use of biodiversity by kaitahu associated with activities that support cultural wellbeing. Policy Eco P4 is concerned with providing a pathway for important activities that unavoidably impact significant biodiversity values or indigenous species or ecosystems that are tauka. The point of these provisions is to ensure that biodiversity is managed in a way that also provides for the wellbeing of people and communities. Absent an appropriate objective, these become orphan policies, and proposed objective 4 provides the missing link. So that's the new objective that's proposed. Policy Eco P4 and the consenting pathway and the ability to access the effects management hierarchy I talk about next. Oceana Gold supports the general intent of Ms Hardiman's proposed changes to Eco P4 to provide a consenting pathway for extractives where effects on significant biodiversity values are unavoidable. Ms Hunter proposes further amendments to Ms Hardiman's suggestions for new paragraphs 1A and 1B, which Oceana Gold supports. Now, so set those out below. Ms Hunter will take you through them in more detail, and you may have some questions for her. But I make some observations. First, these amendments do not limit the policy to only new uses or developments, but also recognise that the ongoing operation of the Macraes mine, as the primary example, is just as important in retaining the workforce and delivering important economic and social benefits to the districts and the wider region of Otago. Secondly, and consistently with Ms Boyd's view, it's proposed that 1A should include a reference to regional benefits, not just national benefits. While Oceana Gold submits that Macraes mine has significant national benefits, the additional reference to regional benefits makes more sense. It aligns paragraph 1A with paragraph 1B, where aggregate extraction is the topic, and that requires significant national or regional benefits. It also follows the approach used in the National Policy Statement for Freshwater Management, and the previous speaker took you to the relevant provision there. And Ms Hunter considers that that is a more appropriate place to a more appropriate guide to the management of effects on biodiversity values. And if I can just make the comment there that the National Policy Statement for Freshwater Management is directly concerned with the management of, in part, in this aspect, is directly concerned with the management of effects on biodiversity values in the freshwater space. The alternate approach, which is to look at the way that the topic is dealt with in the new National Policy Statement for Highly Productive Land, that National Policy Statement is not concerned with biodiversity. It's concerned with managing highly productive land, particularly for food production. And so it's, in my submission, is not the instrument to look to guide the region on how it should manage the intersection between mineral development and significant biodiversity values. And finally, at paragraph 21, the approach that Ms Hunter recommends aligns with the actual benefits Ms Hardiman considers would be supported by such a provision. In other words, Ms Hardiman has considered what she thinks would be facilitated by adding in that exception. And in Ms Hunter's assessment, those are more regional benefits than national benefits, and so it would seem to be an appropriate way to deal with it. Thirdly, the amendments ensure that ancillary activities, so I'm talking about the amendments that Ms Hunter proposes to make to the provisions that Ms Hardiman has recommended. Ms Hunter's amendments ensure that ancillary activities are also addressed in the policy to avoid any unintended consequences where a necessary ancillary activity to facilitate an extractive activity, and I'm talking about there something like a road or a storage area, cannot avoid a significant area of biodiversity. So that's the policy, that if you like, the exception, the addition of the exception, and that's the one where I say that a significant progress has been made with the Regional Council's recommendation. Ms Hunter is looking to improve that so it's more effective. Turning now to policy 6 and the question of definitions. Ms Hunter proposes, in doing so relying in part on the evidence of Mr N Christensen, that the effects management hierarchy be moved to the definitions. And I support this approach as it avoids the current clutter in the notified version of the policy. Importantly, Ms Hunter and Mr Christensen also propose that the definition of the effects management hierarchy should be consistent across both terrestrial and wetland environments. And I agree. Frankly, the idea that the effects management hierarchy means something different in the wetland context than it means elsewhere is what I say, an unsupportable fiction. Further, as Ms. Hunter will explain in her summary, wetland environments often contain Indigenous biodiversity values. In fact, in many cases, that's why we value our wetlands. Applicants and decision makers would be put in a difficult position if they're asked to apply two different effects management hierarchies in effectively the same physical space. Eco M4 and M5. Ms. Hunter proposes consequential amendments to the requirements on regional and district plans. So this is in the methods section of the Eco chapter to account for the changes suggested to P4. And I submit these changes are necessary and aren't controversial. They follow logically. Turning to appendices 3 and 4. These appendices address the requirements for biodiversity offsetting and compensation. They're of considerable importance in guiding both applicants and decision makers in the appropriate design of measures to address residual effects on biodiversity values after actions to avoid, minimise and remediate effects are exhausted, and they are fundamentally flawed in the notified version of the pORPS. As far as I'm aware, these appendices have not yet been the subject of any proposed amendments by the ORC's planning team, and they haven't been the subject of caucusing between relevant experts. Supported by the expert evidence of Mr. Christensen and Mr. Hewson, Ms. Hunter has proposed significant revisions to both appendices to bring them into line with contemporary best practice. In the notified version of the proposed statement, these policies are effectively a rollover of the provisions in the partially operative 2019 RPS. OceanaGold has direct experience, as does the ORC, in the application of these provisions. They were considered in the context of OceanaGold's Deepdale North resource consent application, and in granting consent for a suite of actions that the ecologists agreed would result in a good outcome for biodiversity, where gains would exceed losses. The commissioners had to look past the policies and focus on the effects of what was being proposed. Notably, in that example, ORC was not only a consent authority in relation to the water and discharge permits applied for, but was also, through its planning directorate, a submitter on the application. Given that history, it is surprising the ORC appears to have made no effort to address the problems it must know the appendices create. Perhaps the explanation is found in the fact that none of the planners working on the proposed policy statement for ORC were involved in the Deepdale North resource consent application process. The fundamental flaw in the appendices is that the matters that are addressed in the context of both biodiversity offsets and biodiversity compensation are expressed as conditions that must be met before any proposed action qualifies for consideration. In other words, they're expressed as presumptive limits, rather than as principles to be considered when assessing the appropriateness and quality of the outcomes proposed. This means that according to the appendices, as worded in the notified version, a biodiversity offsetting or compensation proposal cannot be put on the table for consideration if it fails to satisfy one of the criteria, even if that proposal would lead to positive biodiversity outcomes. I submit it is both incorrect as a matter of law and inappropriate as a matter of good or even sensible biodiversity effects management. In their evidence for OceanaGold, both Mr. Christensen and Mr. Hewson expressed concern with the way appendices 3 and 4 are specified as criteria. Mr. Hewson suggests a better approach would be to amend appendices 3 and 4 so that they set out the principles or framework for considering the adequacy and appropriateness of offsetting compensation proposal at the consenting stage. Mr. Christensen also has concerns with the way the offsetting criteria in Appendix 3 are criteria that must be met in order to qualify as offsetting. Instead, he favours the approach used in the BBOP in the 2018 government guidance document, which requires regard to be had to the principles, leaving the decision maker to decide on the evidence and in accordance with the other principles if something can be offset. He has similar concerns with Appendix 4 and considers that it is more useful to define biodiversity compensation in terms of its purpose and provide a framework of principles against which the appropriateness of a proposal can be assessed. Mr. Christensen suggests amending the appendices to set out a framework for considering an offset and to link this to the effects management hierarchy, and his recommended changes are set out in his Appendix 4. He says this in his evidence: rather, the matters set out in the appendices should be expressed as issues which must be considered where relevant and not as criteria which must be complied with. This would allow a case-by-case normative decision-making based on the evidence before a decision maker What is or is not appropriate as offsets or compensation requires such a case-by-case assessment, and to do that in advance in the abstract, in the RPS provisions is, in my opinion, fraught with uncertainty and therefore not the most effective and efficient policy outcome. He goes on to make the important point that while criteria to be applied within the form of a bright line test may seem an attractive proposition, such bright line tests do not work effectively when the criteria are not certain. And then in his evidence, he has that to say. I won't read that. In addition to this overarching concern, OceanaGold seeks specific amendments to various criteria so that they're more realistic and workable. For example, in Appendix 3, Clause 1A, in the notified wording says that biodiversity offsetting is not available for an activity that will result in the loss of any individuals of threatened taxa from an ecological district. Mr. Hewson considers the reference to the loss of any individuals as very stringent, and Mr. Christensen considers it novel. Appendix 3.1b says offsetting wouldn't be available if the activity results in measurable loss within an ecological district to an at-risk declining taxa. Mr. Hewson considers that the meaning of measurable loss is unclear and problematic, as even the loss of one individual would be measurable. Mr. Christensen also has concerns with the wording in Appendix 3.2b, which suggests by using the words measured and calculated that biodiversity modelling is required in all situations. As he points out in his evidence, there can be constraints and disagreements over which models should be used in different situations. He suggests that amending Appendix 3.2b as follows: the offset achieves no net loss and preferably a measurable gain in Indigenous biodiversity, having regard to type, amount and condition at both the impact and offset sites using an explicit loss and gain evaluation. Clause 2H requires the outcome of the offset is achieved within the duration of the resource consent. As Mr. Hewson explained in his evidence, this could preclude longer-term offsets which may achieve better biodiversity outcomes. And I think you had a discussion with Dr. Keesing along those lines this morning. He suggests using the wording in Appendix 3 of the NPSIB. Biodiversity offsets are managed to secure outcomes of the activity that last at least as long as the impacts, and preferably in perpetuity. In relation to Appendix 4, both Mr. Christensen and Mr. Hewson share similar concerns as with Appendix 3, in that Appendix 4 is written as criteria to be met rather than principles to guide decision making. Mr. Hewson's also concerned with Appendix 4.1b and c, which talk about removal or loss of viability of habitat and loss of health and resilience respectively. In his opinion, both of these matters will require an ecologist to assess and make a determination, and therefore the answers to these questions are likely to be subjective. And of course, the problem with anything that's subjective, I'm interpolating here, the problem with anything that's subjective in a policy like this is that the way the policy is written, it's a binary pass-fail test. And if you don't pass it, then you can't use the technique. And so you've got to have some real reservations about anything that's not super crisp and clear and certain, because it has significant impacts in the way that it's worded in the notified version. I want to go on and talk about the relevance of section 104.1ab now, and I know this was raised in my friend's opening submissions to you this morning. In rolling over the offsetting and compensation provisions of the partially operative RPS 2019, the Council has failed in my submission to account for the relevance of section 104.1ab of the RMA. The relevant provisions of the partially operative 2019 RPS were required to be determined as if the amendments to the RMA made by the Resource Legislation Amendment Act 2017 had not occurred. That's an important point. One of the provisions inserted into the RMA by that Amendment Act in 2017 is section 104.1ab. Section 104.1 sets out the matters a consent authority must have regard to when considering a resource consent application. And 104.1ab reads, any measure proposed or agreed to by an applicant for the purpose of ensuring positive effects on the environment to offset or compensate for any adverse effects on the environment that will or may result from allowing the activity. Unlike the position that applied at law when the provisions of the partially operative RPS 2019 were considered, section 104.1ab is now a mandatory consideration when deciding on a resource consent application. It unequivocally requires a decision maker to have regard to any measure an applicant proposes or agrees to that is designed to offset or compensate for an adverse effect. There's nothing in the provision to suggest that biodiversity offsets and compensation are able to be dealt with differently from other types of offset and compensation for the purposes of this requirement. The position at law in 2023 is that a decision maker needs to turn their mind to the outcomes of actions that are proposed and cannot rule out any proposed actions because they fail to meet a presumptive limit in a regional policy. So I suggest that to you as a statement of law. The biodiversity and offsetting provisions in the partially operative RPS 2019 are not alive to section 104(1)(ab), and as a matter of law, they could not be because of the timing of that earlier instrument. Those provisions in the 2019 RPS that have been rolled over sit uncomfortably, I say, when viewed in light of that requirement, which is now firmly in play. The problem is that on their face, the notified versions of appendices 3 and 4 establish presumptive limits. That is, they purport to constrain the circumstances when offset and compensation proposals can be considered. That approach is simply not available as a matter of law in the context of the document that you're considering. While in the determination of the existing partially operative 2019 provisions, section 104(1)(ab) could not be considered, this is not the case now. The notified pORPS curiously largely repeats the partially operative 2019 provisions regarding biodiversity offsets and compensation with their presumptive limits, without recognising the change in the statutory context as a result of the enactment of the Amendment Act and the inclusion of section 104(1)(ab), and without recognising, and this is the next point, and without recognising that in the development of national policy in the form of the exposure draft of the NPSIB, which I'm going to discuss shortly, a deliberate choice has been made not to adopt the approach that was taken in the partially operative 2019 RPS. Just want to pause there and refer you to the footnote. That footnote references the Ministry for the Environment documents around the National Policy Statement for Indigenous Biodiversity. And when the draft National Policy Statement was made public and feedback was sought by the Ministry on it, it was accompanied by a discussion document. That's what I'm referring to in this footnote. That discussion document discusses what the drafters we're proposing in terms of the way we deal with offsetting and compensation. As part of that document, they put forward as an alternative consideration, they put forward, what about the approach that Otago's got in its partially operative RPS? Would you like that instead? It has been deliberately thought about and discarded as an approach in the National Policy Statement for Indigenous Biodiversity. I can't make that point strongly enough. That was the approach that Otago has in its partially operative regional policy statement is novel. It's different from any other region that I'm aware of in the country. And it has been considered and not picked up at a national level in the exposure draft. I have to say, of course, that the exposure draft is still the exposure draft. It hasn't been made operative, but there is no indication from Wellington whatsoever that there's any interest in retaining that kind of approach. And indeed, I'd say as a matter of law, it's pretty obvious why not, because we've got section 104(1)(ab) in play. So at paragraph 40, subordinate national instruments addressing biodiversity that have been developed since the enactment of section 104(1)(ab), and I'm talking here about the freshwater national policy statement and the NPSIB exposure draft, are alive to the requirement of section 104(1)(ab), and they set limits on the use of biodiversity offsets and compensation in outcome terms. That is, they set out principles as to what it is that biodiversity offsets and compensation proposals should achieve or should avoid. In so doing, they provide more detailed guidance to decision makers to assist them as they discharge their duty under section 104(1)(ab) to evaluate whatever proposals an applicant might advance or agree to. The ORC's own evidence is alive to the problem, and I note that Ms. Hardiman's section 42A report has this to say, and she was referring to submissions by Queenstown Airport and Contact, and she says an applicant may propose something else that is something that doesn't conform to the specifications in the appendix, and it will be tested against what's in the pORPS and lower order plans and a decision maker may prefer what the applicant has proposed in a particular case. So that's, in my submission, that's effectively an acknowledgement that wording in the regional policy statement that effectively says only consider an offset proposal or only consider a compensation proposal when it conforms to the recipe in the appendix is just wrong language. We've moved past that, and we're now in a legal context where these appendices should provide principles that guide consideration, not determination a priori of the outcome. So I say at paragraph 42, the position in the notified document is therefore in error for the following reasons. Section 104(1)(ab) is clear that all offset and compensation proposals are to be had regard to. The biodiversity and compensation principles in the NPS FM and exposure draft NPS IB post-date the enactment of section 104(1)(ab) and don't conflict with it by providing principles as to what proposals should and should not achieve that are able to be applied to guide the assessment of any proposal and applicant advances. So my submission there is that when you look at the way that offsets and compensation is described in the new national instruments, the contemporary national instruments, it's quite different from the way that the notified version of the pORPS deals with them. So I disagree with my friend Liz Sefton about. I think she was inferring from her submissions this morning that there are similarly limits in the new national policy documents. There are limits, but they are limits in terms of what the outcomes should be, not, as I say, presumptive limits, which is the way that the pORPS is expressed. So I'm saying in paragraph C, the partially operative RPS provisions regarding biodiversity offsetting and compensation could not consider section 104(1)(ab) and are in conflict with it by purporting to proscribe the circumstances when decision makers can consider a biodiversity offsetting and compensation proposal. And then I say that the pORPS that you're considering largely repeats the provisions of the partially operative RPS as if section 104(1)(ab) doesn't exist. But the Otago Regional Council's own evidence on this matter acknowledges that the section does exist and notes that proposals that don't conform with the pORPS formulation will still be considered and may be accepted. The result is that the provisions of appendices 3 and 4 as notified must be changed to read as considerations and not as presumptive limits. The revisions recommended by Oceana Gold's experts express matters as they must be expressed and should be adopted. And you'll note when you get to them with Mr. Christensen and Ms. Hunter that they look quite similar to what you'll see in the national policy documents. There's just some differences, but that kind of approach. Finally, I want to deal with the significance criteria, and I'm not going to tell you what you should do here. I'm going to make some observations. I'm supportive of the approach that the panel took in asking the ecologists to work together on the significance criteria. Unfortunately, the joint witness statement that resulted from the process leaves the panel, I think, in a difficult position. None of the ecologists, including the ORC's own expert, Dr. Lloyd, support the notified provisions of Appendix 2, but they are not agreed on what changes should be made. It appears that the ecologists are agreed on changes that should be made to the representativeness criterion, and in my opinion, you should adopt their suggested amendments to that criteria, or that criterion. As to the other criteria, I don't express a view on behalf of my client. I've asked Dr. Thorson and Mr. Hooson, who were the ecologists from Oceana Gold that participated in the conferencing, to clearly in their summaries to you today set out their preferences. But what you do with that and with the views of the other ecologists engaged by the other submitters and by the ORC, I express no particular view about. I just want to make the following observations. It helps nobody for the exposure draft of the NPSIB to continue to languish unimplemented. As soon as there is an operative national policy statement that establishes Indigenous biodiversity significance criteria that apply nationally and must be given effect to at regional and district levels, the intractable lack of resolution between ecologists on what significance means can hopefully be put to rest. There is nothing the panel, the ORC, or any submitter can do about that. We're all at the mercy of Wellington in that regard. Secondly, the joint witness statement records that all the ecologists, including the ORC's ecologists, agree a guidance document on how to apply whatever significance criteria are included in Appendix 2 is essential, presumably to facilitate consistent and reliable application of the criteria. To my knowledge, no appropriate guidance document exists, and I have no knowledge what the ORC is proposing to address this deficiency. I submit you should insist that such a document is developed and included in the regional policy statement as an appendix before the instrument is made operative. And then finally, and importantly in my submission, there is a relationship between the policy choice that is made about where the bar for significance is set and the policy implications that flow from the determination that an area's biodiversity is significant. You must not ignore that relationship, and you must be deliberate in the choices you make in the absence of national direction that takes the choice out of your hands. The way the regional policy statement is drafted means the default position is that activities that have adverse effects on significant biodiversity values must be avoided. That's a strong direction. And assuming you maintain that approach in your recommendations to the ORC, I submit you should favour significance criteria that set the significance bar at a high as opposed to low level. The evidence from most of the ecologists, as expressed in the joint witness statement, is that at present the bar in the notified Appendix 2 criteria provisions is set low. If you accept that evidence, it leads to the logical conclusion that either the bar should be raised or the default avoid approach should be reconsidered. And those are my submissions.
Thank you, thank you, Mr. Christensen. I might start with some of the queries that I just had. And I think probably a little bit later. I struggled a bit at your page 8, paragraph 17, when you were looking at the objectives and as a support, or that there was a relationship to the proposed new objective 4, and you talked about objective 02 being about restoring and enhancing biodiversity as an entirely concerned with the relationship between people, biodiversity, and the activities we undertake. And when I looked at 02, I just couldn't see it. What are you relying on in making that statement? Go to 02.
What I was trying to convey there, Sue, was that to my reading, objective 02 is about restoration and enhancement activities, which are activities that we undertake as people. And so I'm saying that objective seems to be directed towards the relationship between us and the activities we undertake, and the biodiversity with which we interact.
Right. There you go. Okay.
So in other words, I think it in a kind of I guess an integrated way, or in a Kiukitai kind of way, there isn't a separation between us and biodiversity. In many ways, it's much more integrated, and we're connected to biodiversity. So the actions that we undertake, good or bad, impact on biodiversity, and that was the connection I was seeking to make.
Right. Just at paragraph 15, sorry, page 15, paragraph 32, you're just reciting at that stage what Mr. Hewson had said, and I just was picking up on what appeared to me to be an inconsistency where you cited Mr. Hewson at paragraph 32b, considering that the meaning of measurable loss is unclear and problematic. And yet at paragraph C, we then have Mr. Mark Christensen suggesting a wording that actually introduces a concept of an offset achieves no net loss and preferably a measurable net gain. And it seemed to me an inconsistency to be for Mr. Hewson to be criticising measurable loss as being unclear and problematic. Even the loss of one individual will be measurable, but then Mr. Christensen, Mark Christensen, is recommending a wording of measurable net gain.
Okay, well, let me have a go, because I don't think they are inconsistent, and they'll tell me they'll explain better if I get it wrong. I think Mr. Hewson's comment is quite simple in saying measurable loss may be very difficult, or it may be an unreasonably high bar, because you might be able to, a measurable loss might be, in some cases, might be as small as a single specimen. I think in paragraph C, Mr. Christensen is referring to the, I think he's referring there to the concept that biodiversity offsetting requires quantifiable measures of loss and gain. And so if I can just explain there, you hear the ecologists talking about no net loss and net gain as concepts. My understanding is that they like to tie that to biodiversity offsetting, and they don't like to use that terminology when they're talking about compensation, because they say no net loss, net gain, they got numbers attached to them effectively, and an offset is something that's quantifiable. And so you've got much more of a, if you like, a handle on it. When they start to talk about compensation, they start to talk about positive biodiversity outcomes, and they use different terminology to describe the outcomes. That's the fundamental difference, or a fundamental difference, between an offset and compensation. And apart from a friend, Ms. Sefton, who said that the difference is that offsets are like for like, compensation is like for unlike. That may be the case on some occasions, but sometimes compensation is called compensation simply because whilst it's still like for like, and whilst it's achieving an overall positive benefit for that aspect of biodiversity, it's not measurable in the same way as an offset is. So it may be like for like, but we have to call it compensation because it doesn't meet the tests that the ecologists have set up for a quantified offset or quantifiable offset.
And the last issue is the biggest, which is really the legal proposition that you're advancing over the last few pages. And the difficulty I just have with that is that looking at the way that Mr. Mark Christensen's evidence relied upon the same sort of proposition that you've just advanced as a matter of law, he was referring constantly to the draft of the exposure draft of the NPS FM 2020, I think it was, or whatever, as it came out in October 2022. But when you look at the actual one that got gazetted, and I don't know if you've got it before you or not, that
the
NPS FM.
Oh yes, the NPS FM. Yes.
Can I take you to paragraph to clause, sorry, 3.22, so and 3A little Roman 2, and it seems to have a new wording that I didn't see, and Mr. Mark Christensen can correct me if I'm wrong, but I didn't see in his evidence. In other words, it seemed to me, and I haven't had the time to do the comparison between the exposure draft and this gazetted form, but what it says is, taking it from the top, every regional council must make or change its regional plan to ensure that an application referred to in subclause 2 is not granted unless, and then A, the council is satisfied that, and then little Roman 2, if aquatic offsetting or aquatic compensation is applied, the applicant has complied with principles 1 to 6 in Appendix 6 and 7, and had regard to the remaining principles in Appendix 6 and 7 as appropriate. Now that seems to be, in an NPS, a statement of what you've termed presumptive limits as to principles 1 to 6, and requiring compliance with them.
Yes. So I agree with the last part of your statement, which it does require compliance with. That seems clear from the wording. But in my submission, on a careful examination of the words in Appendix 6 and 7 of the NPS FM, compliance is to be determined in an outcome sense. So does the offset that we're proposing comply with the outcomes that are established in the principles? That in my submission is operating differently than the notified document that you've got in front of you, which says doesn't matter what the outcomes are, what we're concerned about is whether there's going to be these effects. And if there are these effects, you can't consider an offset. So these, and you can discuss this with my brother more, but I think that there is a fundamental difference in the way that the principles are articulated.
Right. Just to help me out, if you would, but it does seem that wording slipped in at the gazettal stage. Am I right?
I can't. I'd be speculating. I haven't studied it. I'm sorry.
All right. Well, folks, have you got the ability to check that whilst the witnesses are giving it?
I'd never go.
If you could, before the end of the day, it'd be great, because I haven't had the time myself either to do that. But it does appear, when you look at the way Mr. Mark Christensen quoted passages, that wording of compliance with didn't seem to be in from the draft exposure. But when you look at the final gazetted form, they are, but I want to be clear about that.
All right, thank you.
Thank you. All right. So there may be other questions from other commissioners.
Yeah, thank you. No, I did just have one or two here. I suppose in relation to at your paragraph 19, I just I noted that Ms. Hardiman's proposed P4 that she put forward is different to the NPSFM wording, because it looks to me like she's based that on the NPSIB exposure draft, where it does talk, I think it was 3.11. I'll just go to that so I get the wording right.
I think she's based it on the HPL.
It's also consistent with the NPSIB exposure draft though. So
Okay. Yep.
311 to 2A Roman 2 is mineral extraction that provides significant national public benefit that could not otherwise be achieved domestically.
Yes.
Which I think is a reflection of that wording too. I just wondered to what extent that's going to be a big issue for Oceania Gold, given I'm assuming that you could demonstrate national benefit in that way.
I guess two comments. I think that provision, because of the inconsistency that then arises between the NPS-FM and the NPS-IB, you can imagine that there's been quite a bit of commentary back to Wellington about that works. Now, that's not specifically from my client. I think it's from industry generally about a pretty uneasy situation if that was to flow through into the operative IB.
So presumably the highly productive land is as well in inconsistencies here.
Well, yes, but as I say, that's for a different purpose,
Well,
which is for the purpose of protecting that those areas of highly productive land. Whereas there's a much closer relationship between the subject matter of the NPS-IB and the NPS-FM. Anyway, that's I suppose beside the point for the purposes of your question. The other comment I'd make is that having considered the test in the NPS HPL, there are a number of aspects to it that are really hard to understand what they mean, and I'd be slow to jump on that bandwagon if I were you, because of the way, particularly if you end up supporting an outcome which has a pass-fail kind of binary answer to it. In other words, if you don't meet the nationally significant test, however that's described with reference to couldn't otherwise achieve in various terms that no one quite knows what they mean, you have to make a decision about that as a consent authority when an application comes to you. And you can only answer that in one of two ways. If you answer nearly but not quite nationally significant, you'll end up declining an application. It's that binary, which is extraordinary in my submission. So I'd caution against tying up the regional policy statement and then tying up the regional council and district councils below with that kind of, I would say, ill-considered test.
And I suspect it would be be unusual for a regional policy statement to have a national, significant national public benefit as a test, I would think. Look, and the other thing, and this is possibly, Monday afternoon, me taking a bit of a simplistic view here, but just around the section 104.1 AB, and I suppose I'm looking at that, when I look at that section of the RMA, it's telling me I have to have regard to. I mean, I would sort of be assuming that if it comes to a consent application that's got an offsetting proposal in it, the consent applicant will be putting it forward saying that it's okay, and the offsetting should go ahead, or the compensation. It would then be for the decision maker to be having regard to that and determining whether it's appropriate. I mean, and for that, it would be looking for guidance. Say if the NPSIB is gazetted, there's the principles in there, which do say when it's not appropriate as well. Just like I suppose we've got the PORPS in front of us with the appendices here saying when it's not appropriate to have offsetting or compensation with the step after that being to a board. And I was supposing, if I was sitting, making a decision on a consent application, I'd probably be looking at 104.1A, and then from that saying, yes, I can have regard to these things, but then go into whatever documents provide you the guidance as to how you should be interpreting what's put in front of you by a consent applicant. I'm just wondering, I'm just sort of struggling to sort of see where the significance is in what you're saying. I know a lot of it comes, you've talked about outcomes versus presumptive limits and the key between criteria and principles, but I suppose at a sort of high level, I'm not necessarily understanding what the big issue is here.
Well, I'll see if I can go real simple.
Yeah. Take it down the line. That'd be good.
Well, it is unfortunately it's quite a complicated sort of subject, it seems to be.
I get that.
But I think the gist of it is that in the way that the PORPS is drafted, it says don't even consider these proposals when the following apply.
Mm.
And the following apply is limits to the, if you like, the types of effects that are being considered, not the quality of the outcomes that are being proposed.
Right. So that's the key thing. If I were to look at and I've got the NPSIB exposure draft up here, just so I'm not looking at my emails. If I were to look at that, so that's not talking about effects.
So it's Appendix 3 of the exposure draft. I think you'd probably be looking at.
Yes, I'm looking at that.
And if you look at number 2, yes, right. So I think if you look at that carefully, you'd say to yourself, it's written quite differently from the way that the PORPS is written.
Yeah.
So you'd read 2 and you'd go, okay, so what's the applicant proposing here in terms of what they're going to actually do and how it's going to all end?
Yeah. So for offsetting, it's going to have a net gain to get through that first part of 2. Yeah. Okay. Yeah, okay. On to that. Thanks. That's me.
Thank you very much. The order I proposed that the experts come and talk to you was Dr. Thorson, and Mr. Hewson, and Mr. Christensen, and Ms. Hunter to sweep up as the planner. Is that all right? Yep.
Look, we might just have a we might just have a quick break, Mr. Christians. We just might have a quick break.
Yeah.
10 minutes.
Yeah, sure. Okay. Yes, Dr. Thorson, sir.
Right.
Presume this is turned on.
No, you push the button at the bottom.
Cool, thank you.
Go, Dr. Wilson. Thank you.
In the interest of time, I'll just very quickly go. Have you been provided with the summary evidence?
Yeah, yes, we have. So indeed, if you can, obviously, as you say, in the interest of time, whatever you want to highlight.
Yes, okay. So at 5, as we talked about earlier, find that some of the larger drivers of biodiversity loss in the Otago region were not identified as part of the development of the regional policy statement. And importantly, also none of the positive contributions that a great number of community groups and businesses and individuals have made has not been adequately recognised, which I feel means that the policy is not adequately aligned with the drivers' loss. The significance criteria, as I mentioned, we've been in the joint witness statement. We all agree that the joint witness statement, that the significant criteria would well tested, but we do have a lot of concerns about their scientific rigour underlying them. And for those reasons, there's a lot of hesitancy. I do point out in the joint witness statement that the overall trend of all the ecologists present was to make the criteria tougher and so raise the bar. One of the things that was raised as a concern was that in the Section 32 and Section 42A reports, there has been very little analysis on the effectiveness of actually taking this approach of significant natural areas and how well that would actually safeguard biodiversity in the area. And also there is concern that I have that if we unnecessarily set significance criteria at the wrong level, we will end up with a great number of sites where the ecologists come together and say, oh, we don't really care too much about that. And there'll be considerable impact on other landowners and things like that. And so that is a situation that arises reasonably frequently under current significance criteria. Basically because, as I say, in 10, the bar is usually set too low. At 11, we talk about the guidance document, and we see that as being quite essential. There were some pretty key fundamental components that we were discussing in joint witness statement that we would assign to that, including things like how would we deal with common species like Matagauri, which is a at-risk declining species. Yeah, and I think there I understand the frustration people feel that there is no consistency between the ecologists. It's not so much that the ecologists aren't being consistent, it's just that there's not enough information for them to reach a consensus on, so they're taking their view on what it is. So we would like to see that sort of addressed and have better information available for us to make our decisions. In 13, I'll talk about the potential spatial extent of significant natural areas in Otago. This is some of what I was using for the Section 32 and Section 42A analysis. Dr. Lloyd had some concerns about that. I feel that he misunderstood the information, maybe. Stand by that analysis. Under the joint witness statement, there was a range of different views. At the end of this document, I've attached where I consider my recommendations are in relation to the significance. We talked earlier about whether it was one significance criterion or two criteria. I think while we were directed not to consider policy when we were discussing significant natural area, there was a lot of reluctance to set the bar too low if there was an avoidance component of the policy. One that I do have, and one of the reasons why I have the concern is in relation to the representativeness criteria and common shrubland species, cereal vegetation. That can be quite common, but would also have been pre-human vegetation type, but just in a different context now than it is than it was back then. For 16, we're talking about the further analysis of the implications of adopting the significance criteria. 17, about the rarity criteria. I feel that we should be using the best available information. The Otago Regional Council has mapped Indigenous biodiversity throughout the region, and I see no reason why that cannot be used. the national level analysis of a lot of this type of information has quite a large error associated with it. They acknowledge that in the technical support documents. Diversity criterion, I agree with Mr. Vaughan, Mrs. Keesing. That's a difficult one. I've never actually used it. But I do believe that there are some possible cases where that might actually be useful. Gradients is, as Mr. Keesing said, really problematic. Whether there are situations where a gradient would reach that importance, some of the larger gradients between wetlands and drylands, I think that probably be captured under other significance criteria anyway. So it's just the distinctiveness criteria. I don't, with Mr. Keesing, I do agree with the diverse distributional limits. I believe that endemism is a better consideration of that sort of biogeographic pattern and the importance of Otago as a region. Ecological context, I agree with it in the terrestrial setting, but connectivity, I feel, in freshwater and in marine space is a totally different concept. We've got migration of fish up and down waterways and marine larvae drifting all around the sea until they find a suitable place to settle. So I don't think the same criteria can apply. And in relation to the wetlands criterion, I'm not sure exactly what the intention behind including that criterion was, but maybe if it was reworded towards more on its hydrological role that it plays downstream, that might work quite well. And I will say that, at Oceana Gold, I've been working with them for 7 years. It has been a changing landscape of how things have been done, and it's only recently that offsetting has now been employed, as it's only recently been included in appropriate instruments. But it's a really important concept. It's really important to retain that, and part of that is because no matter what the significance criteria actually get worded as, it's highly likely that we will be encountering significant areas in the Macrae's context. There's just a large number of rare and unusual species in that area. So we will get into that. And Dr. Lloyd has given you some written submissions to questions. And I've just made some notes on his response, but I don't think they're of particular importance to go through here. I'll take any questions.
Thank you. Not too much for me. I did have a page of questions, and as I read through various other things, it's sort of not become really clear. One thing though, I mean, you've talked quite a lot of, about the land cover database, and I suppose the extent of, well, potential extent of SNAs. I would assume that to determine SNAs, there would need to be on the ground ecological surveys. Would that be correct? Or does that
I don't think that's needed. That's an assumption you can make. I mean, a lot of them are mapped remotely off aerial photos.
Yeah. So potentially it could be, I mean, as I presume, yeah. How's the LCDB5 determine vegetation classes, for example, to
satellite imagery?
So that's satellite imagery.
Computer analysis of satellite imagery.
Yeah. Yeah. So it is feasible that for, say, for a district plan mapping, it could largely be based on aerial photography.
It's not beyond the realms of possibility. Yeah. The technology is there, and one way across the whole region, very quick and easy way. I can't speak to the accuracy of such approaches.
Yeah. I mean, is that how most district councils have done it to date in your?
Under significance assessments, mostly they've tried to employ a team to go around the region or district and look at sites. But yeah, that approach has been fraught as well. So there's, it's been to date, there's been no cohesive and coordinated approach on how to identify natural areas between different areas.
Yeah, and I suppose, yeah, notwithstanding the access issues as well.
Yeah.
Yeah. Okay. Because I suppose looking at the criteria in Appendix 2 or through the joint witness statement, I mean, how realistically, how could they be determined by broad scale mapping without on the ground surveys?
Most you would not be able to. The vegetation community extent would be about the only ones that would lend themselves to that type of activity.
Yeah, no, that's yeah, what I was thinking is another question I had around Manuka and Kanuka and the exclusions provided in Appendix 3 and Appendix 4. For offsetting and compensation, would you had Manuka and Kanuka, would you still be looking at those, going into those ecosystems to look for whether there were other characteristics that met the criteria, or if it were principles?
When we're assessing a project, you would look at it across the range of features, not just one Manuka or Kanuka.
Yeah.
You would take that into account, but you would try and describe them the appropriate ecological values at this time, as the way it's been done historically.
So you'd still be looking as to whether this, significant invertebrate populations or other things within those.
Yes, you try and canvass a representative amount of it to give you confidence that you're looking at across a range of things rather than just one particular aspect of it.
Okay, no, that's all from me. Thank you.
Thank you. Thank you. Your summary's probably been pretty useful in terms of asking questions. In paragraph 12, you talk about, I already said there's a lack of information around determining significance and further guidance is required. What is required in that space? This is not a new thing. I would have thought it should be reasonably, because I'm surprised by the variety of views on this when this is not a new issue. It's been around a long time.
It is actually quite disturbing given the importance and the significance and how widely adopted they are throughout the country, that there has been no process of identifying what is the critical science needed to underpin those to give us confidence in actually being applied properly with the appropriate outcomes that we're seeking. So we're using general principles and saying these are good ideas, but we do not have the information to say that good idea is actually reaching a good outcome in practice.
How do we get there?
Commissioning some science.
Yeah. Which should start in 1991.
Yes.
Yeah. You talked about the connectivity, and I think Dr. Keeson talked about that too. He referred to lizards, which you'll be familiar with in the Macrae's area. I'm trying to think of terrestrial animal because I don't think lizards have a very big environment they roam in, do they?
No.
What terrestrial animals is connectivity important? I understand the freshwater sense, but birds that fly don't necessarily need connected areas. I guess it's flightless birds.
Yeah, connectivity, and I guess I differ a wee bit from Mr. Keesing on this, is that the connectivity is these highly mobile species that need habitat patches to move around between things like bitten, spotless crake and Vanderbilt that might move between different wetland patches. It might even be resident on wet paddocks at times though. So it's not just wherever they settle is a significant area. But there's also gene flow connectivity is an important thing that needs to be brought into that connectivity, which is why I supported this.
Okay. Yeah, you mentioned the wet paddock areas being reasonably critical for connectivity, those sorts of things. I'm not sure if you addressed it like you do refer to in this about quite a bit of pine forest in the Macraes area now, and there has been concern raised around that. Well, that will actually provide habitat for bush falcon, etc. So they're significant fauna. So do you see concern or an issue around some of those exotic actual habitats being listed, caught in that SNA sort of assessment that you've undertaken, how wide it goes? Is that a part of that?
I guess I'd make a comment on the exotic forestry, is that this is probably one of the most concerning developments in Otago in recent times, is the proliferation of carbon forest and the way that it's been implemented in some areas, at least of Otago. This is in areas which have been traditionally the refuge of biodiversity because it's been too difficult to farm, too difficult to access, but they're now being planted up in pine trees, which will inevitably lead to huge reduction in biodiversity in the areas. But yes, in part response to your question as well, the falcons do use, and other species will use, exotic habitats. And it gets very, very difficult to manage a plantation forest and with falcons and other considerations as well. So when the habitat of indigenous fauna includes exotic habitats, I think it does need to be additional consideration on how that actually applies to land use.
Yeah. And the concern around the extent of SNAs, potential for SNAs, is that reflecting the pre-human start point? Because we've seen a lot of areas cleared that is now tussock. Is that a part of the concern from your perspective?
The analysis I presented was prior to that, so it was quite a, I think, relief to me that it was taken to the pre-human baseline, because previously it had been, the one interpretation had been any indigenous vegetation, no matter how degraded, became significant because it was representative of what is already present because it's there. So it became almost a self-fulfilling circle. So
in that context, I wonder about the Macraes area when you talk about the significance there. That was originally forest, and none of that's there now. If you're applying that start date, is what's there significant now?
I think there will still be elements that are meeting some of the other proposed criteria, particularly around the rarity criterion and the naturally rare ecosystem type criterion. So, and while there are some of the other ones like shrublands would have been a prehistoric vegetation community, which is we wouldn't be quite so sure on its location back in those days what it is now. So it's there are shrublands that are probably significant in there, and there's huge hillsides that are basically regenerating two species of shrubs, and they would have low significance and low ecological importance in my mind, but some of the higher diversity shrublands have ascribed higher ecological importance to.
And I think various documents refer to the Macraes area as a hotspot. And I've always wondered about those sorts of references. Is that because there's a lot of work being done in that area? So these things have been identified, but if we move somewhere else that no work's been done, we'd probably still find that diversity, or is it unique?
That's hard to tell. Most areas have undiscovered biodiversity, and more time you spend looking, the more you'll find. It is a surprise the diversity that is in the Macraes Ecological District, but then yes, there's been quite a history of involvement through the Department of Conservation with the Grand Otago Scheme project, which dated back to the mid-1980s, and OceanaGold over the last 10-15 years have commissioned quite considerable biodiversity survey. So it's quite unusual in the intensity of biodiversity attention that's had in recent years.
Yeah. Because as a non-ecologist, when I drive through there, I kind of see barren wasteland. tussocks and stuff, so I'm sort of surprised if we take that start point that is pre-human. Well, what's left from those days?
Yeah, there's not a lot left in those days, and that's why any of the particularly forest remnant bits would be high significance. But there are some left in those areas, groves of totara and things like that.
Yeah. And are they environments that can be restored to be self-sustaining?
Oh, I've got high confidence that that's the case.
Yeah.
Yeah. I mean, the dryness would slow things down, so the time taken to reach a good state would take a bit longer. I don't see any technical barrier to do that.
Okay, thank you for that.
In your original evidence, you talked about being generally supportive of the SNA approach, but you caution about the approach being suggested in this RPS. And in fact, you go a little bit further to say that the impact that the approach has on people's land, particularly mana whenua land. That's the bit that I'm interested in. Can you explain that a bit more?
I think there's several things to be in part of that, but the primary concern that I had was that it would have an unequal effect on Māori. So Māori land in general tends to be poorer resourced, governed by family trusts and various others, so therefore it doesn't have the same value of improvements that Pakeha lands tend to have, and so therefore it retains a lot more biodiversity in it. But there's also that in general Māori owners tend to be more sympathetic towards biodiversity on their land, Pakeha farmers and others, so there's a range of reasons why Māori control lands. I'm not sure about the term Māori lands in the RPS, what they actually mean by that, but whereas under Māori ownership, Māori trust, probably has a lot higher chance of having good coverage of Indigenous biodiversity.
Then you go on to say that you understand that the rural community has expressed concern about this approach as well. And then you end by saying that you believe that the view held by the rural community needs to be balanced. The need to effectively protect New Zealand's Indigenous biodiversity. I don't quite understand what you're getting at there. Can you?
I do a lot of work with farmers, various walks, and one of the common complaints is the regulations that they're facing a range of things, including on biodiversity, and I guess the wish to basically that it all just went away. I think we need to be mindful that often they're not incredibly wealthy people that can just lock up a huge area and walk away and say, oh, I can't, I'm not going to farm that. There's certainly some that are in that case. But also on the farming community, they also need to understand that they have an important role to play in biodiversity management, and they're a critical member of that.
And then I'm just have to sort of chuckle a wee bit in this last point where you say you don't understand why the Otago Regional Council is not using its own mapping information instead of the poorer resolution of the lens information. Can you just elaborate a bit more on that as well?
I can't speak for the regional council. They're not using their own information on this process, but from the accuracy of data, what I've seen is that the Otago map's not 100% accurate, but certainly a step up from what's available in the cover database.
Oh, okay. Yeah, I just wasn't quite sure what that was referring to. All right, thanks very much.
You found your evidence pretty clear to follow. So I really want just some points of clarification, really. At page 33 of the brief, you talked about a disaggregated accounting model to calculate the extent of works, etc. What are you meaning by that?
The disaggregated accounting model is an offset model, which there was a discussion on slightly earlier. So there's a paper published by Fairbass and others further back. Disaggregated just means that it can pull in different components into the same sort of accounting system. So it's a way of bringing in a range of different biodiversity values into an offset sort of context.
Then in your evidence that you've given to us today, at page 11, talk about pastoral farming's ecological footprint in the Macraes ecological district is much greater than that of mining. So what aspects of pastoral farming are you saying have an ecological footprint? And by that, are you meaning, I take it, a deleterious footprint? So if I asked you about these four: cultivation, oversowing with exotic grasses, fertilizer application, or overgrazing, are those the sorts of activities that you're talking about, or are there other ones that you would add?
I would probably add the main drivers of it is conversion of rough pasture and tussock grassland into high producing grassland by ploughing and combined with spraying and burning, and then oversowing of their ploughed lands, and then winter grazing, winter crop changes. But also increasingly, farmers are also the ones that are planting trees on exotic carbon forest. I'd also balance it with saying, the biodiversity values in the Macraes ecological district have been there with 150 years of farm practices. So to some degree, the traditional farm practices are also probably maintaining biodiversity to a degree, possibly with some impacts, possibly with some benefits, but it's hard to tell.
So is the topography in that Macraes area lend itself to pretty broad sweeping areas of cultivation?
Yeah, it's quite flat spurs of deep loess, and so they have very little access to irrigation. It's one of the few ways of increasing the carrying capacity of course, when you're quite dry farmland.
And do I take it that some of these ephemeral wetlands would have been cultivated in the past?
Yes, and I've seen that. Yeah, some of them have gone into crop, and a lot of them have been ploughed over. Yeah, they're pretty hard to see on the graph, to be fair.
Yeah, no, I'm not being critical of that. I mean, I come from Marlborough, and that happens in Marlborough as well, but not the same level of cultivation, because the topography tends to be steeper. So the oversowing tends to be aerially applied, and with fertilizer used to be burn-offs before that, which doubtless would have been similar practice, I take it, down here.
Yeah, and that's what I mean in traditional farming practice. Oversowing and top dressing is pretty standard practice. Burnings now a lot rarer.
Yeah.
Yeah. It's a more traditional practice.
You gave a description of the concern you had about the very recent development, really, of this widespread practice of exotic planting for carbon credit basis. And is that occurring? You mentioned that it was tending to occur in areas that were a bit rough to be able to sustain normal farming practices. Is that occurring in the coastal areas for Otago, or is it more inland?
It's probably more in the coastal area because it's better tree growing climate. Some catchments, it's getting up towards 15-20% of the catchment is now going into new pine plantation.
Right.
So it's rapidly exploding, and because in a lot of places it's seen as a supplementary income stream for that marginal land, as well as the marginal land that's been converted.
Well, as I understand it, it's becoming the principal income stream, isn't it?
Well, supported by government scheme as well, so there's some added attraction there.
And in due course, are those going to be just massively increased areas of seed source for wilding plants?
As far as I'm aware, the restrictions on what species are planted is pretty limited. And so things like Douglas fir is still able to be planted pretty much at will. And that's probably the worst culprit in areas sort of east of really dry central Otago. Luckily, we don't have a lot of contorted forests in that really dry. So there is potential that we're just increasing that weed loading in surrounding areas.
in paragraph B on page 11, there was a passage there that I just needed you to explain a bit more if you can. I agree that many are dominated by exotic pasture grasses, but not always species that are on the national list of exotic pasture species, which is a requirement for an area to be excluded from the definition of a natural inland wetland. Just explain that a bit.
I guess expressing a wee bit of frustration that even with the new National Policy Statement on Freshwater Management, particularly in dry central Otago climate, it doesn't apply terribly well with what's a dryland, what's a wetland, and what's a pasture. And there's a list of pasture species, but it doesn't capture a lot of what is generally what I would consider pasture species in Otago, including species that are found in these. So you'll get these depressions that are pretty much exotic grass dominated, maybe 2 or 3 local species still in them to show what they used to be. But nowadays, they're just basically grazed parts of paddocks. So the significance of those is, from an ecological context, I'd consider pretty low, considering there's about 3,000 of them throughout the area. It's not like we're dealing with them, 50 or 100. Right.
I was going to ask you about that figure of the 3,000. So a lot of those is this type of activity.
Yeah, but there are some that are incredibly high value that have high remaining indigenous cover over them, high species diversity. And so those sites definitely are significant criteria. These other ones are so degraded. In the past, it's been argued, well, they can be restored back to their original glory, but the constraints on conservation and funding means that that's highly unlikely. It's never going to happen. Right.
Just at your attachment, which is I think the joint witness statement. I'm not sure those green highlights, were they applied by you?
They were put by me just to try and highlight the bits where I've added detail or made change, because it was a fairly complicated table.
Yes, no, well, thank you for that, because that's helpful.
One thing to note in that joint witness statement, I do actually change my position on one of the marine ones. I'm reading it, I realised that it meant that basically anywhere in the marine area was significant. So I withdrew my support for that criteria.
Thank you, Dr. Thorson. Very helpful.
Mr. Hooson is the next witness.
In the interest of time, you've got a bit of a tough road to follow, because Dr. Thorson did a good job of abbreviating. So we're looking to you to do the same.
He did a very good job. My name is Scott Hooson. I hold the position of Senior Principal, Senior Ecologist in Wafamuscal Limited, Otautahi, Christchurch office.
Stop you there. What we're really looking for is you to the highlights, if you can.
Sure.
All right. So all that preliminary wonderful we've been aware of. So you just have the highlights.
Firstly, my evidence deals with Eco P2, Eco P3, Eco P4, and appendices 2 to 4 of the PRPS. In terms of Eco P2, I've suggested a minor amendment to that policy, essentially rewording that so that it reads, identify and map significant natural areas in accordance with Appendix 2. With regard to appendix policy Eco P3, I have
noted here that the proposed wording of that policy is generally consistent with section 6C of the RMA. However, for new activities that are unable to avoid adverse effects described in Eco P3 and that are not provided for in Eco P4, then that activity cannot proceed because the effects management hierarchy in Eco P6 is not available. In terms of Eco P4, provision for new activities, as it was drafted, it did not provide for new mineral extraction activities in SNAs, and I discussed that in my evidence. Obviously, since my evidence has been filed, supplementary evidence has been prepared on Eco P4, and that has been amended, as has been discussed previously. Mrs. Hunter has suggested further changes in her supplementary evidence, which I've reviewed, and I note that I prefer the version proposed by Ms. Hunter. With regard to significance criteria, I discussed the workability of those criteria in detail in my evidence. During expert caucusing, in my opinion, we resolved a number of issues and agreed on a number of the criteria. However, there is still disagreement between the ecologists. I will just very briefly talk you through some of those areas of disagreement that I think are most important. Firstly, and this has been mentioned by the other ecologists, in terms of providing guidance or a guidance document to assist interpretation and application of the criteria in Appendix 2, in my opinion, that is essential. And I'd just like to point out that in terms of guidelines, the Canterbury Regional Policy Statement is a set of non-statutory guidelines that I have frequently used and find to be very useful. In my opinion, the threshold for significance under the criteria in Appendix 2 is low, as has been discussed by others. I talk very briefly in my summary statement about two of the significance criteria where agreement was unable to be reached during caucusing. I won't talk to those now, but we'll leave you to read through those two matters. With regard to biodiversity offsetting and compensation, in terms of key points from my evidence, Mr. Christensen will shortly discuss the development of principles in biodiversity offsetting and compensation in detail, or in more detail. However, I think one of the key points that both myself and Mr. Christensen make is that both offsetting and compensation were developed as principles as opposed to criteria. However, in the pORPS, they are criteria that must be met in order to qualify as either an offset or compensation. My position is that the use of principles is more appropriate because that allows for activities to be considered on their merits at the consenting stage. I then talk about clauses A to E of both appendices 3 and 4, which, as we've discussed, or as I've discussed, are set out as criteria. In my opinion, those clauses are very stringent. And what that means is that biodiversity offsetting or compensation will not be available in many circumstances where they could result in better outcomes for Indigenous biodiversity. I give the example there of clause 1A, where biodiversity offsetting would not be available if even one individual of a threatened taxon was present in the site where the activity was proposed. I then discuss the wording of some of the criteria that I proposed in paragraphs 23 and 24. Examples include measurable loss, and there was a question on that earlier that I'm happy to come back to. The removal or loss of viability of a threatened habitat or indigenous species or indigenous fauna. In that case, the loss of viability, again, is problematic. As for the loss of health and resilience in clause 1C of appendix 4. Another point for emphasis in my summary statement is in relation to the length of time in which the outcome of an offset compensation can be achieved. And again, that has been traversed today. Ms. Hunter has prepared a set of alternate provisions for Appendix 3 and Appendix 4. I have reviewed both of those appendices, which are attached to Ms. Hunter's summary of evidence, Appendix A, and I prefer that version of those appendices because in my mind they better reflect current best practice, including the Business and Biodiversity Offsets Program and the NPSFM and exposure draft of the NPS-IB. Thank you.
Yeah, no, thank you. Just in relation to Eco P2 and P3, and Ms. Hunter may have a comment on this as well, I'm not sure. You are asking for Eco P2 1, the reference to Indigenous biodiversity values to be deleted there, but that is referred to in P3 1A. I'm wondering if you'd also be wanting a further change to Eco P3 1A, or whether you think that's appropriate there. I'm just thinking because the Eco P3 1A is referring to Indigenous biodiversity values, and it does say identified or mapped under Eco P2 1, but just wondering if you've got a comment on that.
Yeah, I guess firstly, to explain the reason that I've suggested an amendment there is that in terms of identifying and mapping these things, generally you would identify and map significant natural areas as opposed to the areas and Indigenous biodiversity values within them, which aren't necessarily mappable.
Okay. They would be identifiable though at the time.
They would be identifiable but not mappable.
Is there value in identifying those values at the time when the SNAs are mapped?
Yes, there is, and that's a standard approach to assessing the area, a significant natural area when you are undertaking a survey on the ground to collect information that then goes into your assessment to determine whether an area is significant or not.
I think for the purposes of consent applications, district plan, prep and the like, when you're out doing mapping an SNA, I presume there'd be kind of a report written on each, or at least some kind of information sheet or something that would be available if the values weren't recorded. Would that be correct?
Yes, that's right. In my experience, that process would involve preparing an assessment report using the information that you collected during your survey of that site.
And I mean, in your experience, would the values normally be recorded in a district plan against a site? Or would a site just really more be in the maps?
Usually, in my experience, a district plan, for example, would include a schedule of sites. District plans across the country vary in the level of detail they provide. Sometimes it can be a table with site names and or maps. Most district plans these days do provide maps of sites, but certainly a number don't. Some schedules and district plans provide a little bit of an explanation as to why that site is significant or what its values are.
Okay, no, that's helpful. Thank you very much.
Yeah, thank you. Yeah, that caused us a slight problem, you and Mr. Thorson, because when I go through the joint witness statement, you two folk don't agree with everything. So it leaves us in a bit of a bind as to what your client's after. Can you work through that for me? Because I think in rarity, subclause 2, as you agree, number 2 by the look of it, but Mr. Thorson doesn't. And that's about restricting down where we should measure these things regionally, ecological district. Why is there a difference there between you and Mr. Thorson?
Yes, so I guess I can explain my position with regard to rarity D2. For this part of the rarity criterion, there are a number of assessment scales listed nationally, regionally, or within a relevant land environment, ecological district, or coastal marine, hydrographic region, or freshwater environment. So there's a number of scales there at which you can assess that reduction. My experience is that often there is limited information at some of those scales. So my preference is to retain those scales, such as the national, regional, or relevant land environment ecological district, because then an ecologist can use the information that is available to him to make that assessment.
Yeah, okay. I guess when we go back to the concern that I think all ecologists are raised, that the bar's very low. Doesn't that contribute to the bar being pretty low? Having such a wide ranging set of assessment scales.
Potentially yes, and I think part of the reason for that is, as has been discussed previously, the national level assessment, which is the threatened environment classification, would lower the bar where there is Indigenous vegetation on those environments with less than 10 or 10 to 20% Indigenous vegetation remaining. However,
on a national scale as opposed to a regional scale.
Yes, that's right. Yeah. However, within those land environments, there is obviously a lot less Indigenous vegetation remaining. Therefore, the argument is that those vegetation types are important as well. But also noting that there are some inaccuracies with modelling at that scale, as it's been pointed out earlier. Yeah. And hence the importance for an ecologist to validate that information with an on-the-ground survey.
And then in the diversity one, I think you're sticking with the inclusion of the gradients reference, whereas I think Wilson recommended that go.
Yes.
What's the relevance to gradients? I think Dr. Keating was addressing that earlier.
Yeah, so in my mind, where you have sites that have diverse natural features or gradients, and I'm thinking about examples where you might have zonation and vegetation through from an intertidal estuarine area into a salt marsh community, into shrublands and forests. Those sorts of gradients are worthy of meeting that criteria. Removing that word would mean those sorts of situations may not be identified. However, I do think that if that word was removed, it probably wouldn't have much of an impact on whether a site was identified or not, because it is likely that those areas would be picked up by other criteria anyway. So I guess my position is that I don't hold a strong view on that, whether that word is retained or not.
So Dr. Keesing's view was that this will be picked up. In other words, it's not needed. It's will be picked up by distinctiveness or representativeness. Do you have a comment on that?
Yeah, I do agree with Dr. Keesing's view on that. I think he's likely correct in that it, as I said earlier, it would likely be picked up by other criteria. I would need to think more carefully about whether there might be examples where a site may only, for example, be significant if it was only important because there were changes in species composition reflecting gradients.
And then we get to distinctiveness in, I think in Roman numeral 1, I think Mr. Dawson recommends that goes, and you're suggesting just an amendment taking out the reference to a target and the limits nationally.
Yes, that's correct, and that was one of the points that I had included in my summary statement. And I might just read that for you because that will answer that question.
See that.
So I say here, in my opinion, the distinctiveness criteria on F1 should be retained because we're a species.
Could you just point me out what paragraph you're referring to?
Certainly, paragraph 18 on page 5. And here I say, in my opinion, the distinctiveness criterion should be retained because where a species is at its national distributional limit, it is on the margin of its natural range and likely to be genetically distinct from individuals or populations in the core part of its range, and particularly if it has a disjunct distribution.
Okay, got that. I think we might have been. Again, a difference in the ecological context in Roman 4 around the wetlands. That was Dawson was saying it's redundant, it's been captured by other criteria.
Yes, and I agree with Dr. Keesing and Dr. Dawson generally on that point, is that those wetlands are likely to be picked up under other criteria. However, the reason that I had wanted to retain that was that particularly in Otago, wetlands, some wetland types won't necessarily meet other criteria such as rarity, where, for example, some of the wetland types haven't been reduced to less than 20% of their pre-human extent within the region. However, if the wording nationally is retained in rarity D2, then it would still meet that criteria.
But wetlands are already pretty much addressed by the MPS.
That's correct.
Yeah. Now the question I had, well, was around the appendix 3 issue, and you noted the concern around the measurable loss. Saying it's unclear, but it's not really unclear, is it? Because it is, if, like Mr. Christensen said, one individual's gone, you can measure it. So that's where the problem is. I guess what you're saying there is that that's too stringent for that at-risk declining tax line.
Yes, that's correct. And the issue that I've raised there is, as you pointed out, the wording measurable loss within the ecological district. The loss of one individual at-risk plant is measurable. However, as they set out in Appendix 3, because they are essentially criteria, as Mr. Stephen Christensen pointed out earlier, there's a binary response there. It's either yes, there is a measurable loss, therefore offsetting can't proceed, or no, there isn't, so offsetting can proceed. So that threshold, or where that decision on whether offsetting can proceed relies on whether that impact on an at-risk declining species, whether, where is the threshold of measurable loss, what's deemed to be acceptable or not. But my argument is that measurable could be anything.
The difference between threatened and at-risk declining. What is that difference in a, well, I guess in a numerical sense?
In terms of how species are classified, there are 2 umbrella categories. There's threatened and there's at risk. Within each of those 2 umbrella categories, there are a number of categories. Within threatened, there's nationally critical, nationally endangered, nationally vulnerable. Similarly, in at risk, there's at risk declining, at risk recovering, at risk relic, etc. Each of those have criteria that have to be, or that are met essentially, so that the people on the panel that make the decisions can place them into the appropriate category. And so essentially the difference between at-risk declining, for example, and threatened nationally vulnerable, nationally increasing now, relies on the individual criteria for each of those classifications. And that relies on things like population size, the number of mature individuals, the trend of that population, the size of its distribution, those sorts of attributes.
Yeah, I'm not sure if we've made it any easier for us actually, but thank you for that.
The questions that I had written down and been covered, so I've got nothing further that I wanted to raise with you. Thanks,
Thank you. Thanks, Scott. Mr. Mark Christensen is the next witness. While he's getting set up, I'll make a couple of comments. First is I'm going to excuse myself in about 10 minutes time because I have to be looking on the aeroplane. So my apologies for doing that, but I appreciate you working late to get through the work. The second comment is that Mark is in a position to respond to your question, Chair, about the change in between the exposure draft and the final version of the NPS FM. And the final comment was in response to Mr. Cubitt's observation that the ecologists haven't made it any easier for him. The point is that OceanaGold engaged expert ecologists to assist it in what is clearly a difficult matter. And what's abundantly clear is that ecologists have their own minds, and as they should, and they have different opinions about the relative importance of different factors and so on and so forth. I don't shy away from that. In my submissions, I didn't make a submission saying what your criteria ultimately have to say. What I did do was say the criteria are set very low, and there are significant implications that flow from that. Now, some of the sting is taken out of the tail of that for my client because of the ability to access the effects management hierarchy, provided that that policy is worded appropriately for significant areas. For other folk who aren't in that fortunate position, this is really biting stuff around significance criteria because of the consequences that flow if an area is significant. And I simply make the submission that because of how important the consequences are of the decision, it ought to incline you towards being cautious in setting the bar too low. And one thing that almost all the ecologists appear to agree is that we've got a pretty low bar here. So be alert to that is my submission.
Thank you very much.
Mark.
Kia ora tātou, rangatira mā. I propose that I read paragraphs 3 to 8 of my summary, and then I have brief responses to 3 questions which have arisen, and then we can take additional questions after that. My evidence set out why I consider it significant that both exposure drafts link biodiversity offset and compensation principles with the effects management hierarchy by providing that regional plans must add a provision that an application may not be granted unless, quote, the council is satisfied that if aquatic offsetting or aquatic compensation is applied, the applicant has had regard to the principles in Appendix 6 or 7 as appropriate, or the decision maker is satisfied that the applicant has demonstrated how each step of the effects management hierarchy will be applied. This approach can be contrasted with the approach in the proposed statement, which attempts to define offsets and compensation by reference to the principles, which are seen to be criteria which must be met. As I discussed in my evidence, this is inconsistent, in my view, with best practice and has led to difficulties in interpretation and application. I therefore disagree with Ms. Mealy's statement for the Director General in her paragraph 33 that, in general, I support the approach taken by the Council with the criteria for offsetting and compensation and acknowledge they largely follow good practice. I don't agree with that statement. I also disagree with Ms. Mealy's assertion that the use of criteria has been done successfully in the West Coast RPS. As I set out in my evidence, my experience is that the West Coast RPS has introduced confusion and uncertainty by doing this, and that has resulted in significant additional costs and effort being expended on litigation. As you've noted, Commissioner, the NPSFM has now been formally amended. While there are some minor changes from the exposure draft, the approach to offsetting and compensation, which I described in my evidence, in my opinion, has been confirmed. And in the footnote, I say refer to that clause, which now says if aquatic offsetting or aquatic compensation is applied, the applicant has complied with principles 1 to 6 in Appendix 6 and 7 and has had regard to the remaining principles. While this could be seen to have strengthened the obligation, I consider it critical that compliance must be with principles which are expressed as general principles rather than criteria which must be met. I consider the difference to be substantive. And having said that, I am unclear what complying with a principle means in this context and what difference these words make compared to the exposure draft. Perhaps it is intended to be the same as the requirement to give effect to compared with have regard to, as per references in Te Tiriti in the Conservation Act and the Natural and Built Environments Law. But if that's so, then why not use those same words? Back to my paragraph 6. I understand that the exposure draft of the NPSIB has not yet been reported back to Cabinet following the submission process, and it may or may not be released prior to the election in October. My evidence describes some major reservations that I have with respect to the wording of the NPSIB exposure draft, where it differed from the approach in the NPSFM. I also understand these reservations were included in various submissions made on the NPSIB exposure draft with which I was not involved. Consequently, it is my opinion that the amended NPSFM to 2020 now provides the most appropriate approach to regulating offsets and compensation. I therefore disagree with the evidence of Ms. Neely and Mr. Brass on behalf of the Director General in that regard. As I stated in my evidence, I consider that the NPSFM also better reflects the BBOC guidance as summarised in the Local Government 2018 guidance document. I'm also of the view that provision in the policy statement about offsets and compensation for effects on terrestrial biodiversity should be consistent with the approach to aquatic offsets and compensation, which is now mandated by the NPSFM. The changes I've suggested in my evidence and is contained in the evidence and supplementary evidence of Ms. Hunter set out how, in my view, that can be achieved.
Can I just interrupt you, Mr. Christensen, for a moment, just before you go, Mr. Stevenson, Christensen, can I? It's not being challenged necessarily by what Mark has just said, but if your argument is correct and if a different interpretation was taken about the impacts of that wording change to comply with principles 1 to 6. In other words, if the interpretation was adopted that was indeed a presumptive limit, and your argument is, well, you can't do that because 104.1 AB requires that you take into account any proposals put forward by an applicant. Do you argue that at law it's possible for an NPS to be held to be invalid by failing to comply or going beyond what the statute provides?
I haven't considered the point, but I think we would be in one of the King Salmon exception type of criteria, and I realise this is a national instrument we're talking about, not a regional plan but it would be it would be a situation where the national instrument is trying to boss the statute around. And I would be making a submission in that situation that you probably need to go back to part 2, because you've got this inconsistency where the statute has been quite clear saying you must consider all proposals. You've got a subordinate instrument saying no, you don't. And I say as a matter of law, a subordinate instrument, whether it's a national policy statement or a regional policy statement, cannot do that.
Right, and you go back to part 2. Yeah. All right. Yeah,
I better go. Thank you very much.
So, thank you.
Then I have 3 comments in relation to some questions. The first one was around the question around possible inconsistency between Mr. Hewson. You asked Mr. Stephen Christensen about that. Mr. Hewson and I are talking about different things. He's talking about the criteria around no measurable loss in individuals or insects, whereas I was talking about the definition of an offset. So an offset has to be showing a measurable as well as measuring the effect. So if I can give you an example of what Mr. Hewson was talking about, and that comes from the West Coast Regional Policy Statement, and it was at the 4 in the Te Kuha hearing, which I referred to in my evidence, which was around a proposal for a mine on the West Coast. The West Coast Regional Policy Statement has almost exactly the same words around criteria to be met and a no measurable reduction in biodiversity. It transpired that the evidence and submissions for both the Director General and the Forest and Bird were to the effect that, of course, there's a measurable loss because it's a mine. And therefore, as a matter of law, in terms of the criteria and the regional policy statement, the submission was made that the offset proposed could not be assessed as an offset. Now, in my view, I term that as sort of a gotcha approach to plan decision making. I find it neither helpful nor assisting appropriate decision making because it turns out that on that reading, no mine in the entire region would be able to put forward a proposal for an offset because it didn't meet that criteria. So that's what Mr. Hewson was talking about in terms of that. My reference was around, and the word measurable comes from bebop, and it's intended to indicate that we need more than subjectivity when identifying how much net gain or achieving no net loss. There needs to be more than just a subjective. I think it's enough. There needs to be some sort of measurable way of doing it. So that's the first point. The second one is in relation to some questions around Mataranga Maori. And if I refer you to Ms. Hunter's appendix, where she proposes, and I agree with, a rewording of that appendix, directly using the words from the NPSFN, there is a reference in Principle 9 to science and Mataranga Maori, which says the design and implementation of an offset is a documented process informed by science where available and Mataranga Maori at place. Now, I have a slight problem with that wording, in the sense that I wonder whether the words where available are in the wrong place. So rather than a process informed by science where available and Mataranga Maori at place, it seemed to me that what would be more appropriate is the clause which said a process is informed by science, comma, and where available, Mataranga Maori at place. So that's what we're suggesting would be an appropriate principle for terrestrial biodiversity offsetting in the RPS here. And the third point, there's been some questions around biodiversity modelling. And if I could refer you to footnote 90 of my evidence, which is on page 68, and it's a reference to a paper which is authored by a number of people, including myself, but I had a very minor role in writing that paper. And Dr. Baber is the principal author, and it talks about the different types of models. And essentially there are two types, as I understand it, what's known as a biodiversity offset accounting model, or BOAM, and it can be contrasted with what Dr. Baber calls a biodiversity conservation model. And the debate between the ecologists as to what is appropriate is hotly contested as we speak. It's the subject of many pages of contested evidence around what is and what isn't appropriate in terms of when particular models should be used and what are the right discounting numbers and so forth. And it's a subject which is not only was hotly contested at the Te Kuha hearing, but it is currently being played out in the Dome Valley Environment Court appeal hearing before the Environment Court on the Dome Valley proposed landfill. So there's a big debate around the use of which particular, and my concern there is that we don't want to pigeonhole. I think it's inappropriate to pigeonhole a type of model in the RPS, or leading to arguments that the RPS wording will only be met if a particular type of model is used. I think it all depends on the circumstances, which model is the appropriate one to use. So thank you, those are mine. Thank you.
Thank you, and thank you for your evidence. It was, it was a bit to get through, but it was very interesting and very helpful for the process too. So thank you for the effort that you put into that. One question I did have, and you probably you may have heard Dr. Keesing this morning talking around, requesting that the reference to consent duration be removed from the criteria for offsetting and compensation. I think it was both. And that sometimes whatever is the offset can take some time to be established. And I suppose I'm just wondering if in terms of sort of best practice, or if there's anything in the BBOT guidance that that talks about how long an offset should take to be up and running. I suppose you could say versus, you know, the values that are being lost. Is there any guidance around that?
Well, there is some discussion in those various documents. Again, it's context dependent. As I understand it, while the achievement of the final outcome of net gain may take, in some cases, centuries, because in the case of the polar carp, the trajectory upon which the restoration or the growth is heading should be able to be determined in a much shorter period of time. Again, depending on the particular ecosystem involved. But while it might take 200 years for the polar carp forest to re-establish or longer, within a couple of 3 decades, as I understand it, there's some reasonable certainty about whether the trajectory is correct. And so one of the things that the BBOP guidance talks around is really an adaptive management type of approach, that you don't just start it and leave it. You've got to make sure that it's managed and actively managed. And if there is some indication that the trajectory that was thought was to be happening you're not on the right trajectory, then you need to make changes. So in my view, there needs to be a sort of an adaptive management condition regime, which requires some assessments around, is the trajectory of the offset one that was predicted, and if not, then does it need to be increased, or does other changes need to happen? I think that's what people was talking about.
Are there issues around, you know, if you've got a consent duration of say 20 years or even 35 years, but a long time frame for delivering the offset? I mean, I suppose once that consent is expired, there's no obligation on the consent holder necessarily, or the former consent holder necessarily, to continue active management or monitoring or anything else. I mean, they could just let it go then. I mean, is that where the, you know, the need for covenants and the likes to be vested? And that's something you would think would be more for consent conditions rather than.
I think there are some mechanisms such as the setting up of a trust, which is then required by its terms of reference to have an ongoing role in the management. I think that's one mechanism. But again, I think it's important that for the duration of the consent, that the consent holder is obliged to ensure that the trajectory is happening.
Thank you. I'll just check over. I think most of the other things have been covered off actually that I. Yeah, I mean, I suppose one of the other things that was sort of playing on my mind a little bit was how to balance net gain with ecological equivalence. And I suppose I was just sort of thinking it through in my head anyway. It was seeming to be something that would be potentially quite fraught. Have you got any comment on that?
Oh, it is fraught.
Right.
Yes, it's the subject of much debate between the ecologists as to what level of ecological equivalence and what sort of detail is required. My experience is that it's always contested. But that distinguishes the offset from a compensation. So the whole idea, ecological equivalence, in my view, is probably the primary component that distinguishes between the offset and the compensation. And in some instances, and I think the other Mr. Christensen might have said that while there is some can be equivalence, if there's not enough information that can then justify some sort of measurable, quantifiable net gain, then because some ecologists will default to calling that compensation because they don't want to overstate the and get into an argument about whether it is or isn't formal offset. But that's a major point of debate. And it seems to me to depend on the significance of the biodiversity that's affected. And it also depends to some extent on the level of certainty about the proposed offset in terms of whether it can be achieved or not. So that the less certain that an offset can be achieved, the more rigorous the ecological equivalence measurement probably needs to be.
Okay. Yeah. The only other, I suppose, question I had was around compensation, where there's not necessarily going to be no net loss. And how, I suppose, what you're proposing as principles, is that going to stack up, and arguably what's already in the appendix at the moment, is it going to stack up against, say, Eco 01 and 02, where we're actually, looking for Otago's Indigenous biodiversity is healthy and thriving, and any net decline is halted. 02, along those lines as well. Can we, if we find that we have a number of reasonably substantive proposals in the region that are compensation is the key tool used, are we actually going to find that we're not meeting the objectives in the RPS?
I think it's very difficult to respond to that in the abstract, but I think I do think that properly applied, transparently applied, and with sufficient rigour, the combination of an offsetting and then a compensation regime, with always the fallback that there is always a situation where no matter what is proposed, it is not acceptable. I think in that context, we are likely to have good outcomes which would meet those objectives. In fact, in my view, without trying to overstate it, the best opportunity we have in this country of reversing the decline and restoring the whole of the environment is to require transparent, rigorous offsetting and compensation proposals.
No, thank you very much for that.
Yeah, thank you. Should be Bianca probably ask the questions around where my thinking was at, and it's around that equivalency for the net, the offsetting gain, I guess, and how that's dealt with in those long-term outcomes and the principles that you propose. But you've kind of answered that, and that's quite complex. I think when you get into a decision-making role, how that's actually brought through in conditions. We mentioned a trust setup. I mean, it'll be coupled with, I'm assuming, it's quite tough bond conditions. A trust setup that would probably be funded by the company, whoever's doing it, right at the outset to ensure that that is ongoing. Is that where you envisage would come through? And is that sort of stuff, to actually understand how this works, should it be identified in these provisions, these principles of how that would work in practice?
I don't think so, because I think it all depends on the circumstances. The idea of a trust that might go on forever is sort of at the extreme end of large scale developments, and there might be other ways of doing it as well. Whereas I think these principles need to apply to the wide range of proposals, small and large, complex and less complex. And therefore that's why more general principles are appropriate rather than specifics, because I think they will play out through the consent process as to how complicated the consent conditions need to be to address the issues. Can I just make a point though, in terms of your question, I think you said the principles that I propose. Well, I am proposing them, but they replicate the NPSFM, which is already required to be in the regional plan for water. So all I've done is taken those ones, and I'm saying the ones that apply to aquatic offsets and compensation should equally, in my view, apply to terrestrial biodiversity offsets and compensation.
Yeah, apologies, I understand that. I guess what you've promoted in your appendix form, Ms. Hunter's carried through into her changes, which you'll address us on, I'm assuming, because there is a big difference between two ecologists on what should be in and what should be out. Just in terms of the definitions, though, that you're promoted, you've included the it's on page 84 for the paragraph. For the purpose of the definition, that you have to demonstrate that adequate regard is had to those principles in the definition, but also in the policy. I'm just wondering why it's in both. Surely it should be more of a policy matter. It's not really part of a definition, that is it?
I'll defer to Ms. Hunter on that.
Yeah,
As
well,
the best way to express that, but
yeah,
as long as it's there.
yeah,
in my view.
yeah. Yes, it's the structure of how these things work is reasonably. I didn't really have any further questions because your evidence was pretty comprehensive, and even though it did take me a while to read.
Apologies for the length. Yeah.
But I'm wondering, in your vast experience in this, what you have touched on in there is, and maybe because you haven't been involved, but how this plays out in other jurisdictions around the world. What are they applying in terms of that criteria or guidelines, or is there a major difference in New Zealand to other jurisdictions?
I'm only familiar with, and it's at a high level with some others, Australia particularly, and the UK a little bit, South Africa, but they all follow, internationally, the BBOP is the approach that has been adopted throughout. So the general approach of those principles is very much the case. Some places are well advanced compared with New Zealand in terms of regulation. Australia particularly, the UK now, as I mentioned in my evidence, have moved to a net gain requirement for all proposals. New Zealand is some distance behind, but then there are many countries around the world that don't have anything at all. My personal view is that we've been fiddling for a couple of decades while Roma's continued to burn. And I'm very pleased that we finally get some national direction with the NPSFM, so we can actually get some consistency across the country. Because everywhere we go, we have the same argument over and over again about what principles should be, whether we should refer to modelling and in what way, and the same things that happen everywhere. So I think we're doing okay, but we could. It's perhaps a solid B. I think a solid B, but we need to be A+.
Yeah, I agree. It's been a long time that we've been in this space, and nothing's really coming out. We're not holding your breath yet.
Well, I do think the NPSFM is a significant advance, because we now have something which sets us out in regulatory form at the national level.
Okay, thank you.
Yeah, well, I just have one observation, I guess, and that's on the issue you raised about Ms. Hunter's wording around Mātauranga Māori and stuff like that. Whilst I think, generally speaking, I agree with your rewording, but I might even go so far such as leave the words "where available" out altogether. And just
yes. Those are the words that are in the NPSFM.
Yes, I know.
So, but what I say that NPSFM is the best example. I don't think we need to slavishly follow those words if there's a better option.
Yeah.
So,
no,
so I would.
I'll have to reflect on it a wee bit more. But I was thinking, well, they're available. I mean, it'd be easy for someone to say, well, actually, we didn't find anything because it wasn't available, even if they didn't seek it or didn't search for it, which would be a challenge.
Yes. I would have a concern if that were worded or interpreted so that it a specific comment from Mana Whenua was required to meet that, because from the resourcing point of view, at least, if that comment were unavailable, then it effectively becomes a veto over the ability for an applicant. I think that's where.
Yeah, I suppose, but I take a bit of solace in Maria's comment earlier on, you know, schemes, if we're ready, and I think they have been. I mean, they've given ample evidence of the way in which they've addressed Mana Whenua issues, in my view, well, you know, I suppose even more than some people might have expected, because they're not easy issues to deal with, as you well know. Yeah. Okay, thanks very much.
Only a few questions, if I can. You've placed quite a lot of emphasis orally on the NPS-FM approach. You've placed strong emphasis in your evidence on that approach in its draft stage. But now, given the changes that have been made and gazetted, when I look at a couple of the knotty issues in terms of Ms. Hunter's draft, which you say you're comfortable with, they actually do change the NPS-FM gazetted form in two respects that I've just looked at. One is in relation to the requirement for compliance. The footnote and the long footnote that you've got in your evidence today refers to the fact that that wording is the applicant has complied with principles 1 to 6 in appendix 6 and 7, whereas in the Eco P6 version we have a wording of the applicant must demonstrate that appropriate regard has been had to the principles in appendix 3 and 4. Now that's using the latter part of the wording in clause 3.223A for Roman 2, and has regard to the remaining principles in appendix 6 and 7 as appropriate. So I'm just left a little uncertain. You're saying the NPS-FM has been followed, but in reality that change has been made. What's your rationale for that? It's really to get rid of that compliance aspect.
Well, it goes back to while the NPS-FM, I'd say, is the best, is better than the NPS-IB in terms of direction. This is an aspect which I don't think is helpful,
right? Because
it introduces this compliance again. In the NPS-FM context, I don't think it's significant change, because it's still compliance with the principles, or giving effect to the principles, or implementing the principles. To me, different ways of saying the same thing because of the principles. But I think it just introduces some sort of confusion as to why there's a difference. What do you have to do about the first 6 principles that you don't have to do? And I would say, I would prefer that it was to give effect to all of the principles than try to differentiate between some of them. So I think it's a matter of.
You've been pretty close to the process. Where did that come from?
I think the term you used was pretty accurate. It slipped in at the last minute,
right
after the submissions.
Right.
So.
And the other one that I was just looking at was the where practicable, and there are 2 uses of the term where possible, which I'll just try to pick those up again. They'll be in the no, you suggested that whole part of the hierarchy comes out, but goes in as a definition, doesn't it?
Becomes a definition. So that's on the first page of the those proposed amendments.
Yeah.
And that uses the word practicable.
Practicable all the way through.
Yes.
Yes.
Again, I think that's directly from the NPS-FM.
The NPS does use web principle.
Oh,
I prefer web.
Web principle. Again, that's my preference too, because where possible, everything's possible in a sense. And practical, in my view, introduces how reasonable the possibility is.
Right. Yeah, I see. And then I can't remember the NPSFM. So in the NPSFM, the sequence in the hierarchy was minimization or remediation. You've applied that. And it's interesting that word minimisation coming in rather than mitigation, isn't it, in the NPSFM? And you prefer that?
I'm happy with minimising. I think it's
to the least extent possible.
To the greatest extent practical.
Okay. We can, right.
Well, I don't have with you, the head at the top of the hierarchy, whether it's avoid or remedy or mitigate, or I don't think that's substantive, because it depends on sort of how you're looking at things. So you take the example of a access road to a mine, which goes up to a mine, and if the road avoids a particular area of significant vegetation, is that avoidance or is it mitigation? In the sense that, is it lessening the impact of the mine as originally proposed? I think it's probably arguably both, either. Right. So I'm not bothered as to which sort of comes first, as long as they all come before you get to offsets and compensation.
No, look, your evidence was otherwise very clear. I didn't have any other questions to raise. So thank you very much. Thank you.
Yeah, I'm available tomorrow if that makes everyone's life easier.
We'd rather finish today.
Yeah, that's fine, yep.
Question one. Well, again, there's been some very helpful summaries of a summary, and we're looking to you for that.
Yeah, no, I've came prepared. So you do have my summary there in front of you. Yep. So just looking at 2.1, I have proposed some additional definitions relating to terrestrial biodiversity offsetting, compensation, and the effects management hierarchy. Just briefly, I agree with Mr. Christensen that it's appropriate to include these additional definitions alongside those which relate to aquatic offsetting and compensations, which are currently in the reports. I also consider it appropriate to include a definition of the effects management hierarchy, and I set out the reasons why I consider that to be a more efficient and effective mechanism, rather than embedding each step into the policy itself, as is currently the approach. And I set out sort of further reasons in 2.4 as to why I think that's not justified from a policy position. And then in table 1, I just attempt to highlight, the subtle sort of differences in terms of if you're dealing with a wetland, which exhibits both terrestrial and freshwater values, likely to, you'd potentially have to apply both hierarchies, and they're similar, but there are subtle but also potentially quite significant differences. If that's just the purpose of that table there. Turning to proposed Eco 04, you traverse this with Stephen Christensen, and I just provide some additional rationale as to why I think that's necessary in 2.7, including reference to the agreed industry issue statement. I think this objective also supports the recognition within that activities using natural and physical resources can achieve positive environmental outcomes, such as through riparian planting, habitat restoration, public access and pest control. And also note the objective might be beneficial for seeking to support ecotourism and similar ventures. Eco P2 and App 2, I think I can skip all of those, 2.9 through to 2.11, because I covered that this morning with contact. In terms of Eco P3, P4, P5, and P6, we've talked about why referring to the NPS highly productive land is not the most appropriate reference document in terms of bringing in that pathway for mineral extraction, but limited to only national projects that deliver a national benefit. And so within this section 3.4, similar to Mr. Christensen and the previous submitter who you heard from today, Ms. Colley, I think it was, it's my view that it would be more appropriate to adopt the direction within the NPS for freshwater, which provides a pathway for mineral extraction activities that provide either a national or regional benefit. And just noted there, wetlands often exhibit both freshwater and terrestrial values, and the approach adopted within the NPS for freshwater management concerning the management of wetlands would therefore seem inappropriate as the basis to apply to all other terrestrial-based habitats. Just further in supporting that view, I had a bit of a deep dive, this is in paragraph 3.6, deep dive into the NPS HPL section 32 document to understand why the justification for the national pathway as opposed to national and regional or regional. And in that, I couldn't find much justification. So the section 32 analysis, which supports the NPS for HPL, does not justify elevating the status of aggregate extraction over mineral extraction in terms of giving it both options. In fact, the section 32 analysis refers to both activities being appropriate provided they have a national or regional public benefit and a functional operational need to locate on highly productive land. And while this is the next sentence is quite speculative, that could be an error within the drafting of the NPS HPL, which might need to be resolved. Yeah, just been referring to Ms. Hardiman's preference to rely on the national pathway. She provides a section 32 AA evaluation of that change and refers to the benefit, which in my view have a quite clear regional focus as opposed to providing a national benefit. And I think in terms of the evidence that's been provided by Ocean and Gold in particular, McRae's mine provides both national and regional benefit. And I think it would also be inappropriate for the pORPS to ignore the regional significance McRae's in particular provides. So I do think there is sufficient justification in the evidence to provide a pathway for national or regional projects that relate to mineral extraction. 3.9, that's the wording of the new clauses, clause 1A and B, which Ms. Hardiman I think is going to change in light of my issues with that. And I provided some additional drafting in the provisions look at. Then turning to Eco P6 and appendices 3 and 4, I think those issues have been pretty well covered today. Just looking at 3.16, in my view, making the full effects management hierarchy available at a policy level also does not mean that proposals including offsetting and compensation will automatically be granted approval. Instead, it enables proposals to be evaluated on their merits, including an assessment of the appropriateness of any proposed offsetting or compensation measures. And the way I have drafted them, the matters set out in Act 3 and Act 4 would be a key guiding component in this evaluation. And in my experience, if decision makers find on the evidence presented to them that a proposal's residual effects after avoidance, remediation and mitigation on biodiversity values are significant and cannot be appropriately offset or compensated for, the proposal has been declined. So I don't think it's a real concern that things will get away, essentially. And that's really it in terms of the summary, key points.
Just before I ask other commissioners for any questions, your Eco P4 changes 1A and B. Can you just explain the red and the blue?
Yeah, the red is Ms. Hardiman's version from, I think, the supplementary evidence dated 24th of February. Right. So it might have changed in the latest version we got today. And the blue is my changes subsequent to that.
Okay, thank you. Yeah.
Yeah, not too much from me because you've largely covered everything off and your evidence was pretty clear. So thank you for that. Oops, turn that on. Uh-oh, it's flashing green now. What have I done? I'll just carry on talking. Thanks, going in the magic cupboard. Just in relation to what I was asking Mr. Houston earlier, we are in relation to eco. Here we go. In relation to eco P2, the deletion of that, the first part of subsection 1, and how that relates into the drafting in 1A of eco P3. And I suppose I was just interested. I mean, Mr. Person was acknowledging that there is some benefits in listing the values against the SNAs, but was acknowledging that there is actually quite a lot of variability in how plans manage that. But is there an inconsistency there with the drafting? Do you think the values is a good thing to have acknowledged in Eco P3 1A?
Yeah, I think possibly. Because it is the values that are important.
Yeah, we're trying to avoid
effects
on the area and the values there.
Possibly even we could cross out the words the reduction of the area and just leave it the reduction of the Indigenous biodiversity values, and it make those areas significant. That's why they've been mapped.
That being the case, is it worth having the values referenced in Eco P2 then? Do you think that's a useful addition, or do you think that should be left to the discretion of the district councils?
Well, possibly, and I think it's just the wording to it was identify and map significant natural areas, which makes more sort of from a grammatical sense.
Knowledge
and logical sense.
Map the values.
Yeah, so I think that it might need to be different, worded slightly differently.
Okay, no, that's good. Thank you.
Thank you. I guess Sandra, we just start your proposed amendments. And just the question I had to Mr. Christensen around in the effects management hierarchy definition with the last paragraph around the purpose of this definition. Offsetting a compensation is applied. You must demonstrate you've gone through those principles. It's also in the policy. Where do you see that sitting as the appropriate location for something like that? It's not really a part of the definition, is it?
Well, it is in both, just for clarity and consistency, but it's probably does make more sense than the policy.
Yeah. And you'll restructure this, and that was a question I was going to ask you earlier. Because it made a lot of sense to me that the effects cascade was in a policy, but sorry, from your experience, it's more appropriate to be in a definition and the policy refers to that, because it's really a method more than anything, isn't it?
Yeah, I think so. And as I've sort of pointed out in my summary, that currently there are sort of two slightly different approaches and potentially the same habitat or the same environment. And also that if there are any changes because of the NPSRB, it might be easier to change the definition than going through a whole raft of trying to update several different policies. So it just makes it potentially more efficient.
Just in relation to your new objective, 04, it's in your today's version slightly different to what you promoted in your 31 March supplementary and in your summary today. Where was that? You're talking originally about protect and manage.
Yeah.
But now it's just manage. And it's quite an all-encompassing objective there.
I think it's, as Mr. Christian was explaining, it ties into the fact that you can't achieve restoration and enhancement without there being sort of social, economic and cultural wellbeing as part of that. There aren't resources to do those things if you don't enable sort of economic development. So there are, it is broad and encompassing, but it applies to lots of different scenarios, for example, like ecotourism and things like that. And also supporting the policy framework which allows development to occur provided certain outcomes are achieved.
Yeah, well, the note that I wrote against this when I first read your supplementary actually was, so this allows for offsetting and compensation, whereas that may not be compatible with objective one. And I think Bianca put that question to Dr. Lloyd, and in a roundabout way, he kind of agreed that a compensation outcome is not necessarily going to be consistent with objective one. So you're saying your objective 4 actually sort of gives those options a bit more strength.
A bit, and you know, in terms of my experience, compensation would probably achieve Eco 01 too. Yeah. We're using Oceanic Gold as a good example in terms of the habitat, which was a compensation, but for lizards, but it was, you know, the outcomes would be achieving those things. Yeah.
Dr. Lloyd was saying is that it's hard to demonstrate whether such transactions are equitable. And if they're not equitable, then they're not consistent with Eco 01. But your objective probably adds a bit of weight to that. Just turning to your new P4. In 1A, ancillary activities associated with mining. Well, I've been to Macraes, there's quite a lot of ancillary building stuff with that. Do they actually necessarily need to be located in the actual areas of significance?
Well, possibly in terms of making the overall, you know, sort of development more efficient, like the roads, for example, or the waste rock stacks, which is probably part of mineral extraction in terms of a definition. But if it's not, then that would be sort of, you know, having that close by to the pit makes it a lot more economically viable.
Yeah, in terms of the arguments around regional, national and regional benefit, I don't understand why, and we've had this argument, well, discussion of infrastructure in relation to landscape in various places like that, for lines, etc., that probably only have a local benefit, but they actually need to go there. I'd see aggregate extraction in the same sort of light, purely because of the economics of extracting aggregates to be efficient. Is that's probably hamstrung by the NPSs on that though, because I don't really understand what aggregate extraction on a regional benefit scale is, because it's actually just local benefit.
Possibly, yeah. I mean, as I say, I tried to do a bit of a deep dive into the NPS, highly productive land, to see why that's separated in terms of that national versus regional for minerals, not so much looking at aggregate, but it wasn't a clear sort of justification in my view within that, any of it, to be fair.
Yeah, but we're stuck with it.
We are, yeah. But yeah, so the NPS for freshwater takes a different approach and does refer to those things.
In terms of aggregate, it doesn't actually, well, it doesn't even address it, I guess. Yeah, I'll leave that. In your P5, I haven't seen where, maybe you refer to this in your evidence somewhere, you've removed the lawfully established criteria there.
Yeah.
What was the reason behind that?
That was, I think, in my original statement.
Oh,
it was
okay.
there. And thinking back to that, yeah, we've got a few versions now. That was looking again more at something like Macraes, where they've got a zoning. So some of the activities might be sort of provided for, expected in that zoning, but might not necessarily be lawfully established. To sort of with that issue a little bit. So it's
yeah, but you're established under a permitted activity rule, you're lawfully established.
Well, possibly, yeah.
I tend to look at these things more in the pastoral farming context that have been recolonised by native vegetation that then that gets really quite tricky when you talk about lawfully established.
Yeah, I guess, I mean, even possibly it's quite concerning with the number 2, in terms of the wording there, an existing activity that's lawfully established around the same time became operative. So it's sort of, yeah, I don't know, if you're permitted activity, it just sort of didn't really add a lot of understanding to what it meant.
Let's go back and look. Was it Forest and Bird that made that, recommended that change? Can't recall what they said about it. The only other thing is that you haven't helped us with the joint witness statement and the difference between your witnesses. But I guess as Mr. Christensen said, it's going to leave that to us. But
yeah, although I have attempted to set out what I think you might be able to do with that in terms of the appendix 2, not making it such an absolute sort of criteria, and there is an ability to make a sort of determination based on fact and when you're dealing with it, consent sort of level.
comes down to the evidence in that case anyway, isn't it?
Well, yes, but as I say, if it's an avoid type outcome, then you want to have a bit of ability to demonstrate that.
Oh, what I should have said in relation to the comments around your changes to P4, you expressed a lot of faith in the clarity provided by the NPS HPL around the mapping scenario there. I don't place a great deal of faith in that from experience. It's quite a blunt instrument.
Yes, well, again, looking at the Macrae's, I guess it wouldn't affect there because it's not, normally zoned.
Affects a lot of other things, though. And I don't think I had any other questions, actually. Thank you. Thank you very much.
I just want to carry on in the same vein a wee bit. And your Eco M4 regional plans, 1A refers to mahinga kai and kaimona seafood activities. And then if you go to Eco M5, which is district plans, 2, manage the clearance and modification of indigenous vegetation while allowing for mahinga kai activities only. What's the difference?
Just to clarify, the original changes from the section 2A. The blue is the ones that I'm recommending. So that's the read the keys at the front, just to confirm. The black underline is the original ORC section 42A amendments, and then the red is ORC subsequent amendments, and then the blue is mine as of today.
Okay.
But I think, just to then add to that, I think the difference there is possibly because Kaimoana is in the sea, so the regional plans deal with the coastal environment rather than the district plans. So that's why it hasn't been included there. But ORC can comment.
Well, that did cross my mind. I was trying to figure out what the difference was. Okay. One other now. Oh, no, I've lost it. Good one. Thanks.
You'll be pleased now. I've only got one that I want to raise with you, and that relates to your new proposed Eco 04. I must say that it reads to me when I look at it at first blush that as struggling to do other than emphasise provision for social, economic and cultural well-being. And it's probably that word provides for. And I just was toying around with a suggested change to that. If it read manage Indigenous biodiversity in a way that is integrated with the social, economic and cultural well-being, is that better meeting what you're trying to achieve by a recognition that there is an integration between the two, but not have an objective of providing for social, economic, cultural well-being in relation to the use of Indigenous biodiversity, which is how it seems to me to read it.
Well, I don't think it's necessarily saying you can use it for that. It's more saying when you're managing it, you need to be mindful of these other factors. But I think I would also be comfortable with the way you've just put it in terms of the integrated approach.
Right. All right. Look, thank you very much for putting that together in that way. It's been very helpful. Your evidence, as always, is pretty clear, and so I don't know.
Thank you.
So it's a long day, but we reconvene again.